All right, good morning. Welcome to the Select Committee of Government or for Government Oversight. This is our second meeting to discuss the Kansas State Board of Nursing. Before we jump into our agenda today, first I want to say that Representative Barbara Ballard and Representative Tom Sawyer are both online, and if staff will help remind me if they have their hand up, I'll be sure and include them in on the conversation. And if, or when we have motions at the end of our meeting today, they will be allowed by House rules, it's not a bill, to vote. If that's correct, then that's how we will proceed on that. Also, a special happy birthday to our vice chair. He's with his favorite select friends today. And so.
Happy birthday.
Happy birthday.
Oh, Barbara, I hear you. Would you like to sing for him?
Oh my goodness. Happy birthday to you. Happy birthday to you. Happy birthday, dear Honorable. Happy birthday to you.
Thank you, Barbara.
She saved me. She saved me. Okay, committee, I do have a beautiful card here. I'm going to pass it around, and we'll start to the right. Please sign it. It's not going to be a surprise, Bob, but that's all right. And then when it makes its way back, then it's yours for the keeping. However, I will say that Chief of Staff, Carrie, is the one that informed me, so we definitely should let Carrie sign that card too. Oh, you are welcome. Okay, so. We have had quite a bit of time to review the regulations, review the statutes, review how those rules and regulations and statutes have been applied. We have listened to lengthy testimony from individuals, from nurses. We have listened to testimony from families, as well as the executive director for Kansas State Board of Nursing and other staff members and board members. So with this, we've had the collection of the performance measures, the licensure records, the KSB and data. And we've also reviewed many, many documents, and we do appreciate the Kansas State Board of Nursing for providing thorough responses. For any responses that may have gaps, this will be your opportunity today to ask those questions and, if need be, follow up further. At the end of our meeting today, we will have time for thorough discussion. So if we do not cover certain topics that you are interested in, as always, please write that down, make note of it, whether it's questions, solutions, recommendations. But ultimately, we will be well positioned to consider recommendations and consider next steps with this process. So to get us started and to help us stay on track with our agenda today, because it's very full, I'd like Sade to go ahead and open us up and speak to the documents that you have in front of you so we can have them organized and ready to go. Thank you, Sade. And again, thank you for staff who are here as well. We appreciate it.
Good morning, Madam Chair and members of the committee. The first document in your packet is the requested information from fee boards regarding license lapses. This is a range of other fee board agencies and their responses. The next document you'll find is the 10-year expenditure change for health licensure boards. That was also requested at the last meeting. The large document that you have is the Board of Nursing's responses from the last meeting, and I would note that this is available online for the audience. After that, you should have the PowerPoint slides from the Board of Nursing, the 100 nurse detail that was requested, the letters of support, is the next document, followed by the NPDB/nurses action codes, which is 4 pages. From there, you will find a letter from the Board of Nursing's Executive Administrator to the Chief Executive Officer of the National Council of State Boards of Nursing. And after that is the testimony, public testimony for the afternoon session. Just to go over the documents that are in the Board of Nursing responses packet. Questions related to general Board of Nursing responses can be found on pages 1 through 8. Page 9 has the hearings and for questions as well as late renewals and lapsed licenses. Questions related to the nursing practice without a license can be found on page 16. The consent agreements questions start on page 20. On page 24, the questions related to diversion begin. The revoked licenses and discipline questions begin on page 25. Page 29 begins questions related to appeals. And page 35 has a list of attachments. And I will give you the page numbers for each of those, in case you want to write them down. Attachment A can be found on page 36. Attachment B is redacted, but those are pages 43 through 58. Attachment C are letters of support, which entail pages 59 through 69. Attachment D is a LPA audit and is pages 70 through 97. Attachment E are reinstatement after revocation annual reports, and those go from 2017 through 2024, beginning with page 99 and going through page 138. And those are both the House letters and the Senate letters. Attachment F is found on page 139. Attachment G is on page 140. Pages 141 through 142 are attachment H. Pages 143 through 144 are attachment I. Attachment J is page 145. Attachment K related to CMS requirements can be found on page 146 through 151. The chart of number of agreed orders for fiscal year 2021 through 2025, attachment L, is on page 152. The list of cases concluding with agreed orders for fiscal year 2021 through 2025 can be found on pages 153 through 157. Attachment N related to the chart of total amount of fines for consent agreements and final orders can be found on page 158. Attachment O related to a list of cases with ordered fines by consent agreements and final orders can be found on pages 159 through 162. Attachment P, which is an example consent agreement and final order, begins on page 163 and goes through 167. The list of revoked licenses in fiscal year 2024 can be found on page 168 through 169. The NPDB guidebook excerpt is on pages 170 through 188. Attachment S is the list of KSBN verification options and hosting providers, and that can be found on pages 189 and 190. And finally, attachment T, common use acronyms, is on page 191. And I'm happy to stand for questions.
All right, thank you, Sade. We have a lot of documents in front of us, so when we are asking questions or when we are making reference and providing testimony, I would ask for everyone to reference the page or attachment so that we can actually visually follow along with what your question might be. In addition to that, Sade provided some information about the health licensure boards, their 10-year expenditures. And we see that pharmacy is up 120%, optometry 94, and Board of Nursing up 85%. This is also, the fund balances are found in their annual report. Do we have a document on their fund balances? We could go ahead and pass that out. And while you're passing that out, I did neglect to welcome our newest member for today, Representative Emil Bergquist. He is also on the Health Committee, so he will be probably, along with their chair, working diligently during the new legislative session to take a look at this. So thank you for being here.
This is the fund.
It's working. It's working.
Representative Ballard, if you'll mute your. All right, Sade, if you just provide a quick overview of what they're looking at.
Okay, so on the document that I just provided, this is the Board of Nursing fee fund ending balance. So as of fiscal year 2026, their ending balance was 1.0 million. In fiscal year 2024 actuals, the ending balance was 4.6 million. And for fiscal year 2025, that projected balance is 4.4 million.
All right, thank you. And also in reference to the 10-year expenditure, that's expenditures, not fee funds. If we wanted to, we could also examine fee funds in our other health licensure boards and do a comparison. It is an item that is often talked about in appropriations, the growing fee funds and making sure that the fees are proportional and that we are not getting such large balances. So I wanted you to have that so that as we move forward, as it's relevant, you'll have that in the back of your mind. Thank you, Sade. All right. Committee, we're going to move to the next section. Did I forget anything on this section? All right. So I'd like to go ahead and invite Carol Moreland, the Executive Director, to come forward. And we do appreciate your time this morning. As we dive into this very lengthy response, which we do appreciate because we did put forth quite a few questions, I wanted to set forth some general guidelines for us. I want to give you an opportunity to provide an overall opening of any kind that you might like. And of course, I'll also give you an opportunity for any type of closing remarks after we ask questions. But as we move through your testimony, which is a response to our written questions, I will pause and at certain points and then allow for questions so that they're relevant at the point and the page that we are working on. If there is a question that is particularly redundant or we may not need to spend extra time on, then we would encourage you to move past those. I think there are some questions that are maybe provided in length, and I'm going to mention one of them, and it's on page 2, and it talks about the abolishment of the State Board of Nursing. I think that not funding the board or moving the funding somewhere else is not the same thing as abolishing. You answered the question exactly as it was provided to you. However, I don't think that that is a serious consideration of not having some type of oversight in some manner. So I don't think we have to go into those details on that. But with that, go ahead and open with your opening statements and proceed with moving through the testimony, and then we'll pause you at the right time. Thank you. Carol, could you pull that microphone a little closer to you so that everyone can hear? Is it on? Okay, thank
Okay.
you.
Is that better? Okay, all right. I wanted to let you know who else from KSBN is in attendance because you may have some questions for them also. We have Andrea Watson, who is our board president. Brenda Sharp, who is a public board member. She serves on the investigative committee. We have Rachel Kenny Townsend, who's one of our disciplinary counsels. Sydney Winslow is a disciplinary counsel, and I just have to let you know, Sydney will only be able to be here until noon. So if you would have specific questions for Sydney. Linda Davies, who's our practice specialist, she's also the supervisor of the investigative division. And Adrian Guerrero, who is our director of operations and responsible for IT. Okay. We listened very closely about the concerns that we heard when we were here last time. And we have went back, and the board has had a couple of special board meetings to look at things, discuss things. And so we just wanted to share with you today the actions that we have taken based on these concerns, okay? We want to work together for the solutions. So one of the concerns that we heard was around license renewal notification, and then also the ability to renew a license more than once in a renewal period. So what have we done? We've worked with National Council for the implementation of the mandatory nurses e-notify enrollment. We kind of talked about this just a little bit when we were here in July, but we're going to make it so that all the nurses in Kansas are in that. Okay, so they can be notified by email, as long as we have emails, about when their license is coming up for renewal, okay? Because we didn't really have that piece for all the nurses in the past. We sent a postcard, but we also heard that email would be better. So we're hoping to get that implemented by the end of December. And then we're also going to continue to get e-notify information out to the institutions. It's very, very important because they can register all their nurses. This is all free. They can register all their nurses, and then they will also know when that nurse's license is coming up for renewal. They will also know if that nurse has not renewed her license on time. Okay, another concern we heard that there was no grace period after license renewal date, and the discipline process for unlicensed practice and unprofessional conduct was felt to be too severe. So what have we been doing? We've researched the practices, policies, and legislation of other Kansas state agencies and other boards of nursing in the nation related to license renewal processes and any grace period allowed. You have right there what we have found out. We have reviewed information from 80 staff from over 30 jurisdictions. 64% do not allow a grace period for the licenses if they fail to renew their license on time and continue working. 78% report there is no state law that supports the allowance of a grace period. And 81% report their Board of Nursing takes disciplinary action against a licensee who fails to renew their license. Okay. Going right along with that concern, another thing that we have done is the board members have directed the KSBN staff to draft a policy pertaining to disciplinary action related to unlicensed practice violations. This draft policy will be provided to the board for their review and potential approval at the September 10th board meeting, this Wednesday. We have a board meeting. And then we've also put together a task force, and they've already been initiated to review the disciplinary practice, policies, and legislation of KSBN to determine changes that should occur. An initial meeting has been held. We also are looking at multiple stakeholders. Multiple stakeholders that will be part of the task force. Okay, the next concern that we heard, and this had to do with one of the cases that was talked about last time, continuing nursing education. Mandatory requirement of 30 hours of continued nursing education at the time of license renewal is an extra burden on the licensee. So we researched the requirements for mandatory continuing nursing education for license renewal throughout the nation. As part of the Nurse Licensure Compact, we want to be consistent with state board requirements in an effort to positively impact the nursing workforce in Kansas. So what we have found out, 79% of the 46 states that responded require CNE for RN license renewal. 78% of 45 states responding require CNE for PN license renewal. And 84% of 49 states responding require CNE for APRN license renewal. KSBN is committed to working together moving forward to address the concerns voiced, and we have made a start. We have taken some actions, definitely not everything, but we have started in the time that we've had it since July 29th. What I wanted to do next is just kind of go through all those questions. I'm not going to go through all of them. I answered some of them, and other staff members answered some, so they will be coming up here also to address theirs. I was going to talk about the question about abolishing the Board of Nursing, but I understand that wasn't really your intent that it say that. But I can just say that defunding anything like that and making the Board of Nursing not able to do what it needs to affects public protection. It affects the nursing workforce in the state of Kansas. I mean, I hear all the time about shortages of nursing. Let me tell you, you could make it a whole lot worse. Because one thing that you could do is you could get us taken out of the compact, the Nurse Licensure Compact. And that is huge. I will tell you that is huge. And right now we have about 25,000 nurses that have multi-state licenses. Okay, if we were not part of the compact, that's 26,000 nurses, 25,000 nurses. And that would have a big impact. If they didn't have the ability to get a multi-state, I can promise you some of those people will not stay in Kansas. So that's just something to think about there.
All right, Carol, I'm going to pause you for a moment, and it'll be at random moments when I do pause you for questions. And so Representative Avercamp has the first question.
Thank you, Madam Chair. Ms. Moreland. Going back to your document, working together on solutions, just a quick question on one of your bullet points. I think it's your second page, where you state 81% report their Board of Nursing takes disciplinary action against a licensee who fails to renew their license. So I think it's understandable if somebody fails to renew a license, there's some form of disciplinary action. But in your findings, did you find various degrees of disciplinary action? Because it appears that we just have a full throttle on or full throttle off disciplinary action. What did you find with regards to that?
And we're still getting all of that information together because, like you said, it varies. And so we will have that information. I just didn't have it to present here today. Okay, but we will.
So once again, you did find that states had various degrees of responses to the various degrees of, say, wrongdoing or mistakes, correct? Mm-hmm. All right, thank you. Thank you, Madam Chair.
And just to follow up on that, one of the items that we requested for more detail would be the 100 lapsed licenses. And for those nurses that were working with a lapsed license, so we do have that data. When we get to the consent agreement or the order portion, I will direct you to that document as well, because I think we're going to have a lot of questions relating to that. Representative Francis.
Thank you, Madam Chair. One of the questions I had, where I understand that around 80% of all states require continuing education, And Kansas requires 30 hours of continuing education. Did you do any research to see how that compares to the number of hours required by other states?
Some of the other states, it varies. They do not have that much. So again, we're looking at that. I will just tell you the biggest thing we hear about continuing nursing education is the fact that Missouri does not require it. And I could be working right next to a nurse from Missouri. I have to do 30 hours of continuing education. That nurse does not. Does that mean I'm more competent than that nurse? Probably not. So we're trying to kind of look at all of that, but they don't all require 30 hours.
And I just want to iterate my support for continuing education, but I do think it can be excessive. You know, I don't know that it has to be necessarily every year, things of that nature, but I do understand the importance of it, but we don't want to be excessive.
I'll add a question, not for you to answer right now because we have a queue, but for a report back to this committee and also to the health committee. And I'll ask research to write this down. So if you don't get it, you're okay. All right. So, and that question is, what would be the number of continuing education hours for each state? And I would be curious from a Kansas perspective, there are many ways in which you could, you could get credit, whether it's online or through a college. What would be the average cost for those credits for every 2 years? So you would just need to provide some kind of estimate or range for Kansas only, but then a list of all the states that show how many hours of continuing education for those different levels of nursing degrees, including the advanced. Okay,
So
moving on.
can I
Yes,
just ask a question? When do you want that?
Well, certainly research could actually perhaps even pull that, but I'll let research reach out to you.
Okay.
And then that may be something very simple for research to pull, or maybe something simple for you to pull. But within a few weeks, that'd be great. Ultimately, for the health committee, we have two other representatives that would like to ask questions. Representative Tarwater and then Humphreys.
Thank you, Madam Chair. First, I just wanted to clarify my statements before on defunding the nursing. I said withhold funds, and my intent is to withhold funds until there's meaningful change and a shakeup, including the board and director and some massive changes in order to help this board be more nurse-friendly. And my question is, do you support a grace period?
I think that's up for the board to talk about.
I asked you, do you support a grace period?
I'm not the one who makes the
If they asked you,
decision.
what would you say?
I have been a nurse my whole life, and I have been through a lot of personal things, and I have never let my license renewal not occur because
So
it
you do
means that
not
much to me.
support, then? You don't support it?
I think it's very important.
This is why we need a change. Thank you. Thank you, Madam Chair.
Representative Humphreys.
Thank you, Madam Chair. I have just a couple of questions, if it's okay, on the working together document. So I see that you've decided to send emails ahead of time. That's great. And then you said you're working with a software vendor. Have you implemented yet those changes that if people click something twice or there's errors, have you implemented that change?
It is
that
very
they're going to be
close.
notified if there's errors?
It is very close to being implemented.
Okay, so that would minimize duplicates and that kind of thing. Okay, so maybe you could let us know when that gets implemented. Okay. And then, so then also about the grace period, which I think is on the next page. I had a question about some of the statistics on here. 80 staff from 30 jurisdictions. Like I would understand if you had said 30 agencies. What did you mean by jurisdictions?
That's actually what we call in the nation. Okay, some people would call it states, but you have to understand there's more than just 50 states in National Council because we have territories and stuff. So they use the term jurisdiction.
I see. Okay, so that wasn't you weren't checking on if other agencies in Kansas have grace periods, like the board, the dental board.
No,
You were checking on other states.
boards of nursing.
Okay, okay, that's interesting, because I'm interested, and I think that's part of, what we talked about a little bit last time, other agencies, if they have grace periods or not in Kansas, because that's probably most applicable to what we're talking about. But my question is this, like, number, that 178%, there's no state law supports grace period. But, and this might be for the revisers, we don't have a state law that prohibits a grace period. I mean, we know there are agencies that have grace periods in Kansas, but that could be, maybe you could check on that and let us know.
Jenna?
Yeah, thank you, Madam Chair. What I would say is that there's no overarching state law that says no agency can have a grace period, but the, especially health-related agencies that have grace periods, they are built into the statute. And so the Board of Nursing regulation, or Board of Nursing statutes, as it's currently written, does not support a grace period.
Okay,
that would require statutory change.
Okay, that's super helpful, and maybe something we could put on our recommendations. Okay, and then my last question just has to do with that 81%. Just, statistics, we can kind of make them how we want them. But of course, that 81% that takes disciplinary action, that includes those who have a grace period and those who don't have a grace period. So of course, I think it makes sense that disciplinary action would be against a licensee who fails to renew their license. No issues there at all. I'm kind of surprised it's only 81% actually. But it does include those states or jurisdictions with or without a grace period. So just to kind of note that.
Thank you.
Okay, sorry, I did have one other thing, if it's okay, Madam Chair, on the next page. Can we see the draft policy that's going to be provided to the board at their September 10th meeting?
Yeah, it's going to go to the board in September 10th to see if they will
But
approve
today,
it.
September 8th, we're not able to take a look at it.
I can talk, we can see with our
Okay.
disciplinary council.
I mean, I'd just be interested, we've had a lot of task forces in my years through the legislature, and sometimes things happen with task forces and sometimes they don't. So it just would be interesting to know what actions that they're going to be contemplating on the 10th. So, okay, that was it. Thank you, Madam Chair.
All right, great. And I would also say that by the end of our meeting today, we should have at least a list of recommendations that we can get behind. It's not a bill, it's not a requirement, it's not a mandate. It is passed over to the speaker and the health committee. So it's not something that everybody has to be absolutely 100%. We like every single item on here. We have to get every single time frame right. It'd be kind of like a conference committee report where maybe you like 89% of it, and that can be passed along. And so that may have some impact on what is submitted on September 10th. If not, then that's certainly okay as well. This was brought up already, and I will reference again because I think it's a great document provided by KLRD. You guys put this together, and that is it's the requested information from the fee boards, which is quite a range. I know we don't have time right now to go through that, but I want to be sure everyone takes some time later to go through that. Representative Hoy.
Thank you, Madam Chair. My question is in reference to the discussion about grace periods. And I had looked into malpractice insurance, and malpractice insurance coverage does require that nurses be licensed. And we could have the revisor weigh in on this, but there could be some policies that perhaps have a grace period, but we wouldn't be able to know that. So my big concern would be that patients could recover less depending on assets available. It could increase liability for other healthcare providers or facilities. And so I think we need to have a better understanding of that before we go into a discussion about grace periods.
And Representative Hoy, I would say that we, by legislators through what we write in statutes, can define that. We can define that during that grace period, you are considered licensed. So therefore, they would not be flagged for any type of penalty. That's our role, is making sure we have clear definitions and guidelines. But we will take note of that and make sure that we cover all the bases and that we do define exactly what our intent is. All right, if there are no further questions, Representative Bergquist, and then we'll move to the next set of questions in your testimony and move from there.
Yeah, try to make this brief. In this age of communication beyond compare, our opportunity as government and you as an agency of the state to communicate with the members that depend on your administration. I think it's paramount. This email and these other alternative means of communication should be used to the max rather than we'll do this and this now. But to keep as many professionals in our state, we work every year to try to bring opportunity for professionals to be able to bring healthcare, technical jobs, and the whole works. But when we're asking you to commit to communication as an effort, not just as a mandate, any response?
I agree. Communication is very important. And that's why we're trying to do more methods of communication. But I guess one thing I would just be sure that everyone's aware of is those are the emails that we have. Not all nurses give us their emails. Not all nurses update their emails. And we really have no control over that. We run into that now with phone numbers, mailing addresses, all of it, even names. Some of them don't update them. So we work with what we have you may hear a nurse say, well, no, I didn't get that email. There might be a reason, and it might be that we don't have an email address for that nurse. We will attempt to get all of them that we can.
Every bit of communication you can make to them that you have access to, not just one or the other or two. Appreciate it. Thank you.
Okay, thank you.
And actually, we do have one more. Representative Osmond.
Thank you very much, Madam Chairwoman. This is not a question, actually. It's just more a response to Representative Humphreys, who asked what was going on with other agencies. We've got in our packet, it looks like an expansion of last meeting's boards. There's about 13 of them, I think, in this list. My quick reading of it shows that of the 13, 5 sort of mirror what's going on with the Board of Nursing, 5 do not have the same policies as the Board of Nursing, and then 3 of them sort of an amalgamation or a hybrid. That's just my quick reading of it, but feel free to take a look through and see.
All right, thank you for that summary. Okay, so let's go ahead and move to the additional questions, and if you'd like to move through your testimony, and we'll halt you when we have questions.
All right, thank you. Okay, I won't say anything else about the section of abolishing because evidently that was not the intent. On page 6, I did want to address the abuse, neglect, and exploitation.
Carol, I'm going to pause you already. Can we go back to page 4? The question about email opt-in, because there was a letter that was submitted to the National Council of State Board of Nursing, and anything on that? Does anybody have any question? Okay, I would say I do appreciate the letter that Adrienne sent out. I think that's excellent. And I would also note that looking at your statistics, there were 1/4, a quarter of all your nurses that did not or were not receiving any digital communication. So they were at risk of having that postcard lost in the mail if they weren't working for an employer that was tracking it for them. So I'm very pleased that this is part of your onward recommendations to implement. All right, you can go ahead and one more. At the bottom of page 4, it says, how does KSBN respond to CORA requests? Are there any questions, committee, on that one? I just have one. You did respond at length about the meetings, and you also mentioned that on page 6. But are individuals allowed to attend in person if they're not speaking?
Our board meetings and our committee meetings and stuff, yes, definitely. They are open. It's the agenda and everything is on our website before the meeting and everything. They are welcome to attend. It's usually in a place that has room for an audience and stuff like that. Plus, they're all broadcast live. So we see a lot more people watching them online because they don't have to travel clear across the state or something. But yeah, anybody can attend them. Now, I will say the investigative committee starts as an open meeting and then goes into quasi-judicial, and they can discuss that a little bit more.
All right, you've caught us up. Back to page 6 where you were.
All right, I just wanted to, the abuse, neglect, and exploitation, do we adequately address it, and how many cases? I did just want to refer you to attachment D, which is page 70. That has the legislative post-audit results from July of this year. We were one of 3 licensing boards that were included in that, along with other agencies, but it found that there were no recommendations that we should be doing anything different from how we were doing it. And then all of the statistics follow that.
All right, we're going to pause there. Some of us do serve on legislative post-audit. I think one of the concerns from that post-audit would be the fact that different agencies have different reporting and they may not intersect, and therefore the public may not know where to, to look for those individuals that are on that list. So I guess my question to you, does KSBN follow up once you refer a nurse to an agency, KDHE or DCF? Do you follow up? And if so, is that adequately and accurately reported on your site as well, once follow-up has been made and a determination has been made?
Okay. Linda Davies is our practice specialist. She can probably answer. Do you want it answered now, or do you want, I'm not sure how you want to do this.
Linda, do you have that information on hand? That way we can put any questions related to any issue to rest while we're talking about it. Thank you.
I currently, if there is abuse, neglect, exploitation that's alleged from the complainant in the complaint, I can refer at that time to another facility, agency in the state. KDAS and DCF and APS are starting to give me reference numbers now so that I can follow up. Before in the past, I didn't get any response from them at all. So there was always a disconnect, but then also the committee, the board's committee, investigative committee, will also maybe make a direction to do a referral to another agency for abuse, neglect, and exploitation. And at that time, it's done as well, but it's usually handled through the disciplinary council. So there are means to be able to do that and means to be able to follow up now, but in the past, I would never hear anything back from the people that I would refer to.
Okay, and whoever's taking notes for us, is that you, Jackie or Sade? Please add this to it, because it seems to me that it should be the Kansas Department of Health and Environment, it should be DCF that sends back a notice of the findings for nurses that are licensed, because if they do not, then they could absolutely be lost in this process and have, be found guilty of some crime, and yet they're still practicing and you wouldn't know.
Correct.
So that's a risk item. So please, everyone, take note of that if this is something relevant for other committees later. Okay. All right, any other questions on this? All right, thank you, Linda. You may proceed.
You ready for me to go on?
Yes, ma'am.
Okay, all right. On page 8, I did just at the top, there was questions as to whether KSBN had followed the statute 651120A, which requires an annual report, and we have followed that. You have copies of those letters from 2018 to 2025 in your packet. They're on attachment E. They start on page 98. They were sent to the chair of the Senate Health Committee and the House Health Committee. I can tell you they left KSBN. I don't know the process. Once they come over here, but they were submitted. So we did do that.
I'll hold you on that question. Any questions on this item? Are they found in the annual report? I didn't see it.
Probably not.
Would it be, would I be able to search for this information on your website? I didn't see it.
Probably not. I
Okay,
don't know.
so this will be on our recommendations if this committee so chooses to maintain it. But basically, when something's, a hard copy is sent to an office of a chair, just in all honesty, they receive probably a stack every day, and it can be lost in the shuffle of a 90-day session. So I would encourage you to send, normally the process is, and it wasn't stipulated in statute, but normally when we get those types of annual reports, they go to Kansas, to our research department, and then you can also, they can distribute it, but you can also distribute it to every board member through a blind copy so that they have a digital copy, so it will not be lost in the future. That'd be helpful.
Okay.
So
thank
we'll
you
add
for that
that to our
information.
list. All right, thank you. You may proceed.
Madam
Okay.
Chair, may I have a
Representative
question?
Ballard.
I apologize. I'm on my phone and I can't find the hands to let you know. I would have a question though. Excuse me. Since nursing does report to social services budget, I guess I would have a question in terms of the report that comes, because we normally ask a variety of questions in terms of abuse or other areas that we get for that. If we want this report to be available all the time, is that something that maybe we say, does it automatically come to health services, social services budget, or a variety of things? And I would like to ask Carol that question.
Carol.
The report that we're talking about that we send over every year, is that the report we're talking about?
Yes.
Okay, I just want to clarify. No, that report is given to the chair of the Health Committee on the House and the Senate, according to statute. It doesn't go anywhere else. Now, if you want that changed,
Yes, so we will not be changing the statute here today, but that is certainly something that the Health Committee can look at in the future. But definitely, if you could send it also to our Social Service Budget Committee as well, add that to your list. It will take no additional time. Will that work for you,
Thank you, Madam
Representative? All right, proceed.
okay. I know that you have a lot of discipline questions, so I'll just kind of go through here. You wanted the board members. They're all listed there. We do have one vacant public member position. We do have 3 new ones that are just coming on. So that kind of winds this up. The next part has to do with disciplinary and hearings and everything, and I'll turn it over to Rachel, our disciplinary counsel for that. Is that okay?
That will work.
Okay.
Thank you. So I'm going to continue going through the questions. I am going to start by just kind of addressing some of the overarching questions that were kind of presented. There's a lot of questions and responses. If for some reason I don't hit your specific question, please let me know. But I saw some consistent kind of questions come through, and I thought I'd just cover some of the resources that KSBN provided. To start, I will point to page 139 in the packet that the board sent in response. It's labeled as attachment F. And this attachment covers the board's disciplinary process. This is a pretty comprehensive process where there are some statutes based in the Kansas Nurse Practice Act. Largely, this is based in the Kansas Administrative Procedure Act and Kansas Judicial Review Act. And so it would be pretty consistent based on what each state agency does when it comes to disciplinary action and pursuing that. First, the board receives a complaint, or sometimes this generates because of an application to verify licensure requirements. That complaint and/or application, if there's a reason that it would be violating the Nurse Practice Act, is then investigated. This is investigated by a nurse, primarily nurse investigators, and they collect evidence through subpoena or witness testimony in any other matter. At the completion of their investigation, They will then write a investigative summary that is provided to delegated members of the board. I'll kind of cover why they're delegated in the future, but largely is because later on in the process, other members of the board need to be able to review that case without a conflict. And so there are members of the board who do not hear those facts until later on in the stages. So if the board reviews the case and believes there's a violation of the Nurse Practice Act and wants to pursue disciplinary action, they will then transfer that case and that disposition they wish to pursue to the board's disciplinary council. I am one of those attorneys that review those cases. We then do a thorough review of the evidence provided in that case and also the board's disposition that they decided at that stage. They then, if we have any questions, we will go back to the board to get clarity. If we have any questions on the law, we'll reach out to the Attorney General's office and our support over there and see if it's consistent with what other state agencies are doing or if there's, any questions on application. Moving forward, if action is pursued, generally that starts with a summary proceeding order. A summary proceeding order alleges facts, violations, the law connected to an issue, and also provides the board's decision, what action they choose to pursue, and also notices of what their applicant or licensee's rights to that decision would be. That is provided in the chart. Notice of rights are provided on pages 32 through 34. I broke it down based on different orders that an applicant or licensee may receive. They basically say what kind of, depending on which step they're in, what they can do. And so to a summary proceeding order, licensees and applicants have a right to a hearing. They have 15 days plus 3 days because of mailing to request that hearing, and that's all based in statute. If they choose to request a hearing, that case is then transferred to the Office of Administrative Hearings, where a non-biased administrative law judge will review the evidence in the case and see if it supports a violation of the Nurse Practice Act. The board does contract with OAH to provide those services, but this is not someone who has ever reviewed the case with the board or has like a position at the board, is a staff member, has a relationship with the board other than that they handle these hearings. Hearings are similar to like a trial. We do opening and closing statements. We put exhibits in. We have witnesses. And then the board, then the administrative law judge at the end will put in an initial order. If the administrative law judge finds for the board and the action is still not final for about 33 days because the applicant or licensee has a right to review of that decision by the board's agency head. So again, that's that prior step that I kind of discussed of another member of the board who's never heard the cases before is then reviewing that case and making sure it still is upheld. After that, if the agency head decides to pursue that action, then they put in a final order. That final order still has a reconsideration right to the administrative or to the agency head. After that, if there is an order, additionally stays could be issued during this period. If we have a final order and the board has made a final decision on that case, then the applicant or licensee has a right to judicial review. Judicial review happens through the district court, the Kansas Court of Appeals, and the Kansas Supreme Court if they choose to hear. Through that process is kind of the conclusion of the case and the decision on if the law and statutes upheld by the facts and evidence in that case. Again, each of these steps, each of these orders that the applicant would receive or the licensee would receive would include the notice of rights, whether they have a right to a hearing, reconsideration, review, appeal, judicial review, and how to do that is included. I will note that throughout this process, at any stage, there could be a settlement. And that is where you would see a consent agreement and final order. It not only happens at the beginning, it can happen throughout the whole process until there's a final closed case. The consent agreement and final order, there is an example provided on page 163 of your packet. Let me turn. And so these can come from not only the board side, but also the licensee's attorney, the licensee themselves at a request. They are.
I'm going to put you on hold right now because when we are going to thoroughly discuss consent agreements, so just take note of this page number because there will be questions about it. But I'm going to go back to the flow chart.
Okay, perfect.
And I think we may have some questions. Vice Chair Lewis.
Thank you, Madam Chair, and thank you for being here. I have a couple questions about the process. I mean, I think I understand the process that you've outlined, and it comports with the statutes that that the law on the books now. But as I've thought about this over the last month, I've wondered if we shouldn't consider a mediation process up front. In my 38 years of law practice, I will say that increasingly, and I've been in litigation for those times, increasingly lawyers and others involved in resolving disputes have found mediation to be very helpful. And I'm wondering, you work at the Attorney General's office, right?
I'm integrated within the Board of Nursing, but my position is Assistant Attorney General.
I'm just wondering if you're aware of any other context in which the Attorney General's office engages in mediation, and if you are, what you know about that.
I am not familiar with the Attorney General's office mediation policies. I'm not aware of any other state board of nursing or state boards for professional licensure that use them. It's by all means possible. I have not heard of them in discussions with other attorneys over there. From when we sit down and talk, other people who handle professional licensing boards, it's pretty consistent with this process, but it could be that we just haven't brought up mediation.
Right, okay, thank you. As I said, my own experience is that oftentimes you can get early resolution of matters, mediations, a voluntary process. The resolution, if it comes, is completely voluntary, similar to your consent agreements. It's just that in this case, you would actually have a non-party mediator working with the two parties, the nurse and the nursing board, to come to a resolution that could avoid a lot of costs and expenses and time for everybody involved. The other thing I've thought about as I've thought about this process is how expensive it is for the nurse. It's expensive for the government too. You have your time and others. In the nurse's case, though, she's not, taxpayer monies are not being given to her to hire a lawyer. And although, question, in the administrative hearing, does she need a lawyer, or he or she can proceed without?
Yes, they can represent themselves.
And how frequently does that happen, in your experience?
It comes and goes. I would say, in my experience, I feel like it's about 50-50. That could be changed. I don't have actual data points to support that, but I feel like usually we have that actually go to hearing, about 50% probably are represented by counsel.
Right.
Or at least request them.
Yeah, so one of the proposals I think that are going to come before the committee later today is to consider mediation, and also consider a system whereby the costs and attorney's fees would be shifted in some fashion if the nurse were to prevail in the process. And I'll leave it at that.
Other questions about the process? I actually have just a few. Okay, Representative Request.
As we went through the page 139, you mentioned at any stage it could result in a settlement. How many settlements are come to? What kind of percentage of settlements are there that don't result in an admission of guilt and signing a paper?
So, because of the board's reporting requirements, which I will cover later on, the action itself is what makes the action reportable. And so the board often pursues that through a consent agreement and final order. I am not aware of any that we have not had an admission of guilt, or have I had opposing counsel suggest that to me. We would have to review the statutes on what the possibilities are in that. I mean, there have been diversion agreements in the past, which is somewhat not an admission of guilt because it's just a stipulated fact if that would be imposed if not, but a clear, like, no admission of guilt, I'm not familiar with, but we can review the statutes to see the possibility in that.
Thank you.
Okay, I do have a few questions for this page, and actually, if we could have a staff member on hand close up, because you may not have this. How many, according to the performance measures, complaints have doubled in the past 5 years. They started at about 419, and now they're estimated for 2026 to be 825 or 6. So from those number of complaints, first part my question is, how many of those are investigated? I believe, I couldn't find how many investigations per year.
I will defer to Linda Davies to answer that question.
Okay. That may be in the performance measures. I didn't see it.
Linda Davies, practice specialist for the Board of Nursing, so thank you very much for asking me to be here. I was in Pennsylvania in July, so I was not able to be here, but I did listen to the entire hearing. So I can say that the complaints that we have been receiving, we are seeing an increase, and that's primarily probably because I'm going out and doing presentations. I'm a member of the CARCM, the Kansas Association of Risk and Quality Managers. I have a master's degree in patient safety and quality, so therefore I'm interested in knowing what can we do better and what the data say that we can do better at. So I do visit with them, and they do call me and ask me, can we do this? How do we do that? And so we run hypotheticals sometimes, but then they also do report. So they are, the facilities, the hospitals and long-term care facilities, medical clinics, they are reporting more. So I think that's what we're seeing. 20% of the complaints that we do receive are averaging to be sworn statements, so therefore they're admitting, the risk manager is saying that they would testify if they were called to have to, like, acknowledge that their complaint that they submitted was true and correct. The complaints that we open, it depends. If they're not sworn and there is a licensee that the board could take action on because there is a license to practice in the state of Kansas that the KSBN has given, or they have a privilege to practice because they're a multi-state licensee from another jurisdiction that is working in Kansas. We don't know if those multi-state licensees are coming into Kansas to work because unless they get a violation of the Nurse Practice Act and the employer reports them. So they can be in here working, unless the employer reports, we don't know. But then in that case, we run the investigation because we have subpoena power. And then at that point too, then we would then communicate with the other state board of nursing because that's where their multi-state license is from. Our board is only able to take action on the privilege to practice. So your question is, they've doubled. I think it's because we've joined the compact. I work with other state boards of nursing. I communicate with them every Wednesday. I have contacts in other states. I do contact and discuss things with current different committees here and then different organizations here in the state, as well as I also go and I talk to all the students at the schools of nursing. I've gone out to Fort Hays, to Emporia. I'm going to Pittsburgh at the end of the month, Emporia. So I've gone to Baker. KNET went to Baker. I couldn't go that day, but they went to Baker. So I've gone to KU. So there's more education, I think, and more communication from the Board of Nursing out. So therefore, we're seeing more complaints being reported in. Does that answer?
Thank you. So what was the number of investigations?
For this year?
We could just go with 24. The
number of
last
investigations, I think we were at, I don't have my numbers with me, but out of the, say, 800 that we received, we'll say maybe 625 were maybe opened.
Okay, if we could get a follow-up on that, just to confirm
Okay.
those numbers and perhaps the number of investigations per year. If it's on the performance measures, I missed it, so you can just, if it is, just reference that. And it did include the number of hearings, which was, and orders. It had, I think, around 34 or 30, which was very low. So that means that when we get to the consent agreements, we see that that's much, much higher. My last question for you is about the complaints again. We have a great flow chart that shows the complaints that are directed toward a nurse. What about complaints that are directed towards the Kansas State Board of Nursing?
Those don't come to me.
Okay.
So those go to Carol.
Okay, so Carol, make note of that. You don't have to answer at this moment. Next time you're up, I would like you to respond to what you do with complaints related to the Kansas State Board of Nursing or the website, and if you're tracking those. If not, of course, I believe that you've said that you would be looking to track them in the future. Thank you, Linda. Oh, Representative Humphreys, is this for Linda or back? Okay.
It's a quick question. I may have missed something. Those 800-plus complaints, and this may be in there, who's making those complaints?
The facilities, the other nurses, we have patient families, we have patients. I mean, it varies.
So I was just curious, when you say you're going out to speak to nursing schools and so on, I don't really see how that correlates to more complaints. I mean, because
The risk managers had a huge turnover a couple of years ago, so they have now 72 new risk managers. So by educating them as to what to report, how to report, who to report to, because there's a variety of ways to report for various different agencies, it's kind of like just keeping that communication up to speed to where they know who to call if they have a question.
And that's 72, where are they? I mean, just all over?
They're in the facilities, the hospitals.
Okay.
Throughout the state of Kansas?
Yep, okay.
Yeah.
All right, thank you.
Representative Tarwater.
Oh, sorry.
Thank you, Madam Chair. Can you clarify what a complaint is?
Complaint? It is, what is received is an allegation that the facility has found either through their risk management process, through their peer review, internal peer review, that they are alleging that this licensee has done X. And so the complaint comes into us, it's an allegation. We have no evidence until we start an investigation and determine whether or not the committee is going to be seeing the evidence that's there. Sometimes the evidence doesn't support the allegation that's presented.
Thank you, Madam Chair. So last meeting we had, when the nurses that testified, they all testified that they're the ones that reported that their license had expired inadvertently, and they needed to try to, or they double-clicked or whatever the story would be. And all of those counted as complaints is kind of
No.
how I heard it. Those are not
No,
complaints.
it does not. And that's kind of what I wanted to clarify with you, because complaints are separate from applications that have legal history. So on the investigative side, we have, the complaint comes in alleging unprofessional conduct from a facility, from a patient family, whatever, and we will run it through this way. The application for licensure, which is what you're talking about with the reinstatement applications, if there is a hold in our system that shows that they are currently being investigated, or if they've answered incorrectly on the questions, or they've answered that yes, they have a felony and they're trying to apply for a multi-state license, they're ineligible for a multi-state license. So those type of things will come to the investigative division to review, and they don't necessarily have a nurse investigator that looks at those, because primarily they're looking to see, we need to get certified data court documents, and we need to have an explanatory statement from the applicant, now the former licensee, to say, yes, this did happen or whatever. So since June, since these questions were starting to come out, I have just a nurse investigator only looking at reinstatement applications, because the issue is the practice of nursing and whether they continue to practice after their license lapsed.
Okay, so if a nurse double-clicked on one license, and I know you've maybe have fixed that process, but if they double-clicked on the same license rather than renewing both licenses, or if they were a few days late to renew, and that is not a complaint unless you look at it and you're going to take action, then it becomes a complaint?
If it's flagged by licensing to come to us, then we do look at it.
So that counts as a complaint?
Not in the data. The data is separated so that the complaints are complaints and the applications for legal review are separate. Because we run around 800 for one and we run around 1,600 for the applications that we review every year.
Okay, so on the 1,600 that you just mentioned, how many of those are enforced and how many of those do you just let go? Let renew late?
I can get that data for you. I don't know off the top of my head.
Well, you may have already gotten that data because we asked that question several times last time. Did we receive that?
Regarding the lapse licenses?
Right.
Yes, we do have that, and we'll
Okay.
definitely take some time on that
you.
particular item. So I guess to follow up, we have two others that are in the queue for questions, but to follow up with the line of questioning, in theory, then there could be a much greater number of investigations than complaints, because they could be coming from the licensee board or the licensee or those that are working with KSB. So for example, if they identify that someone, for example, clicked a button twice incorrectly, that gets pushed over towards an investigation. It was not a complaint. So my question is, investigations could, in theory, be greater than the number of complaints.
The number of investigations is, if you want the total number, it's running around 2,500. That includes all applications for legal history plus the complaints that are received. So.
All right, thank you.
But to my knowledge also, I don't think I've ever seen an application where someone has double-clicked that's come to us to review, to my
Well,
knowledge.
we did discuss that. There was an individual, and we discussed that in our last select committee.
Okay.
We'll go on to Representative Waymaster and then Vice Chair Lewis.
All right, thank you, Madam Chair, and thank you, Linda. Who is the board's licensing division?
That would be, the licensing supervisor is Rayanne Bird. And then there are 4 total staff on the licensing side, Karen and Barb and Jackie and
so
Rayanne.
they're staff, they're not board
They're
members.
staff.
And I'm looking at the budget summary from the 2025 legislative session for the Board of Nursing, and it has listed here under the agency overview, the licensing division, and it says the board's licensing division evaluates nursing schools and maintains the licensure of practical nurses, registered nurses, advanced practice registered nurses, anesthesiasts, and mental health technicians. So in the purview of the licensing division, is there a monitoring of those that are coming up close to expiration?
I'm not over the licensing division, so I could
Right.
direct you to Adrian Guerrero, who is.
And that might be a question that we can have answered at a later time.
Okay.
And then going on to Representative Tarwater's questions, and I believe even the chairperson had, asked us about the double clicking and everything and I'm referring to page 12, so am I jumping ahead? I can reserve my questions for later. But it said that out of the 60 nurses that took disciplinary action, 10 nurses provided in their statement to the board that they thought they had renewed or attempted to renew their licenses. Of those 10, 8, there was no evidence at all that they had tried to submit a renewal. But I'm looking at the other 2, and it says one nurse had an unsuccessful transaction, so I don't know exactly what an unsuccessful transaction is defined as, and the other had attempted to renew her license 4 times, and there was still action taken against that particular nurse, even though that they had tried to renew their license. So I'm just kind of perplexed as to why there was disciplinary action on 2 nurses. I mean, I know that's out of, many more cases that were out there, but why was there any disciplinary action taken on those 2 nurses that one had an unsuccessful transaction, the other one tried to renew it 4 times?
That would be a question for disciplinary.
Okay,
All
and
right.
we'll
right, thank
circle
you, Madam
back,
Chair.
because actually on that page 12, I had a question on it. It says, what happened to those nurses? And were they part of the 60 or 40 that were provided to us on the lapsed nurses list that we received?
Well,
And-
Madam Chair,
yes.
according to page 12, it's out of the 60.
Okay, because of the action taken?
Yes.
Okay, well then it's part of the 60, so that we will want follow-up, so when we discuss that particular handout, then we would like to know what happened to those nurses and why in those situations. Any other questions for Linda? Yes, Vice Chair.
Thank you, Madam Chair. And I'm just following up on questions by Representative Tarwater and the chairwoman. So I'm now referencing page 139, attachment F, which was the flow chart of the complaint process. And I just want to be clear, if there's an applicant and there's an investigation and it goes beyond the initial investigations process, it does then turn into a complaint, and the flow chart that we're looking at, attachment F, would apply to how that's handled?
If there is an investigation into an application that has legal history that we need to look at, then it goes to the nurse investigator or a special investigator, depending on the type of application that we currently have. And then it goes to the investigative committee chair for review. They are the ones who make the determination of disciplinary action or not based on criteria. They have delegated duties from the board to be able to make those determinations. And we do that so that the applicants for licensure are not held up waiting for a quarterly board meeting, so that we can meet weekly, sometimes every other week, depending on when. And like if we have new grad season, we try to meet as often as possible to get the nurses on the floor as timely as possible.
Right, so my question, if I might, is does the flow chart that we're looking at, attachment F, apply to that process?
I would say there needs to be an addendum to this that just is dealing with the applications for legal history, and it adds to and connects into it. But I don't consider an application for legal history a complaint, which I think that's where we're getting confused.
Right, so maybe
Do you
I
want me
can
to
ask-
add
Maybe I can
an
ask the
addendum to
Attorney
this?
General's, yeah,
Okay.
Rachel, is it Rachel? Rachel, yeah. Maybe I can ask Rachel about that.
Okay.
All right, we'll shift to Rachel, and we'll finish up with any questions on the flow chart before we go into the next hot topic, which will be the consent agreement, which also will be the list of 100 lapsed licenses. And there is a handout for that as well. Representative Lewis, did you want to follow up?
Yeah, so you followed my questions.
Yes.
I'm just trying to figure out how your flow chart here applies to the applicant who's investigated, and then the board determines to go further with that.
Yes, so really, on that top first square, it could be complaint and/or application. It still would go to an investigation, which was what Linda was referencing, by a nurse investigator or based on legal history, if they need to, get court documents, that would be that investigation. And then it is reviewed by a delegated board member. An application is a single board member because of the frequency they need to meet versus the 3 that meet for the investigative committee. But their going forward is the same process. The same due process is provided by the Kansas Administrative Procedure Act and the Kansas Judicial Review Act.
So if I might. So the investigation you're talking about is found at exhibit attachment F again, near the top left-hand corner where it says investigated.
Yes.
And then if you proceed beyond that, it goes to review of the board and then down the list.
Yeah, and all that process would be the same. We provide same right to a hearing, right to review, reconsideration, and judicial review.
All right,
Kind of the big steps.
Thank you.
Representative Humphries.
Thank you. And we were told there were, in 2024, 625, I think is what I wrote down, investigations. Can you break down which ones were the complaints, the risk management complaints versus the complaints about the other?
Yeah, and I would need to defer back to Linda. She does the metrics on complaints. Really, I am once the case gets transferred or during the review process. Yeah.
All right, so what we'll do is give Linda an opportunity to pencil that together, all the different investigations. We've heard 1,600, 2,500, 800, so I think there may be some confusion on that. So if you'll pencil that together, and we'll have you provide that number to us shortly. Also, before we proceed, when we look at reviewed by the board, would that mean as few as one person from the board, 3 people from the board, or the entire board?
So it is delegated, because like I discussed before, because we do have to have members of the board who do not have review of that case. So when it goes up on like an appeal reconsideration review, they're able to look at it with fresh eyes. So yes, if it's discipline, it is typically handled by all 3 investigative committee members unless someone is not present that day. It needs to have a quorum to make a decision. Applications are typically, unless requested by the chair, which then it can go to the full committee based in the delegation. And I can provide those delegations. I don't think I provided it in this packet, but I can follow up with that if you would like. But yes, it would be 1 member that reviews it at that stage. Because it has to be a weekly review, we want to get people licensed and back in the workforce.
Okay, so if somebody does have a renewal glitch or they have a lapse of 6 days, then they would be likely reviewed by 1 individual from the board.
That's correct.
So 1 person determines whether or not they're going to move through with disciplinary action.
Yes, they decide what to pursue. Many members then, we talk about the ALJ, the district court judge, the agency head, also review this matter before it becomes final and imposed.
Okay, all right, thank you for that. Committee, I would like you to also pull out the document that has, at the very top, it has name in the left-hand corner, it has the 40 licensee applicants, and that is going to be the document provided by research that was provided by the board. And so as we move through and you are reviewing the consent agreement document, as well as we start moving through the questions that begin on page 10, 11, 12, I want you to have all of those handy. Yeah, it's this one. All right. We'll first have you overview this section, and then we'll have Representative Avercamp go with the first question. Well, go ahead.
Thank you, Madam Chair. Not sure who to direct this question to, but for me, it's kind of an important one because the Board of Nursing has flexibility to make distinctions. And so I think, from my perspective, it's a very important aspect of this. On page 8 at the bottom, in answer to the question, would the board admit that mistakes have been made given the testimony they heard earlier? Right at the bottom of the page, it's the last sentence. Kansas Board of Nursing only pursues actions they believe in good faith violated the Kansas Nurse Practice Act. Anybody, just in good faith, anybody want to define that, how the Board of Nursing would break that down? So in good faith.
I can defer to the board in that I think in good faith is they apply the law and statute based as it is and in application of that law. They do not intend to act outside their authority provided within the law.
Okay, but they do have to make distinctions.
They find violations based on the practice and the statutes. That's what they practice within, I believe is what the intent of that statement was. I don't know if we want to defer. Does a board member want to discuss? Brenda Sharp, one of the investigative committee public members, will.
Okay, and while Brenda's coming up to answer that question a little bit further, I'll also remind the committee on page 26, this committee did ask for a review of those cases that were brought to this committee during our last meeting, and we will be talking about those and the review of those particular items because I don't think all the information was disclosed that we requested pertaining to those, so we'll hit that as well. Go ahead. We have Brenda.
Good morning, Madam Chair and members of the committee. I'm Brenda Sharp. I'm a public member of the Board of Nursing. Happy to be here today to try to answer questions that I can. I will state that as a member of the investigative committee, I take my charge very, very seriously as the charge of the nursing board is to protect the public. That is our charge, and we all take that seriously. My fellow board members on the investigative committee and the board, the majority of them are nurses, practicing, retired, et cetera. I am one of 2 other public members that serve on the board, but I would consider myself a staunch supporter and appreciator of nurses and the nursing profession, so I will start with that. I'm in a bit of a difficult position here because some of the conferees that you have allowed to testify before the committee, either at the last time or that are on the list for this agenda, have become before a committee of which I'm a part. Most of them have not. Most of them were part of cases in which I was not part of that review. But I did want to just offer a few thoughts or answer any questions. If you want to repeat your question, Representative, I'm happy to try to address that.
Yes, thank you, ma'am. So I think from my perspective, the part of the problem is there appears to be different application of statute or the flexibility that the Board of Nursing has. So somebody is late on their renewal. When does the Board of Nursing decide, yes, we're taking disciplinary action here, but not here? And then seeing on page 8, it says, in good faith, violated the Kansas Nurse Practice Act. And just hearing some of the testimony from our last meeting, we had nurses that have never had any disciplinary action, never had any problems. And there's what appeared to be a very small clerical error on their reapplication, their renewal, and they received disciplinary action. It doesn't seem like that would really be in good faith, like they were trying to violate the Kansas Nurse Practice Act. But we also see that there were some that didn't renew on time and they were let go without any disciplinary action. So just how do you make those distinctions?
I think I'll start with it would seem, and you all have heard one side of the story, and unfortunately the board nor this committee is able to provide full details of any of the cases that are provided, because we would then be violating confidentiality, every statute and regulation that I'm aware of as part of the sworn oath that I took to be on the Board of Nursing. So you are hearing one set of facts as that individual sees it. It is possible, I would ask you to consider that there are other facts and circumstances that taken in totality might offer a slightly different perspective on some of these cases. I can't speak to all of them. As I said, I wasn't involved. I will tell you what good faith means to me. It means that I spend every weekend prior to our investigative committee meeting, which is the 3 individuals, 8 to 16 hours reviewing a packet of about 500 pages of investigative reports on licensees on which we've received a complaint. We review all of the information that's been provided to us. That includes prior discipline or interactions with the board. It includes witness statements. It includes interviews with other adjacent providers to that individual. It may include malpractice insurance reports or claims. We see a substantial number of drug diversion cases. Sadly, it is a very prevalent problem amongst the nursing and many other health professions. So we receive information from K-Tracks, for instance, on the number of prescribers or the number of prescriptions that this individual has and is possibly shopping for others. We see lots and lots and lots of information on lots of different kinds of cases, and it's our responsibility to take all of the facts and circumstances and look at the totality of that. You are seeing and hearing some of that. We will not, cannot, would not, and should not respond to individual cases that have been provided and presented here to this committee. But in good faith to me means I read it all, I consider it all, I discuss it all with my colleagues who are nurses, and we move forward with a recommendation to our disciplinary council as to how we would like to proceed.
Just one quick follow-up. So for a nurse who failed to renew on time, and they kept practicing, can you walk through a case scenario very generically of when that individual would be let off without any disciplinary action?
Yeah, I would say if they were not practicing nor representing themselves professionally to be a licensed nurse professional.
So am I hearing you correct that if they did not renew on time and they kept practicing, they would receive disciplinary action?
Most likely, yes. If they did not renew on time and continued to practice, then yes, they are practicing without a license.
And committee, we will be looking at the details of those examples that were listed, or the number that was included on the performance measures, and then the document that was supplied to us, which is the 100 lapse licenses. So we will definitely be getting more in depth into that. I think that is it for the moment, but I'm sure there'll be more questions. And Rachel, go ahead and come on back up. Let's go ahead and move to the consent agreement that you were discussing. You wanted to overview for us what a consent agreement looks like. It was on page 163. And then let's just move through the questions, and I will stop you because there will be quite a few questions.
Okay. So just to begin, I thought I'd review the consent agreement example provided to you, as you stated, on page 163. I wanted to note that, as discussed before, applicants and licensees are sometimes represented by counsel and sometimes they are not. When a licensee is not represented by counsel, we do include a cover letter when a consent agreement and final order is offered. I don't believe that we provided a copy of that with you, but again, I can supplement the file if you would like to see kind of the form of what's provided. In that, one of the statements including that letter is that the investigative committee or chairperson, depending the case type of the board, has reviewed your pending case and feels this may be resolved with a potential agreement between you and the board. At this time, the board is not ordering any action included in this agreement, and this is only an offer to enter into an agreement with the board regarding your outstanding disciplinary case. It then goes on to give instructions on if they wish to pursue that case or that agreement, how to execute it, how to sign it, and how to send it back. And then it concludes by saying nothing in this letter should be interpreted as legal advice. If you need legal advice, you can seek the advice of a licensed attorney, and that would be at their own expense. And that is pursuant to the statute. So to circle back to the agreement that would ultimately be offered, this is just an example. There could be some deviation based on the facts of the case, negotiations between the parties, various things, but this is a good general example of what would be sent. I wanted to highlight a couple of paragraphs based on the questions that we received. The first is paragraph 2. This paragraph states, applicant understands that pursuant to KSA 77515, applicant may be represented at applicant's expense by an attorney during these proceedings. Applicant would be replaced by licensee if this was a licensing case or a case based on a licensee, but that would just provide them notice of their right to an attorney. And we do put that right after the jurisdictional statement. The second paragraph to highlight is paragraph 8. This is their notice of rights paragraph. It states, applicant has a right to a hearing with evidence and witnesses. Applicant has a right to seek review of the findings from that hearing in accordance with the Kansas Administrative Procedure Act as provided in KSA 77501 SK, and review of an action pursuant to the Kansas Judicial Review Act. And again, it provides the statute of the Kansas Judicial Review Act. Applicant is waiving those rights and voluntarily entering into this agreement in order instead of proceeding to such a hearing. Again, this is to provide notice of those rights and what they would be waiving by signing this agreement. The next paragraph I will point you to is paragraph 19. This is the paragraph that references the discipline and the reporting of that discipline. It includes this agreement order is a discipline and must be reported on any future renewal or reinstatement applications. The original of this agreement shall be placed in the disciplinary case file, agency record. This agreement and order may be disclosed via request for records of information. That would be pursuant to CORA. And this agreement will be reported as required by state and federal law. Again, later on, we can discuss the National Practitioner Data Bank reporting requirements and the resources we provided connected to that. Additionally, that could include nurses, which is based in the Nurse Licensure Compact, so state law, and additionally, the Office of Inspector General.
Okay, there may be questions about the consent agreement, but I want you to hold those. Remember what those questions might be. I want you to jump to the bottom of page 10, and I want us to begin discussing the 100 lapse licensees. As everybody's turning to the bottom of page 10, of course, also have the other document that I mentioned. I will set a little context because this is an item in performance measures. The item listed in the performance measure says the number of nurses practicing without a current license. The information that we received back actually indicated, and perhaps I misunderstood, that 40 of them there were no findings that showed they practiced without a current license. If that is so, then it's a little confusing that they were included as practicing without a license. So I think there is some ambiguity, and hopefully you can provide clarity. For the committee's reference, there were 44 that were practicing with a lapsed license in 21. Then it jumped to 121, then it went to 48, 45, 100, and then there's estimates for 75. So before you go into the details that are found on page 10 through 12, and we answer Representative Waymaster's question specifically, can you address the 40, 60, and what's listed on the performance measures?
Yeah, I believe we somewhat addressed that last time. I don't know why it was probably an oversight to list it as that way, and we could, moving forward in reports, provided as this is 100 that were investigated for unlicensed practice. And so there are certain codes internally that would be pulled and can conclude that those were the 100 investigated. These were not the ones necessarily transferred to disciplinary counsel or which action was pursued. It was simply the investigation of those 100. And to put in context, I did look for fiscal year 2024, some numbers. So 31,788 nurses renewed that year. That includes, and then additionally, 1,155 nurses filed reinstatement application. So as we discussed earlier, that reinstatement application is often what results in an investigation for unlicensed practice, depending on the responses on that application. So of that almost 1,200, 100 were investigated, 40 had no action pursued, and 60 had disciplinary action taken, and most of which were a fine.
Representative Hoy.
Thank you, Madam Chair. So this says publicly available action. So this list, any member of the public can request?
The list of 100?
Yeah.
No, typically that is not something that we have. It is publicly available information. If it was reported as discipline, we provided that out of a request from from this committee to provide that list.
So we just put these names out on the public record that wouldn't have otherwise been able for the public to get a list?
So they would have been reported based on that, but this list would not be in existence until we received a request. We were trying to provide all information as requested from the committee.
Okay.
Thank you.
I don't like that. Thank you.
Representative Hoy, they are actually public. You can find them on at least 3 databases. So if you wanted to find any, that's the only reason they were included, because they are public. So that is why they are included. So yes, Representative Hoy.
Okay. Thank you, Madam Chair. I am not able to get on those sites and look them up. Like, you have to have a membership or something.
Actually, I have myself.
Okay.
You can go on to the Kansas State Board of Nursing website, and they have a disciplinary button you can push, and you can pull down. In fact, I was able to find the individuals from our last meeting on that list. I found one random one that had let their license lapse for 6 days that I brought to this committee. So
okay.
you
so
can.
I could make this list myself?
Yes, you could.
Okay.
Okay.
I'm sorry,
Yes.
Madam Chair, I just want to put one note. So typically in these orders, I think, notated on the form that you received, C&E information and also number of days is not always included within like a consent agreement or in order. So that is a little bit more specific information that typically is within the public order, but is within a file that could be requested for Kansas Open Records Act.
Well, I will know if you have a consent agreement, and I believe 60 of them signed consent agreements, you could click on the actual document and you could find out exactly how many days there was a lapse, if that was one of the key findings. So it is available. You just wouldn't be able to put it together. You would have to spend some time putting it together in a chart, which is why we asked Rachel to do that for us, so we could completely understand the data. So Representative Francis, and then I would like us to follow up on Representative Waymaster specific.
Just real quickly, to make sure I understand, the 60 can be found on the website, not the 100. The 40 that nothing was found against, obviously, correct. That's not reported, correct?
Yes, that's correct. Only the ones that had final disciplinary action would be reported.
Correct. Those were redacted for that reason. So we just wanted to understand the difference between those that did not have any action taken and those that did have action taken. So I'm going to come back to Representative Waymasters. Are the examples that are listed on number 12, action taken on 12-9 and action taken on 12-5? Can we find that on our list? Because it says 2024, and I believe this list is 2024. Oh, this list is 23 and 24.
So that data came from fiscal year 2024, so it would be inclusive. I don't believe I notated which ones those were on that list. And I'm not prepared today to discuss any kind of specific cases, largely because I may have not represented the board in those cases. We can provide further follow-up, Representative Waymaster, and to the committee regarding the specifics of what the outcome of those cases were. I can provide the public agreement or order. I just don't have that prepared for today.
Okay, because I'm looking on the list that you provide, and I cannot find one that has, and maybe I'm just missing it, 12-5 or 12-9.
Okay, yes. So I believe on the list, we provided the date of lapse and the date of reinstatement was filed. That does not mean the date of which action was taken. So largely that is because of, again, that flow chart. That process takes time. If you would like follow-up regarding the date actions were taken, we can include that in follow-up materials.
Right. Representative Waymaster noted that says action taken. So we would like some follow-up on those. Is that correct?
Yes, Madam Chair, that's correct.
Okay, if we could add that to the list, because we would like to know if they also received a professional misconduct or unprofessional conduct as well, if they had to sign into a consent agreement. So committee, let's pause and look at this list for a moment, because we want to ensure that there is parity. If you look at the first page on the list, and also it's interesting to find out who had their professional development in place and who did not. And in many instances, even if you had your professional development, you were given the same amount of a fine versus somebody that did not have it. But on the first page, we see a lapse of, for example, one individual of 8 days. On the second page, we see one individual that had a lapse of 13 days, it appears. However, it said no finding, and so no action was taken. On the third page, we have an individual that had a lapse of 3 days. They did sign a consent agreement. They did not have their hours at that time, but apparently they were able to complete their hours within 3 days, but for those 3 days, they had to sign an agreement. Then right beneath that, there are two individuals that had a lapse of 4 days, and they did have their education up to date, but they had to enter into I'll say that loosely, they were compelled, they felt necessary to enter into a consent agreement, and they paid their fine. So just throughout this, you can just look at the number of days. On the next page, you'll have someone with 5 days, 6 days, 8 days, 6 days. My question is that a consideration, the amount of time? Or it looks to me, no matter what the amount of time, a consent agreement is required?
Okay, so first, just again, I think you kind of conditioned it earlier, but consent agreements are never required. They're offered and they're a voluntary agreement. And so a licensee or applicant is never forced to enter into those agreements. They are offered them. I will say the board also received a letter from the Joseph Hollander and Kraft Professional Licensing Defense Team, who often represents licensees and applicants when the board pursues disciplinary action, and they spoke highly of consent agreements because of it being an efficient way to fulfill its enforcement responsibilities for the board and protecting the public, while also the nurse receiving expedient and cost-effective resolution. That is one reason why consent agreements would be entered into. Regarding what is considered, unlicensed practice, the number of days is generally, in my experience, considered. It is not the only piece of evidence considered. The board may also look at the statement on accountability, whether they had knowledge of letting their license lapse when they continued to practice, previous actions. I'm sorry, I'm just coming off the top of my head. There's a variety of things. They look at every piece of evidence given to them in that investigative summary or by talking to the investigator and then make a conclusion of that case. Whereas a useful tool is the unlicensed practice days. It is not the only information that is reviewed.
Representative Francis.
Thank you, Madam Chair. And I understand there may be more that goes into some of this than this document appears to show, but can you give me some context? For instance, I see two individuals on here on the third page. I don't know, is it allowable to use names? I hate to use an actual name, but they were 4 days late, looked like they had their continuing education done. The lapse started on August 1st, and yet the reinstatement happened December 13th. You know, what kind of thing happens where they were 4 days, without a license? It takes 4 months to resolve, and then they get substantial fines over the $100. I mean,
Again, I wasn't prepared to talk about specific cases today. Largely, I probably wasn't the attorney who represented the board in those cases, and so I don't want to misspeak. Again,
and I
all
don't
of
ask
those
for you to-
things can be considered that I discussed earlier, the accountability, whether they had knowledge of practice, as you stated, continuing nurse education, past behaviors. It would be whatever evidence is put in that investigative summary. Again, we could provide the consent agreements for specific cases if you would like. Consent agreements are an agreement. Maybe they don't have all facts in them, but they would at least give you some idea if there was anything else pled in those cases, or agreed to in those cases, rather.
so if they're only 4 days without a license and it took 4 months to resolve the case and the fines were more than $100 and they had their continuing education done, there should be some assumption that there was more to it than just being late.
I don't want to presume anything because I don't want to assume. Now you have a name of list, so I'd be hesitant to allude that any one person did any one thing. I don't want you to make assumptions. But all I can say is the process of which the full investigative file is reviewed. I think also I would like to highlight that the board has heard feedback on this. They are looking into reviewing policy moving forward so that the full board can provide guidance to board members who are making these kind of determinations. But that's not to say that there wasn't something there. I just don't know. The board does act in good faith and tries to review the cases with all evidence before them and whether or not there's a violation of the Nurse Practice Act.
And thank you for that. And I think on that one, if we could add that to the list, when there are anomalies in this list where it takes an excessive amount of time that does not expedite the process for our nurses in Kansas, then I think it would be helpful for you to review that item, and it'd be helpful for your positions as well to know where things got caught up. And I think it would be helpful for us to understand. Representative Francis, Abraham, sorry.
Thank you, Madam Chair. Just quick clarification. So for these nurses who had the consent agreement signed and then they got their application approved and then they were fined, they were also put on the newsletter by name as being guilty of professional misconduct and also put on the website. Is that correct?
So reporting happens in a variety of ways. Yes, discipline is reported in the newsletter. It doesn't label it as misconduct. My understanding is it only will include that they were fined. Additionally, yes, we provide all disciplinary orders on the board in the disciplinary case list. You would have to generally search by the name to know what that outcome was. Again, these are just usually provided for the public so that they are aware of the board's actions and disciplinary action that's been pursued. Rather, they also are reported based on state and federal law to nurses, the Nurse Licensure Compact, which is a Nurse Licensure Compact system, the NPDB, which is a federal-based system, and then also to the Office of Inspector General. And we just provide them. NPDB and OIG have their own process as well. So when it gets reported, licensees and applicants have a process to challenge the board's decision to report. And the board, I can't speak largely to that process because it is their internal process, but I know we've had to respond and support why an action was reported or not pursuant to those processes. And I'm sorry, I can address it later on, but if you're wondering about the reporting, those are, how those appear for unlicensed practice are included within the packet. They are, let me see if I can find what attachments those are. They are attachment H on page 141, attachment I on 142, and attachment J on 143. They are reported as practicing without a valid license. Unprofessional conduct does not appear on that public reporting. It does appear as a statutory site within the order. That would be on the board's website if someone chose to go look for it. But in general, if they do an initial verification search, it would just say practicing without a valid license, or it would not appear at all, and for example, for the Kansas verification site. So you can look at what that looks like. And that was pulled from the same individual who the consent agreement and final order was provided, as an example.
But to be clear, if you are a nurse and your name is placed on here and there is a link to the consent agreement, which is available to anyone, to the public, and if you were an employer, you would check that link. And if you were providing malpractice insurance, you would be looking into that, and it would have consequences. So the professional misconduct would be included in that. It would be a very easy and realistic search if you're an employer or someone or provider of insurance or providing malpractice insurance. Any further questions, Representative? Okay.
Madam Chair, I'm sorry if I can
Yes.
I just want to note, just so for clarity, so if you look in that example, it does provide example of how that appears in the order. And while, yes, the unprofessional conduct statute is cited to, it always is accompanied with the definition, which is practicing without a license. It never appears as just unprofessional conduct. It always includes the definition of what that unprofessional conduct was found in, and doesn't cite to necessarily the rest of the unprofessional conduct regulation. It only is the statute and the regulation for that violation.
Representative Vice Chair Lewis.
Yes, thank you. Representative Tarwater and I have been conferring here, and we're just interested in knowing if we missed it or if there's a definition of practicing in the law or in your regulations.
Yes. So I actually provided that in one of the responses to the questions. Let me see if I can find where that question is. And so, yes, each of those are defined. Scope of practice sometimes is not, but the generalized definition of each practice type for the Board of Nursing is a defined term. Let me see where that is within these. So it begins on page 16, and continues to page 19. So, for example, RN is on page 16. It'll say the practice of professional nursing is performed by a registered professional nurse for compensation or gratuitously. It means the process in which substantial specialized knowledge derived from biological, physical, and behavioral sciences is applied to care, diagnosis, treatment, counsel, and health teaching of persons who are experiencing change in the normal health processes and who require assistance in maintenance of health or prevention of management of illness, injury, and it continues. The next section is an LPN's practice. Then it goes into the various APRN roles. So nurse practitioner, nurse midwife, nurse anesthetist, and clinical nurse specialist. I did not include mental health technicians, which is also a license for the Board of Nursing, but I can provide that if you would like.
Right. Thank you for that.
You're welcome.
Okay, the next question for you is actually, committee, if you look at page 23, it says how many consent agreements related to lapsed licenses or any behavior not related to clinical practice. So we have the list before us of the 100 lapsed licenses, or at least the ones that were reported, and we have 60 of them that appear to have lapsed licenses, and that's why they went into a consent agreement. My question is, were there any that were not related to lapsed licenses? Any consent agreements? Because I'm not sure if the math adds up.
Yes, I believe so. I'm sorry, let me find that data point on that question.
The 11, because it's on page
Yes,
23, it says 7, on page 23, 71 consent agreements. So are we to assume that 11 of those?
We're not related to?
Right, I'm just wondering.
Yes, if that's the, I'm not looking exactly at those numbers, but yes, that is a possibility that 11 were not related to unlicensed practice at that point.
Okay, so just in case that any of my questions or our committee questions are unclear, we'll add that to the list of questions. Clarity in the breakdown of those nurses that signed a consent agreement based on a lapsed license where they're practicing. I understand that you do not consider a lapse if a lapse is, there's no penalty for that, if you will, if they are not currently working. But I'd like to know for sure if we're only talking about 11 individuals that actually in the state of Kansas, out of 77,000 licensed nurses, only 11 individuals had anything that would be professional misconduct other than, out of all of these. That's pretty amazing. Yes, Representative Humphreys.
So I just, for clarification, the flow chart, there's all the complaints. You're going to break down for us sort of the different investigations between lapsed licenses and other complaints, like by risk management folks. But all of those, you can sign a consent agreement and final order. So is the chair, are you asking, we have the 100 that was practicing without a license, but there were other consent agreements signed that had to do with the other complaints and investigations. Is that right?
Yes, that's what
Okay.
I'm trying to get at, is
Yeah,
the
so
total number.
Do you know the total number of consent agreements that have been signed? Do we have?
Based on what the chairperson stated, I believe for fiscal year, I think it was a typo, 2024, that was 71 consent agreements. I can verify that information. Again, consent agreements are voluntary. That's not the only way a case would conclude, but often we will get reached out by opposing counsel to representing a licensee or applicant requesting an offer of conclusion of the case. Or we could be sending those offers in the case of like unlicensed practice for consideration by the applicant or licensee.
Okay, I think it would be helpful even in the flow chart if we had some numbers plugged in, right in the flow chart as far as where people went and what happened and what the next steps were.
Yeah, and we can provide that going forward. I believe we did have some information on the various types of orders in one of the questions, but we can put that into the flow chart and provide it as a supplement later on.
Thank you, Madam Chair.
I think that would be a great visual to have it on the flow chart. I'd also add that on the performance measures, which the appropriations and ways and means they can consider those performance measures, I think it'd be important to break that apart. For example, the hearings, the number of hearings versus the number of orders. Consent agreements are not listed on the performance measures, but I think that there is a keen interest in that. So would ask that be one of those recommendations. Representative Berquist.
This may have been answered before, but I asked, are all the all these that are identified as having signed a consent agreement, are they all identified in the record as having unprofessional conduct?
No. So a consent agreement can be any violation of the Nurse Practice Act. So that's any of the enumerated grounds for disciplinary action that are provided in KSA 65-1120. That can be anything from criminal convictions, whether misdemeanor or felony. Misdemeanors have to be related to the practice of nursing. It can be action in another jurisdiction. It can be a professional incompetency, one of which is unprofessional conduct, which is further defined in regulation. But no, consent agreements can be a variety of violations, not only those related to unprofessional conduct.
Thank you. And just to follow up, my complaint back to this whole process is that the form that we were given of this sequence says complaint at the top, not simply noticed action or even self-reporting action. It all looks like to me that it ends up in the complaint department.
Yeah, I will modify that and provide that adjustment in the future. I apologize if that created any kind of necessary.
Okay, and I jumped ahead. So we're kind of on page 11 and 12. So I want you to just scan these pages here, committee. If there are any questions from pages 11, 12, 13 that were not answered, as you're scanning to see if there's anything we miss, I did find a question on number 11 that I neglected to ask. It said, were any of these nurses reinstated after practicing without a current license? Again, we're talking about those that signed the consent agreement. And the response was, all nurses who submitted a reinstatement application have had their license reinstated. So my question is, so could we safely conclude that those nurses that signed those consent agreements for working with a lapsed license safety was not an issue?
So, okay, so any of the ones, so when these applications are reviewed, often the outcome, not only, but often the outcome is the application is approved and they are returned back to licensing to confirm that they've met all the licensing requirements. Discipline can be a subsequent process because they violated the Nurse Practice Act if that was the board's findings, which would be the findings if they pursue disciplinary action. I believe when we looked at the list of 100, every nurse that had submitted a reinstatement application within that list had also had their application subsequently approved. Now, they may also have had a disciplinary action taken against them, but it didn't, they are currently able to practice or have subsequently let their license lapse.
So back to my point, safety was not an issue.
I don't think safety was I think the violation is they're addressing public safety. The nurse was approved for reinstatement. Exceeding that, I will refer to the board.
So again, safety was not an issue, which by the way, would be the primary purpose of the State Board of Nursing. I believe that's in your mission statement. And if they're reinstated 3 days, 4 days, 6 days, 9 days later, 38 days later, safety was not the issue. They just didn't follow the rules.
So I believe that we speculated to some other risks to the public other than just the nurse's competency. Additionally, the nurse could have had other action taken on their license because of other things that come up through the application process. Applications also typically ask about felony convictions, name changes, contacts. All those are important for the board to verify, including the 11 ULRs, which are uniform licensing or licensing requirements as dictated by the compact. Additionally, the implications on facilities to have an unlicensed practitioner. I believe one of the resources provided were the CMS requirements, which could also be a risk to the public for nurses that are accredited. So the nurse was approved for licensure and continued to practice. That was assessment based on the determination of the board.
All of those things may be true, but we come back to the question, they were approved for relicensure. Therefore, the Kansas State Board of Nursing was giving a vote of approval that it was safe for them to practice. Disregard federal rules, disregard state rules, disregard having no grace period. The board said, yes, we will renew your license. You are safe to practice. That is what I'm getting at. Safety was not an issue on any of these cases because 100% of them were reinstated. That is my point.
And I'm sorry.
Is that not correct?
I would
'Cause I'm
say the
sure you
board
wouldn't-
pursued disciplinary action on the actions that happened before that they were reinstated. That is what the grounds of the disciplinary action are. It is not from the moment moving forward. And so, yes, the board did approve that application because they believe they met the licensure requirements. But that doesn't mean that they did not pursue disciplinary action regarding the conduct that they engaged in while they were lapsed and they continued to practice without a license.
I understand, but the number one thing that we should all be concerned with, and it is in your mission statement, is safety. And all of these fulfilled that safety obligation, or they would not have received a license. That's what we care most profoundly about, is safety for our public. And all of them fulfilled that, as well as those individuals that we reviewed in our last meeting. They did receive their license. They were considered safe to practice nursing, period. Representative Hoy and then Representative Awerkamp.
Thank you, Madam Chair. And I agree that safety is the number one priority, but I do see the importance of other risks to the public. And that's what I was mentioning earlier about, you know, I'm going to say this is probably very rare and very unlikely, but even if it's a clerical error, whatever the reason that it is, somebody just forgot to renew their license, if a malpractice or something does occur in that time, patients are still at risk of not being able to recover the full compensation for whatever that may be. There are other risks to the public other than just like, oh, thankfully this nurse isn't going to do this or that to me. There are also risks to the facilities and the nurses themselves, because then they could have somebody come after their assets if their malpractice insurance isn't covering that. So I understand where this is coming from, that it seems like, oh, this was just a little accident, but a clerical error and accidents can mean life or death in this profession. And so I am very appreciative of all of the time you're taking to explain this. I feel like I've learned a lot, and I'm just appreciative to those who are volunteering their time to review these, because even though some of them don't seem as severe as others, this board is protecting the public and patients when we receive our health care.
Representative Awerkamp.
Thank you, Madam Chair. Hi. So there's been comments made that, you know, in each case, you look at, yes, they were late on their renewal, but also the investigative group looks at other aspects of that individual. And there's a long list of different elements that they look at. Of the 60 that the Board of Nursing took disciplinary action on for their late renewal, practicing without a license, how many of those 60 also received disciplinary action for an additional item? And the reason for the question is, if you're saying you're looking at other elements of that individual, what elements actually rise to the level of disciplinary action? Because if they're not rising to the level of disciplinary action, why are they being considered?
Yes.
Because if they're that bad that they're being considered and say, yes, this one was 3 days late, they get disciplinary action. This one was 3 days late, they don't get disciplinary action, because the investigative committee's looking at different things. But those different things, do they actually get disciplinary action on those as well?
So to address what my prior statement was regarding, it is that the board may consider various factors connected to the unlicensed practice other than just the number of days. So what kind of practice they were engaging in, did they continue to practice after they knew they didn't have a license? Did they take accountability? Why did they practice without a license? All of those facts would be, but it would come from the violation of the unlicensed practice and not connected to another violation. Now, there are times in which other issues come up because they're reviewing an application, and I don't know the numbers based on the 60 that disciplinary action was pursued. If there was additional violations pled, it's possible. When applications are reviewed, many things are reviewed, including most commonly criminal history would probably be the most frequent issue that comes up with an application. And largely, again, that's because of nurse licensure compact requirements that you can't have a felony and have a multi-state license. So that could be one issue that's looked at, and those factors I was referring to was regarding what would take in consider of the violation of unlicensed practice. It is not only the number of days, it's also the other facts related to that unlicensed practice that would be considered. Does that answer your question?
Mostly. Thank you.
Thank you. Thank you, Representative.
Okay, I do realize we're going a little long. We're going to go till 12:30, and then we will break for lunch. So Representative Sutton.
Thank you, Madam Chair. Always happy to stand between the committee and lunch. It's fantastic. As I look at this, the renewed, not renewed, disciplinary action, not disciplinary action, from what we have, it appears kind of arbitrary. And I don't have enough faith in humanity to believe in arbitrary, all right? So what I'm looking for is some sort of a rubric that is put together for the apparently one person that makes the decision as to whether or not this goes toward disciplinary action. And that one person isn't always the same person. I don't know if it's a jump ball or musical chairs or how that's determined, but it's not always the same person. So I would have to think that there's some sort of a rubric used so that different people sitting in that chair would have the same procedures in making their determination. And one of the things that you mentioned, that's my question, but let me also tie in here. One of the phrases you used a little bit earlier was past behavior. That scares the heck out of me. How is that measured? What are we talking about here?
Yeah, I'll address that first if that's okay, and then I'll
Sure.
go back to procedure. So first, past behavior, what I was referencing as prior disciplinary actions by the Board of Nursing. Was this the first time they have had an action for failing to practice without a valid license? Have they had other similar actions in the past? But they would be final disciplinary actions by the board. It would be what that consideration is. And so again, they're going through the flow chart. They're aware of those past. It could be maybe past actions by another licensing board. If they, with the compact, we have nurses who their primary state of residence changes. So maybe Missouri Board of Nursing has previously taken an action. They have, had issues with applications before, not disclosing information. Just in general, those kind of information would be what I was referencing with that statement. Right. On the chart, so first I would like to point back to the action plan that Carol presented earlier. The board has directed staff to gather more information on how other state agencies and how other boards of nursing are handling unlicensed practice. They've heard your feedback, your concerns, and that one board member is delegated this authority. And so they will be reviewing a possible internal policy that would provide direction from the full 11 or the full amount of board members to provide maximums and guidelines to the one member who's making these kind of outcomes. So moving forward, that is the intent is to have, the board is mostly made up of nurses. The chairperson is that makes these decisions is often a nurse, but to have more voices in that discussion on how they move forward with those cases.
Okay, so just to sum up, there wasn't a rubric, but we're going to put one in.
Well, I believe the investigative committee chairperson receives a selection of training when they take the role, of which they may receive some historical data on how previous chairs have made decisions. But they would review each case on an individual capacity and then review it based on, potentially past actions and what has happened in historically. But again, a factual-based determination on the evidence before them would ultimately make the decision of a case, just so that each case is reviewed on its individual merits.
All right, I'd feel a lot more comfortable with some standardized procedure. Yes. Historical may not be the way to go currently.
Which the board has heard your feedback, and they are looking at how other agencies do it, how other states do it, and are going to discuss it as a whole board rather than a single member being delegated just that decision and giving some direction. I'm sure the committee chair would also like that. So they have direction from the full board in those decisions.
Very good.
Thank you.
Rachel, I'm
Thank
going to
you,
let
Representative.
you have a rest moment because in these last few minutes, I know the Sydney is the other attorney for the AG. Is Sydney still here?
I'm sorry, it appears that she has already left for the day.
Oh, I thought she was here until 12:30.
I'm sorry, noon. She had to leave at noon today.
Okay. So I guess I would just then, I'll just send the question to you then. We see that Sydney had 88 consent agreements that she signed. This is on page 152. And that's quite a lot out of the 100. And it's interesting because we have 100 consent agreements, but we were told that 40 of them had no findings, so I guess the consent agreement is just a no finding, and you can mention that. But just very specifically on page 27 and 28, our committee asked the board to review the cases that were not ongoing and provide us what, basically their opinion on whether or not these were fair outcomes. We wanted them to review these cases. We also asked which board member was part of the disciplinary council. And since we've learned that oftentimes it's one individual, could you please address on page 27 who was on that disciplinary council or that one member for Anna Ahrens?
It appears, based on the information provided, again, I did not represent the board in that case, and so I cannot talk specifics regarding it. But based on the information, the case was through Investigative Committee Chair Juliana Resick. And that is under the first paragraph on page 20, or the first paragraph of that section on page 26.
Okay. Thank you. And then for the John Coslett on page 28, it went to the administrative law judge on that particular item. So was there a board member that reviewed it before it went to the administrative law judge? And if so, who was that?
Yes, it would have gone to a board member. Unfortunately, because of the age of that case, I did try to review it to see if I could find that information. We can do further review, but based on the information I have available to me, as of right now, the only information I had was within the agreed order that was, I believe, provided in the prior committee meeting.
All right, thank you, I appreciate that. All right, committee, we have 10 minutes that we'll be able to ask either further questions of Sydney or, sorry, not Sydney, Rachel, or Carol. We will give Carol and board members an opportunity at 2:30 as well to provide more comments, for more opportunity for questions, and also for closing comments. But I would like to make to the committee for any questions. Okay, are there any final comments that you'd like to provide? Doesn't have to be a final comment, but anything before we close.
I believe I covered most of the questions. If anything has not been specifically handled, please let me know. We can answer it in the afternoon after you've had kind of a chance to look through your questions or through follow-up if you guys would need any additional information.
All right, that sounds good. We appreciate that. So Carol, we will give you an opportunity this afternoon to keep going and to ask further questions. Committee, it is 12:21, and so we will do our very best to start at 1:30 and give everybody 1 hour. And so do your very best to eat quickly and return. So we will go ahead and part ways right now. And I will go ahead and call our meeting to order. Again, we have a full agenda for this afternoon, so we are going to move right into public testimony. For our public testimony, we have quite a few individuals that will be providing testimony. We will strictly be holding you to no more than 5 minutes per person. Vice Chair Lewis will just hold his phone up at a minute so you kind of know that you need to wrap up. We want you to feel comfortable sharing your testimony. You do not, of course, you are not required to read it. If you would rather just speak to us casually, that's actually preferred. And we will hold all questions until the end, so please stay close. If you're providing testimony, maybe sit on the first and second row so that when someone does call for a question, just please identify which individual you would like to ask first. So we'll first begin with Amy Seipel, and welcome back to our committee.
Thank you. Madam Chair and committee members, thank you for holding this hearing and allowing us the opportunity to testify. As you know, I was taken to court by the Kansas State Board of Nursing on August the 5th. The judge's decision is still pending. Now, it has been implied that those of us who deserve the red scarlet letter of public shaming somehow have histories that warrant that. I have never been sued. I have never had any complaints filed against me. Many people in this room were at my trial. Whatever the Board of Nursing had against me, they definitely tried to bring forward. Now, you heard Rachel say that 100% of people sign the consent agreements. Let me tell you why. If the judge rules in my favor, the Board of Nursing can still bring action against my license. They also have the option of waiting 3, 4, 5, however long they want, years, and resurrecting my case when the public pressure has been brought down. Furthermore, if the judge rules against me, they'll be sending me a bill for all of their court costs to take me to court. Why don't you think anyone avoids signing the consent agreements? And it gets worse. My attorney told me he thought what was happening was unjust, but he encouraged me to sign the consent agreement because he said the fallout is considerable. If my license is revoked, I'll be added to the Office of Inspector General report. At that point, I wouldn't be able to be licensed for anything else in the state of Kansas. I couldn't sell insurance or be a real estate agent even. Furthermore, I would be flagged on all background checks. I might not even be able to volunteer in a church nursery. My attorney said, you can fight them and you can become the sacrificial lamb, and maybe you will be able to help affect change for the next generation, but the cost may be considerable. So I come before you asking, do not let my efforts and the efforts of my colleagues be in vain. We are here at great personal risk because we are trying to represent the next generation of nurses like Madeline here. This legislature is one of the last hopes that we have. Now, I still believe, I humbly believe that nurses should be regulated by nurses. There are 77,000 of us. And nursing leaders have come together, and we have talked about how we can create a just and transparent culture within the Board of Nursing. We've been working with Representative Pickert. We put together ideas and recommendations. However, I firmly believe they will not be manifested without your intervention and influence. I want to thank you for representing the 77,000 nurses in Kansas. And I do want to tell you too, for every one person that comes up and speaks to you today, there are a dozen more who are too afraid. We received calls every day since that committee hearing in July. I received calls from nurses all over the heartland telling me their stories, and nurses are really good at keeping data. So whenever they would send me their stories, and Representative Pickert did the same thing, we would ask them to submit data to us too. We wanted to make sure we weren't dealing with some terrible criminal like they have implied. But I want to thank you for representing the nurses and the patients that we serve. Our patients need us. They need us to get back to work. Thank you.
Thank you, Amy. Next, we have Yolanda Griffey, APRN. Welcome.
Hi. I want to thank you, Madam Secretary, and all you representatives for letting me come and talk to you today. First of all, my name is Ilonda. So if you think of your I, that's how you say my name, Ilonda. I have been a licensed nurse. I've been a nurse in Kansas for 55 years. I have been a licensed nurse with the Kansas State Board of Nursing for 47 of those 55 years. The last 14 years, I have worked my way up to being an advanced practice nurse practitioner. And I worked for the last 10 years at McConnell Air Force Base near Wichita, Kansas. I experienced this problem renewing my APRN license back in July of 2023. We were in a mess in our country nationally. We were very busy at the base deploying soldiers, and that's what I did. I worked in deployment health and in making sure they had the right medications that they needed if they were exposed to chemical warfare. And that requires, you have to have a license to prescribe. You also have to have a DEA number. It came towards the end of July, and I said, oh my gosh, I got to renew my license. I renewed my license on July 31st. That was the last day. I could not get my APRN license to go through. I hit it 4 times, and it would not go through. I said, well, maybe I need to do the RN first. So I did the RN. It went through. So I went back to do the APRN, and it would not go through. But I thought, well, they're charging me the same amount of money on my credit card. Maybe it went through, and I didn't know. So I just, made one last attempt, and that was the end, because I had completed my required continuing education hours. I had my malpractice insurance. I had everything the state board had required me to have. I continued to work as an APRN for McConnell Air Force Base. I was not notified by the Kansas State Board of Nursing that my license didn't go through for my APRN. I was not notified by the Air Force Credentialing Committee. I was not notified by my employer. I was a contract worker out there. I even renewed my DEA license in September. I don't know how it went through and not have that license at the Kansas State Board of Nursing. My husband got sick in March. This was 8 months later. And I decided to leave the Air Force Base so I could be home with him and get a part-time job, and had applied for veteran evaluation services because I love veterans. And they called me up and said, Alana, there's a problem with the Kansas State Board of Nursing. You need to give them a call. So I called them immediately, and of course I got an answering machine. And then I went online. I tried to get my APRN license to go through because I saw that it said it was inactive. And I finally sent an email, and I got an email back that said, we'll take a look at it. Meanwhile, keep applying. I did that for 2 weeks. I would go in every other day. And finally, I get a letter back from the Kansas State Board of Nursing that says, Alonda, for some reason, it doesn't look like you've even tried to renew your license. And I said, but I have. So I went back in, and that day, which was about the 17th of April, it went through. So I told him, I said, now I know if I was in your shoes, you would want me to prove my continuing education. I said, I have everything already here to send to you. I sent that all in to the board to prove they had my hours. I sent, my malpractice insurance. And then I get a call back, and she says, we have to launch an investigation. So that goes to another person at Kansas State Board of Nursing. And on the 27th, I hadn't heard anything, so I got a hold of him, and I said, how about my license? And he says, well, it looks like you're all ready to go. We're going to activate your license. I'm going to submit it to the committee. And by the 27th of, or by the end of April, I had an active license. I didn't know anything else was going on. I received a letter in December that said that I was being reported to 3 boards across the United States for unprofessional conduct because I worked as an APRN for 8 months without a license. And I said, I can't believe this. So that's my story. I'm still an APRN today. I made sure my license went through this year. It went through without any difficulty. But I work for part-time for a company that does in-home assessments for people I go into their homes. So I want to thank you for letting me speak. I hope I gave you enough information that you can take my testimony with you. Thank you.
Thank you, Ilonda. We appreciate your testimony. We do have Representative Ballard with her hand up. However, we're not taking questions right now. Representative Ballard, is this something unrelated to the conferees?
No, it's probably a mistake because I didn't mean to have it up. Thank you.
Okay. Well, it's good to know that you're still there.
Well,
All
I'm
right.
on my computer now. I was on my phone this morning.
Okay, great. Next committee, we have Shannon Gregg, APRN.
First, I want to thank Madam Chair and the committee members for the opportunity to testify today. Obviously, my name is Shannon Gregg. I've been a nurse and nurse practitioner for over 25 years, with the last 14 years being an APRN in a clinic. In 2021, I received a letter from the Kansas State Board of Nursing about a complaint that a patient had filed against me. And that an investigation would be brought up and I would be notified as to what that investigation showed. It wasn't until March of 2025 when I finally received a letter stating that they were finally looking into and beginning the investigation. You can imagine 4 years later, personally, I kind of thought that it had gone away. I thought maybe no news is good news, waiting 4 years to hear back. I immediately called the risk management department at where I worked, and they helped guide me through this. It was very scary. I felt like nobody had my back unless it was the risk management department, which was not really their responsibility because they only investigate legal issues and not complaints, but yet still were able to help guide me through this, the investigation. So obviously, a nursing license, an investigation, this is our livelihood. This is how I make money for my family. This is how I live. So it was very scary. I have had 0 complaints. My file was completely empty. And when the investigator called, I was to call her back and set up a time so she could ask questions about the case. And again, this is 4 years later. Thank goodness I remembered what was going on because if not, I probably really would have been in a difficult position. Case management was there with me to witness the conversation. And at the end of the conversation, the investigator led me down the path saying, I really don't think this is anything. I've reviewed the case. There's no clear evidence of any misconduct whatsoever, but it would need to go to the board and they would make the final determination about where things would go, if there'd be any disciplinary action. So in June, I received a letter stating their final decision. And I was really confused and angry about the letter that I received. I don't think you guys have a copy of the letter, but the title of the letter was Letter of Warning. And that in the body of the letter, it said, I may have engaged in conduct violating the Kansas Nurse Practice Act, and if there is similar conduct in the future, it may result in disciplinary action. First of all, there was 0 explanation about what my conduct was. I may have violated the Kansas Nurse Practice Act. How am I supposed to review the Kansas Nurse Practice Act when I don't even know what I did wrong? And that they would also keep my file open, and so I guess maybe they can look at it later on if some other patient or person files a complaint. And again, I come back to the same thing. I don't even know what I did wrong. What did I do wrong as a provider? And so anybody can just file a complaint, and then it puts my license possibly in jeopardy. So it was very scary. And I really find the whole process to be insulting, and as a profession, and to my coworkers and everybody. And the other thing that I really want to say real quick is I have 2 daughters. One is in pre-nursing at KU, and the other is completing her CNA at Washburn Tech right now. I walked into their room when I received that letter, and I looked at both my girls and I said, I really struggle with supporting you going into the profession in Kansas, because there is zero support for nurses and anybody in the field. So, any questions?
Thank you, Shannon, and we will take questions at the end, but we do appreciate your testimony. Next, we have Deborah Murphy, and she is an APRN and will be on WebEx. Okay, is she here? Okay, we'll come back to her. Representative Pickert, just let us know when she's on, or you guys let us know. Next, we have Michelle Dreiling, RN. She should be in person. Is Michelle here? No? Okay, I would just refer the committee to her testimony, and we'll set that aside. Next committee, we have Erin Harris. She should be on WebEx. Okay, good.
Can you hear me now? Can you hear me now?
Yes, we can.
Sorry, so sorry, and I am getting pulled over. I do apologize. I'm multitasking today. Madam Chair and committee members, please thank you for letting me provide my testimony today. My name is Erin Harris. I am a licensed RN in the state of Kansas. I've been licensed since February of 2006. This is my 19th year of service to the profession. I wanted to present in person for this hearing, but I'm unable to because I've exhausted all my paid time off resolving the issue that I will elaborate on concerning the Kansas State Board of Nursing and the manner in which they handled my RN reinstatement application. I would like to preface with, I've never forgotten before this year to renew my license. On the morning of June 9th of this year, I was getting ready for work, running things through my brain, what I had to do that day at home and with my patients. In a moment, I realized that I was missing something, that all of a sudden, like it just popped into my brain. Oh my gosh, I forgot to renew my nursing license. And it was due on May 31st, 9 days prior. I immediately checked the Kansas State Board of Nursing website. I was not surprised to see that my license had lapsed. I called the KSBN right away the morning of June 9th when I realized what I had done. At this time, I was told by Barbara Bigger, who is an administrative assistant, I believe, that all I needed to do was fill out the reinstatement application, pay the fee, and turn in my continuing education hours. The task was completed that day, and I paid the $150 reinstatement fee. I was told that my application would have to be assigned to an investigator. I informed my supervisor at work and stopped performing nursing duties and functions that day. During this time, I was nervous but confident that this would be resolved in a timely manner. I have worked with other nurses that this has happened to, and it seemed that they were reinstated within a week or so. I inquired about getting a temporary license and told that was not possible until I reinstated. On June 11th, Evan Faulkner, who was listed as Senior Special Investigator, contacted me through email. He let me know that he was reviewing the case and had questions that I needed to answer. This included if I had been working during the time of June 1 through June 9, what delayed me renewing my nursing license on time, and my supervisor's name and number. I answered the questions honestly and promptly that same day. I let him know that I did work those days. It was not intentional. I had just realized on June 9th that I had forgotten to renew. I let him know that I didn't have a great excuse for forgetting other than I forgot. I didn't think that he wanted my full story of how stressful work is. I work full time. I'm a full-time mother. I have family with health concerns. I simply took responsibility for forgetting. I provided my supervisor's name and number and expressed that they had been notified already and they would be expecting a call from the KSBN. Evan quickly replied and stated in an email, I won't need to contact your supervisors. He let me know that they had to take my application to the board member on June 12th, which was the next day, to review the application for approval to reinstate my license. I thanked him for all his help on the situation, and at this time was continued to be hopeful that the issue would be resolved by the end of the week. On June 12th at 11:49 in the morning, I emailed Evan to check with him regarding this process. I asked him if I should be checking the licensing page daily or if someone would contact me. I expressed my want and need to get back to work as quickly as possible. I thanked him again for his help in the situation. At 12:53, he emailed right back and let me know the meeting with the board member was that morning and they decided that the reinstatement application needed to be sent to legal counsel for further review. He told me that legal counsel would be in touch with me once they had my application. I thanked him again for all of his help. I asked him for a time frame for this process. I asked him if this was a normal part of the process to be sent to legal counsel or what the reasonings were for moving forward to this step. I expressed that I was unfamiliar with their processes and sought reassurance that this was part of their normal process. I also expressed to him that the term legal counsel was concerning to me and even asked if I should obtain legal counsel myself. Evan responded the same day and said this is part of the normal process. I thanked him again for his reassurance. On June 16th, 4 days later, I had not heard anything from legal counsel. I emailed Evan and asked if there was a time frame to be expected for legal counsel to reach out, letting him know that I had not heard from them, expressed my need and want to get back to work again. And he just expressed that my application was with legal counsel and he did not have a time frame. I also asked him for a number for legal counsel, which he did not provide. I did not receive any additional email responses from Evan after this date, and I felt in my heart that maybe they were upset with me for asking so many questions or maybe being too pushy. I didn't send another email until June 20th. I expressed to him at this time that the process seems longer than normal. This is the 9th day since the case was opened. I had still not heard from legal counsel. I asked for feedback on timelines again and thanked him for his help. There was no reply. On the evening of that same day, I received my personal mail at home about 4 p.m. and there was a letter from the KSBN. The letter was dated June 16th. It was to notify me in writing that all future contact with KSBN about the case must be with the legal counsel and not the investigator. The words must and not were underlined to draw importance. In this letter, it did give me the number to contact legal counsel, which Evan couldn't seem to give to me, requested previously via email more than once. It was signed Evan Faulkner. I called the number provided and was told that it was waiting to be assigned to a legal counsel member. The application was given to legal counsel on June 12th, 8 days prior. I called them again on the 24th. My application had still not been assigned. Still could not get any timelines for processes. We're now 14 days in from when I originally filed my reinstatement application. No timelines, no end date, no end point for any of this.
Erin, hold on. Erin,
yes.
hold on 1 second. You're doing great and you're in a car and that's stressful and that's hard and we definitely appreciate it. Because of time, I'm going to ask you to summarize and move to your last few paragraphs. And then because you're in your car, we're going to go ahead and take questions now so you do not have to stay tuned in. How about that?
Okay, so bottom line is, I kept getting this runaround for several days, several weeks, actually. It ended up being 6 weeks. I ended up getting a lawyer. I was put on unpaid leave from my job while this was getting sorted out. It was about $7,400 in monies lost from just being paid and from lawyers' fees. And 6 weeks into it, My boss actually emailed me and said, "Hey, did you know your license is turning up active?" So they did not try to call me, contact me. I wasn't even mad that it got put over to legal counsel because, in fact, I did practice for 9 days without a license technically. But there was no other investigation into this process that I am aware of. And randomly 6 weeks later, my reinstatement came just before the last meeting that you all had at the end of July. And I'm just wondering, would it have been reinstated had all of this attention not been brought forth to the KSBN about what's going on over there? It was a hard process. I could have been let go from my job. My patients suffered. I'm a hospice nurse. Nobody's breaking down doors to try to be a hospice nurse every day. My main goal is to see change in the Kansas State Board of Nursing. It should not have taken 6 weeks for somebody to decide that this was an accident and there was no harm here. And so I'm just bringing forth my testimony to hopefully create change in the way their processes are run over at the Kansas State Board of Nursing.
Thank you, Erin. And I can just say from my personal perspective, I'm actually horrified that this has happened to you. 9 days should not equal 6 weeks of not being able to work and not being able to be paid, and have those that are on hospice not have your services. So from my perspective, I am so very sorry. We will take any questions that the committee may have for her since she is on WebEx. I think she's endured
I
quite enough.
appreciate it. Thank you.
Okay, it looks like, yes, one question. Representative Tarwater.
Thank you, Madam Chair. Aaron, thanks for being here today, and thanks for sharing your story. It's kind of in line with what we heard last time. So were you given an opportunity when they were making their decision? Were you given the opportunity to be represented at the board meeting?
No.
And then at the end of the day, when it was finally reinstated, you said they didn't contact you, they just reinstated it?
I found out through my boss because my coworkers and my boss, they were all checking the thing daily. I actually found out from my boss that it had been reinstated, and we were actually out of town. And when we got back in town, there was a letter in the mail basically stating that I may have violated the Nurse Practice Act and that my license is active now, but they could reopen the case at any time. That's how I was told that my license was reinstated.
And did you have to sign any document, like we've been talking about, the guilty document?
Thankfully, no. Thankfully, no, that did not end up being something that happened. But I wonder, like I said, if all of this had not come about during this time, I almost wonder if I would even have my nursing license yet. If all of this attention hadn't been brought down as to what is kind of going on over there. Because I agree, it was 9 days and there was no risk and there was no reason for me to have to go without my license for 6 weeks.
Okay, so Madam Chair, I'd like to make sure that we stay in contact with her to make sure that since they left it open, that she's not punished for being here today.
I appreciate that too.
Thank you.
Yes, we will follow up, and we also encourage you to stay tuned to the entire proceedings at your convenience. We do have 2 more representatives that have questions for you. First, we'll go with Representative Awerkamp, and then online we have Representative Ballard.
Thank you, Madam Chair. Hi, Aaron. So just to verify, so during those 6 weeks, were you ever contacted with regards to a timeline so you could have some expectation? And I think I know the answer to this was all the costs you incurred. Was the Kansas Board of Nursing, did they ever offer any form of compensation for your lost time or for your attorney fees?
There was never any, they never offered to give me any compensation for the lost time. They never offered to give me any compensation for the attorney fees. And I'm sorry, repeat your first question again.
First question, did they ever talk to you about a timeline so you could have some expectation as to when you would have an answer?
No, and I emailed several times to Evan Faulkner, who I thought I was supposed to be communicating with, and several times was told, no, there is no timeline. And they couldn't give me any type of timeline. So as far as I knew, I wasn't going to have a job for forever, especially after I found out kind of what had been happening. And I asked several times for a timeline,
Right,
which I think I've mapped out in that written testimony. Hopefully you have a copy of that.
Yes, I do. I was just verifying. Thanks, Aaron. Thank you, Madam Chair.
Yep.
All right, we do have one more question. Representative Ballard. Representative Ballard.
I think she's on mute, maybe.
I'm unmute.
You're good.
What was his title and who did he tell you he was when he called you?
He didn't call me. Number one, I've never spoke to Evan on the phone ever. It was through email, and he was listed as Senior Special Investigator.
That you only relate to him through email, telephone, but never written?
Through email, yes, and I have all the emails.
Email, okay. That just struck me as interesting because most of your talking about your renewal was through him, and he assured you on numerous times that this was a procedure, everything was sort of okay, but you had to make the initiative. Am I correct?
Correct. I asked for a phone number, a contact for legal counsel at least a couple of different times. He never provided me with that until he sent me the letter basically asking me not to contact him anymore. So yeah, it was all through email. I did try to call a couple of times, and I spoke with Barbara Bigger a couple of times and tried to figure out a timeline from her, and she couldn't give me any information. But all of my correspondence with Evan was through email.
Thank you, Ms. Harris. I'm awfully sorry you had to go through this. Thank you, Madam Chair.
Oh, that's okay.
Representative Sutton.
Thank you, Madam Chair. I just wanted to clarify there. Did I just hear you say that this senior investigator, before any judgment was communicated to you, told you not to contact him anymore? Did I hear that correctly?
Through a letter? Yes, he sent me a letter in the mail, and I think it's in my written testimony there. I don't remember the day right offhand without looking at it, but I got a letter in the mail, and it said that you must not contact the investigator. Must and not were underlined to draw importance. And then in that letter, I finally got the number for legal counsel, which I had asked for through email several times previously as well.
Fantastic. Excellent. Thank you, Madam Chair.
And just one more question again. You did not sign a consent agreement, correct?
I was not made to sign a consent agreement. No, thankfully.
Okay, and I will just note for the committee that one of the common items on the consent agreement is the applicant waives all time limits under the Kansas Administrative Procedure. So there is no speedy trial, if you will. If you would have signed it, you wouldn't have necessarily expedited the process. Perhaps, but perhaps not. Okay, well, thank you so much, Aaron. We hope you have a really blessed day. We hope you will stay in touch with us, and hopefully many good things will come in the future.
Yeah, thank you so much. I appreciate your time.
All right, thank you. Committee, we're going to move back to, let's see, Deborah Murphy, who is now on WebEx. Deborah, welcome.
Thank you.
Deborah, you do have about a 5-minute, and so just try to watch your time. We will go ahead and ask questions after directly to you since you're online.
Okay. My story started in June of 2018 when I received a letter from the board saying I had violated the Nurse Practice Act. I am a nurse practitioner. I specialize in psychiatry. I had seen a patient that was seen by a colleague of mine before she left the practice, and I had seen this patient once. They asked me to send the records, and they didn't provide me with a proper release of information. And psychiatric records are protected. I hired my attorney to take care of it, and he did all of the correspondence with the board. I felt like that protected me to some degree because the letter was rather threatening. It took a long time to resolve. It was September of that year that I finally got a letter back from the board. The thing that really kind of bothered me was I was not exonerated. What I got back from the board was that they had decided to inactivate the case and that it could be reopened in the event of future incidents being reported to the KSBN. That made me feel rather paranoid. There's not a lot of us doing psychiatry. Psychiatric patients often have a complaint. So I was just a little bit worried. I guess I expected to be exonerated. The other thing that kind of was unusual was the investigator was an LPN, not an ARNP like I am. And I felt like maybe that would have been a better choice if that had an investigator that was actually a peer and not someone that was a licensed practical nurse with, I don't think, any psychiatric background. So that was my concern.
Thank you, Deborah. Committee, are there any questions? We appreciate your, yes, Vice Chair.
Real quick, we've heard about warning letters in the course of the hearing. Is that what you got, a warning letter?
No, it was actually a letter that said that I was being investigated, not just warned. And that I called the investigator at the office to discuss this.
Okay. But the investigation at some point was closed, do I understand?
It was not closed. It
Oh.
was inactivated, meaning that they could come back on me at any time if they got any further complaints to the board.
I see. So it didn't say on the top or it didn't indicate that it was a quote warning letter. It just said, we'll kind of leave this in limbo.
Right. It is an investigation and I have a case number.
Right. Thank you.
All right, thank you, Deborah. We appreciate your time. Hope you have a great day.
You too.
Committee, next we have Taryn Durman. If I said that correctly, RN, welcome.
Thank you. Madam Chair, committee members, thank you for the opportunity to testify in this committee hearing. My name is Taryn Durman, and I have been a registered nurse in Kansas for nearly 10 years. The majority of that experience has been in the emergency department in the last 3 years, working in administration, including nurse manager and nursing supervisor. I have always been in good standing as a nurse. I've consistently renewed my license on time, paid my dues, and maintained continuing education hours. On June 5th, 2024, I was working as a nursing supervisor at Providence Medical Center. I was PRN, or as needed status. Prior to June, my last shift at Providence was on April 24th. On June 5th, while walking to a meeting, I was stopped in the hallway by my boss, Juliana Reischik. I was told by her that I would be terminated since I did not attend a mandatory class. I was completely shocked and blindsided by this conversation. We were in a public place surrounded by our peers. I was taken off guard and embarrassed to be having this conversation out in the open. I told her I was confused. I didn't understand why I was being terminated. I told her I was not informed of this course, as I am PRN and my last shift was over 6 weeks ago, prior to these mandatory classes taking place in May. I asked her about a makeup class. She told me that makeup classes had already passed and there's nothing else I could do. She then told me that we could discuss this further after the meeting. After the meeting, I went up to Juliana and clarified what she had told me in the hallway. She told me again that I would be terminated and there's no makeup classes. I asked if there was anything I could do and she told me no, that I would hear from HR the following day. I then became emotional and informed her that I would not be able to continue my shift as a supervisor for the remainder of the day. It was 2:30 at this point and my shift ended at 7 p.m. I asked her to be excused and she refused. She expected me to continue my shift even though she had just told me I was being fired. I was emotionally distraught and asked for clarification. as why I was being terminated unfairly for a class I was never made aware of. Juliana told me again I could not leave. I asked her multiple times to be excused, and she refused. I then proceeded to tell her that I could not fulfill my shift, and I proceeded to give Juliana a handoff report. She told me that what I was doing was patient abandonment, and it was reportable against my nursing license. I told her that it was not patient abandonment, as I was working in an administrative role and had no patients in my care. She then told me it was job abandonment, and that was reportable against my license. Then Juliana states, "You don't want to do this, Taryn. I'm the president of the Kansas State Board of Nursing. This is job abandonment and reportable. I can show you the Kansas Nurse Practice Act." Unbeknownst to me, my boss and CNO at Providence was the president of the Kansas State Board of Nursing. She used her position with the board to threaten me into staying and to continue to work under distress. I then told her I felt threatened by her and I cannot continue my shift due to emotional distress. She continued to threaten me. "You don't want to do this. This is reportable." I turned around and walked away. As I returned upstairs to the staffing office to collect my personal items, on my way out of the office, I ran into Juliana. She asked to talk to me. We got onto the elevator. We took this down to the first floor where I attempted to leave. Juliana continued to threaten me in the elevator. "You don't want to do this. This is reportable." She repeated this to me multiple times as I continued to beg her to let me leave. I asked her again what I could do to save my employment, and she simply stated, "You'll be hearing from HR." Juliana was physically blocking me in the elevator in an attempt to intimidate me and refused to let me leave. I had to ask her multiple times to let me off of the elevator, as she continued to let the elevator ride up and down floors during this heated discussion. I felt trapped and just wanted off the elevator. I again told her I'd already handed a report off to her, and I was too emotional to continue my shift. I informed her that I felt threatened by her, and she continued to mention how my actions would be reported to the nursing board. I then offered to stay while she found me a replacement. She informed me my replacement will be here at 7 p.m. I again told her I cannot stay for the remainder of my shift and would be leaving. She then asked for my badge. I handed it to her, and she told me to leave. I left without further issues. Juliana, on many occasions, has used tactics of intimidation and threats as a way to control her staff. Nurses, including nurse managers and supervisors, are in fear of their license due to her position with the board. Nurses should feel supported by their leaders and not be put into compromising positions. It is disappointing to know that the president of my state board of nursing acts in this manner to her nursing staff and would jeopardize another nurse's license and livelihood. In my years as a nurse, I have never had anyone personally attack me or threaten my license. For it to be my boss and president of the state board of nursing is shocking and embarrassing. I expect more out of a board member of KSBN. Juliana no longer serves as the president, but from December of 2024 to July of this year, she has been serving as the investigation committee chair. Someone who has had multiple complaints against their professional conduct is allowed to not only remain with the board, but now be the chair of the investigation committee. I asked this committee to investigate the Kansas State Board of Nursing to ensure its members are held accountable. No nurse should fear retaliation or threats to their license from those charged with protecting our profession. It's been 15 months and my case is still under review by the assistant district attorney. I'm at risk of being labeled as unprofessional for the rest of my career. I've given the board investigators my side of the story, as well as names of other nurses in which Juliana has threatened. In June of last year, I reported Juliana for unprofessional conduct to Carol Moreland. But those accusations were investigated and quickly dropped, and Juliana remained with the board. If anyone should be labeled as having unprofessional conduct, it's Juliana and any board member who allows this behavior to continue. I encourage the state to investigate KSBN and its members. I fear there is corruption at multiple levels within the board. How is someone who has had multiple complaints against them the chair of the investigation committee? I am just the tip of the iceberg of a long list of nurses who have experienced threats and unethical treatment by the former president. These nurses live in fear of the power she holds and don't want to risk coming forward in fear of retaliation to be put in the position that I am today. That's it. I did provide a timeline. Hopefully you guys have it. It has like all of my letters. So if you have any questions at the end, please let me know.
All right, thank you, Taryn, for sharing your testimony. Committee, next we have Stephanie Smith, who is also WebEx. Sure. Stephanie, are you with us? You are on. If you just unmute yourself. Hello, Stephanie. It's sometimes hard when you're at home and you're listening. What we can do is she's having mic issues. Okay, we'll give you just a little bit here. Sure. Stephanie, what we'll do is IT will give you a call and see if we can figure out what's the technical difficulty, and we will come back to you. Next, we have Katie Meg. Welcome.
Can we skip to Mike, Shauna, and then have Aaron go before Katie?
Sure, we can do that. Mike, Schamer, come on up. And just give our committee just a minute to find your testimony. We're hopping around a little bit. Just a 1 second. All right, you may proceed.
Okay, good afternoon, everybody. My name's Michael Schomer, and I'm not a nurse. I am a proud father of a now 23-year-old son named Connor. My son's had a great deal of psychiatric problems. Starting in grade school where he got picked on and bullied a lot. Children can really be mean to those a little bit different from them. Connor was shy, quiet, withdrawn, and it continued to get worse in high school. After graduation, we'd taken him to several doctors and tried many meds, and eventually was diagnosed as being on the spectrum as autistic. Eventually, while suffering from what was also diagnosed as a severe depression, we experienced every parent's worst nightmare. This was the first of 2 of Connor's suicide attempts. Thankfully, through the grace of God and expert medical team at Wesley Medical Center, he escaped death by the thinnest of margins. We doubled our efforts to seek psychiatric help for Connor, but Kansas seriously lacks in that area, as do many states. Connor went on to show some improvement and acquired 2 different jobs, both of which he worked at for 2 years, and I don't think missed a day at either one of them. At the same time, he was taking night classes and secured an associate's degree. We began to become cautiously optimistic at this point, all the while being very responsible with his prescription meds by locking him up, as that's the method that he used to on his first suicide attempt. He used a blood pressure med. On December 27th for 2023, for reasons we're still not sure of, he went into full-blown psychosis, and we didn't know what to do. He was talking to people that weren't there, thinking the FBI's listening to him through the TV, and just full-blown paranoia. So I took him to the ER St. Francis. They had no idea what to do, but promptly admitted him to we believe St. Joe's psychiatric wing. We didn't know for 10 days exactly where he was. Since he wasn't a minor, they wouldn't tell us where he was. So finally we tracked him down, and they admitted he was there. First they said he wasn't even in the system, and then they finally told us he was there. And the care he received there was little more than a bed for 30 days. On the 10th day, they finally let us see him, and they had had a COVID outbreak, so his meals were in paper sacks on the floor. They didn't even see if he was alive in the room. I mean, they didn't see if he was eating or anything. Anyway, that was 30 days. They milked the insurance for all that was worth, and then they kicked him out the door. So 12 hours after his release, here we are again chasing an ambulance to the hospital. He'd taken an entire bottle of Tylenol and aspirin. He couldn't get any prescription meds because we locked those up. So once again, through the grace of God and Wesley Medical Center, they saved his life again. He coded for 3 minutes this time, but you know, here's the thing again, at the end of that, they still had no nothing to offer, no advice as to where to go from there. Bring him back 20 times and we'll save his life, but we don't know where to tell you take him from here. And it's really frustrating. But anyway, we ended up taking him to a hospital in Arizona, and that was $9,000 a month after insurance. That was out of pocket. And he came back worse than when we took him out there, honestly. So finally, we came across a nurse practitioner, Anna Ahrens, who's here today. And she somehow or another, I don't know, by accident or by design, came across the perfect formula of medications and treatment. And about the third or fourth visit, I was on the way home from his office with her, and it was like a switch flipped. He was right back as if it had never happened. It was unbelievable. So, you know, we really couldn't believe it. I mean, we found somebody that was not just looking for a paycheck, but really did care about people. You know, she has a unique, no-nonsense, stern yet compassionate method of getting his attention. And he would look her in the eye and respond to the questions she was asking him. She held him accountable for what he was doing and, you know, started to get through to him. So he got a job again, and everything was going good. And then the unthinkable happened. Her license got revoked for prescribing his meds. And we're like, well, when do you think this is going to be resolved? How soon can you get this fixed? And we're like hoping he can hang on. We don't know how long. And should we find somebody else to prescribe him? Well, we don't know. And this went back and forth. And I kept checking with him. Are you okay? Are you okay? Well, he doesn't know if he's okay or not. He's, you know, he's borderline most of the time anyway. So it went about 2 weeks too far, unfortunately, and one day he got up and there he was walking through the house talking to the ceiling again for 8 hours nonstop. So anyway, this whole thing, the bottom line is this could have been so easily prevented. She double-clicked on the computer, for crying out loud. That's all that was wrong. I can't for the life of me understand how this got to this level with a simple antiquated system that first of all should have let her know that she double-clicked. I mean, that in itself is beyond me, but the bottom line is this could have been so easily prevented had this thing gotten resolved earlier, and thank God we still have him today and he's doing much better. But I'm still praying for Anna and the rest of these nurses that have come forward. I had no idea the magnitude of this situation. You know, this really has opened my eyes today as well, but thank you for allowing me the opportunity.
All right, thank you, Michael, and I'm so glad your son is doing well and that he made it, even though it was very challenging. I'm sorry for all your struggles. Committee, we're going to now go back to Stephanie Smith. There's a thunderstorm, so she's not able to go the traditional route, so we're going to connect via cell phone. Okay, he's making the phone call. Stephanie, welcome to our committee. We have you. We'll be able to hear you, and then we'll give you up to 5 minutes, and then questions will follow.
Okay, I'm so sorry. It's thunderstorming here, and I don't know if the Wi-Fi got taken out or what. I apologize. Madam Chair and committee members, thank you for letting me be here today to give my testimony. My name is Stephanie Smith, and I'm a fourth-generation nurse in the state of Kansas. I'm going to kind of just summarize a lot of this that I have written in my testimony. It's very long. I'll start. When I graduated high school, I knew I wanted to be a nurse also. I took a summer CNA course and obtained employment in pediatrics. When my friends were working in retail and restaurants, I was always so proud to be working in a hospital caring for children and their families with some of the greatest nurses and leaders I had ever seen. I knew nursing was my calling as well. I went to nursing school and I graduated in 2011. I worked multiple different jobs, labor and delivery, pediatrics, but I felt my calling was in hospice. I spent 5 years in hospice. I absolutely loved it. But in 2016, after being newly married, my husband and I suffered a miscarriage, and I had decided that I needed to back off from full-time work. My caseload was extremely heavy in hospice, and it was, I didn't feel like I was able to give my patients what they needed, and it was taking a toll on myself, both physically and emotionally. So I told the DON that I was working with at that time that I needed to step back and that I would help to transfer my patients to other nurses, and that I would go part-time or even possibly PRN and maybe take some on-call. She was very frustrated with that. She eventually told me that she was just going to find a different RN to take my position and that she was no longer going to need me. And I still decided to stay on and help to transfer the patients over to other nurses because, like I said, I'd had these patients for a long time. I cared about them and I cared about their continuum of care. The director was flagging all of my charting and sending it back to me after hours to quote fix. She also stated in an email, she also started to email me instead of our usual text message conversations. The emails had a clear shift in their tone and were very harsh, containing constant criticisms of me and how I was handling my patients and casework. After, let me go down here a little bit, this is a lot. After one particularly nasty conversation that we had in 2017, I told her that I was going to be resigning immediately. She told me that she would be turning me into the Kansas State Board of Nursing. I absolutely did not believe that she would do that, and I didn't think that there was anything that she could turn me into the Kansas State Board of Nursing for. So I just went on. I just said, okay, if that's what you need to do. Never did I imagine that that DON would report false allegations to the Kansas State Board of Nursing about me deferring patient medications for patients that I absolutely loved and cared for. I received a call from an LPN investigator with the board several weeks, possibly months, I don't remember, later. She had multiple patients and multiple different medications that seemed to have come up missing. She did not give me a chance to explain why I thought this complaint had come in or what had gone on. She simply was very accusatory. She made me feel as though I was guilty of something I knew I absolutely did not do. She did not care to hear my side of the situation. I told her at that time that I would need an attorney before I could speak with her any further. I'll never forget when she replied, "That's what I thought you'd say." And the phone call was ended. I was so confused, angry, but mostly sad and scared. I was directed to an attorney who took my case and began her own investigation. She was sure that she could help me, but she was honest that this was going to be a fight. She had a long history of cases involving KSBN and warned that this was going to be a very stressful experience. She immediately had me take a drug test, which I passed. She also had me complete a psychosocial and substance abuse assessment, which found that I had no signs, symptoms, or history of substance abuse disorders, including but not limited to alcohol or medications. I spent thousands and thousands of dollars, countless sleepless nights, and many hours attempting to clear my name and protect my nursing license that had meant so much to me. I told my attorney I was not going to be working during this process. Thankfully, I have an amazingly supportive husband, and I didn't, quote, have to be working.
Stephanie,
Part of why
Stephanie, apologies
Yes.
for interrupting. You are doing a wonderful job providing testimony. I know it's stressful. We're at a little over 5 minutes, so what I would recommend is just take a minute to wrap up and in your own words summarize your conclusive comments, and then we'll see if anybody has questions. We do have your full testimony, so be assured we will read it.
Okay, great. So my attorney basically told me that I don't have many of these cases go through that are successful, and I didn't have any reason to believe that I would be the first. So I decided with her assistant, she had told me that they had offered a consent, and if I participated in this KNAP program, that I could continue to have my nursing license. It would be completely unencumbered. I would have no disciplinary action against me. All I was going to do is pay some fines and complete this program. I agreed. I had been through so much and I just wanted it to end. So I did that. Little did I know that KNAP, I thought my nightmare was over. It was really just beginning with KNAP. You can read in my testimony about all of the different and horrible things that KNAP puts participants through, but in my own words, it's been a living nightmare. It's been completely stressful. It has been financially a hardship. It has it's been awful, and I don't wish that on anyone. It claims to be a therapeutic program for people who need help. And I thank God that I don't actually have some sort of substance abuse disorder or mental health problem, because if I did, this program itself would be enough to cause irreparable damage. I would hope that the board would take a look into this KNAP program. There's nothing therapeutic about it. It's completely punitive in nature, and it costs a lot of money, a lot of resources, and it needs to be reevaluated. Thank you.
Stephanie, thank you for sharing your heartbreaking story. Committee, what questions do you have for Stephanie? Representative Humphreys.
Thank you, Stephanie, for sharing your experience with us, and I'm just heartbroken over what you've been through. My question is, and I'm kind of in the middle of reading your testimony, so you may have said this in the written part, but how long is the KNAP program, and what exactly do you have to do, and when will you get out of the program? Or maybe you already are.
So yeah, I talk about that towards the end of my testimony. Let me just say right here, this part. KNAP is 3 years, 5 years. It could possibly be 1 year or 18 months. I've heard a lot of different things from a lot of different people. I'm currently at 2 years and 10 months. I pay $75 a month just to be in this monitoring program. I've submitted multiple, I believe it's at 4 now, substance abuse evaluations from different providers to them, all stating that I have absolutely no substance abuse problem history, mental health disorders, aging disorders, physical ailments, nothing. And I continue to be tested. I've been tested. I wake up at 5:15 to an alarm that alerts me to check my KNAP app every Monday through Friday. And I have to see if today is the day that I need to go drive 45 minutes across town to take a drug test and interrupt whatever it is that I've had going that day. And then when I do that, it's another $38 to the KNAP app and then $15 at the drug testing site. So monthly, at the bare minimum, I'm spending $128 just to be monitored. KNAP offers NA, AA, inpatient, outpatient, different types of therapies, but I haven't ever had an assessment that said you needed any kind of treatment. So KNAP said, well, we don't have anything for you like that. We're just going to monitor you. So all I do is literally just almost like a probation, or what I would think maybe like a parole would be like. I hope that answers your question.
You haven't been notified that, at the end of 3 years, you'll be finished with the program?
So it's complicated because there is a 6-month fee restriction, and I have not worked. I had a I had a child, my little girl, during this time, and then I had another little girl that passed away. And so I haven't worked during this time because it's just been, I've been being a stay-at-home mom and grieving. And so there's a 6-month key restriction, and I've told my case manager at KNAP that I don't plan to be working in the next 6 months, but I'm supposed to be off KNAP in about 4 to 5 months at this point. And a key restriction is where you are supposed to have a full-time job, and you're supposed to have another nurse that you're going to then have to put that person out to have them basically supervise you with a key.
Okay.
And your boss has to, yeah.
Yeah, so thank you. I mean, I just want to make sure I understand. You can't get off the program until you have been working for 6 months. Is that what I understand you to say?
That is something that I did not understand before I signed, but that is what I'm being told now. That's what I've been told for the last year and a half.
Okay. Do we
Is
have
that,
any
yes,
idea?
you can't.
Yeah. Okay. Thank you, Stephanie. Thank you for, I know it's hard, but we appreciate you sharing your story with
Yeah.
us.
Thank you so much.
Other questions, committee? I guess my only other question would be, so the complaint, as far as you know, there was only one complaint filed against you stating you were deferring medication from patients?
That's all I know of. My attorney was told that she she said that she didn't even know for sure what the complaint was. We didn't ever get anything. I had to write a letter to them addressing whatever I thought it could be based off of just the one conversation with the LPN. And so, no, I was never invited to a board meeting. I was never invited to a meeting with any representatives of KSBN and we tried. I tried multiple times. I wanted to know what this was, and I wanted to know how to address it. I adamantly denied any accusation that could have come my way in my attorney's letter back to them, but I have no idea, still to this very day, what exactly it was.
I am absolutely stunned that a Kansas State Board member would allow this, that reviewed this case, that would allow potentially one complaint to justify years of being part of a program that cost you up to $5,000. And in addition to that, have absolutely not even reasonable requirements to be reinstated. In addition, you have shown over and over that you have no drugs in your system, and that still cannot free you. So to me, in America, we get to face our accuser, and if it's one instance, and you don't even know if it's 1 or 2 or a date or a time, and
or 7 or 12, I have no idea. I don't know. All I know is that if what I think, I just can't even fathom. I don't know. And like I said, this has been nearly a decade now that I have been dealing with this in some capacity, some way, shape, or form.
yeah, definitely we're very sorry that there's not more transparency and accountability in this process, that you were not afforded the information that you needed to make the decisions that were necessary, and you didn't have any way to appeal.
No, none. And I know, I just want to really stress that I am somebody that I felt was important to speak up because my livelihood and my home and our finances don't depend on me working. And I know that's a luxury that a lot of nurses do not have. If I was a single mom, or if I was somebody who was contributing financially to our household, I can't imagine what those nurses go through. And I know there's so many of them, and they're just terrified to speak up because of the retaliation, or because of, heaven forbid you actually do seek help. Some of these nurses do need help. and they can't speak up and they can't get the help that they do need because of fear of being put in this program that they either can't afford or don't know how to be successful in. And it's awful.
So sorry. I'm so sorry. We can hear your grief on the phone, and we'd like you to stay in touch with us. We wish you the best.
Thank you so
Oh,
much.
I'm sorry, Stephanie. I think we do have one question for you. Representative Bergquist.
Yes, Stephanie, thank you very much for having the courage to give your testimony. I just have to say that I'm sure we all share the same feeling, but thank you for your heart for being a mom, and thanks for being a nurse, and thanks for caring about your family enough to strive through all this, and we hope you'll be in touch.
And we do
Thank
have
you,
one.
I will.
We do have one more. Vice Chair Lewis.
So from reading your testimony and listening, what I understand, and correct me if I'm wrong, is the first time that you were advised that by the Board of Nursing as to what their concern was, which was listing multiple different medications from multiple different patients that she had said had been reported
It
as
was,
missing. Excuse me. So that's the
yeah.
first time you had heard from the Board of Nursing that they were concerned about drugs missing, is that right?
Yes, yeah, but yes,
Okay. Yeah.
absolutely. And I just wanted to specify that when I say multiple names and multiple medications, what they did was they just listed out my entire caseload of patients and any medications over my entire time of having them on my caseload. It was things that just, it was all sorts of different things. It was not a, like, I think a lot of times we think of people feeling like opioids or something. I mean, it was like Pepsid, and I mean, there were opioids on there, but it was things that it was lactulose and just the most bizarre thing. So it
Mhm.
was, we put it together that it was just all my patients and all their meds.
Yeah, so, okay, so then going back to your employment, before you had your discussion with the Board of Nursing,
Sure.
you apparently weren't getting along with your boss, and then eventually you quit.
Yes.
In the course of your employment, was there ever an allegation that you had been taking medications from patients that you weren't supposed to?
No, no, never, no. And if there had been, I would have done everything in my power to alleviate any concern. I would have taken hair follicle tests, whatever they needed. Absolutely not. No, this was not until after, like I said, many months after I left. There had never been any kind of accusation like that of me. And I had never shown any kind of impairment at all. Never.
Right, so, just taking you at your word, and we haven't heard from the nursing board.
Sure. Yeah.
If I were the nursing board and I were investigating somebody for taking patients' medications, I would want to ask the employer if they had ever accused the nurse of doing that, and apparently they didn't in this
I would
instance,
think
because
so.
obviously that undermines the allegation in the first place.
Absolutely.
We have two final questions. We have Representative Ballard online, and then we'll end with Representative Tarwater. Thank you.
Okay.
Representative Ballard,
Can you hear me? I'm trying to get on.
you're on.
Thank you. Ms. Smith, wow, this is really perplexing. How much of this accusation is in writing to you?
About 3 sentences in 8 years, 3 sentences.
3 sentences. And
Yes.
you've been on this program 2 years and 2 months. Did I hear you correctly?
2 years and 10 months.
And 10 months. Does your insurance cover any of this at all?
Absolutely not. No. And this is paid on top of all my legal fees that I spent trying to even get to this point.
All right, that was my next question. You answered it as well. Madam Chair, thank you so much. This one is difficult.
Representative
Thank you,
Tarwater.
Ms. Smith.
Thank you, Madam Chair. Just when you think it couldn't get much worse, it certainly does. So it looks like we have an employee error that was retaliatory in nature because you wanted to cut back your hours because you had a family life. Who did you work for at the time? Who did this to you?
She was fired a few months after this happened, but it was a company called Heart and Soul Hospice.
It's called what?
Heart and Soul Hospice.
Yeah, there's no heart and soul in that at all.
No.
Right.
No. I don't know that I mentioned that in my testimony, but a few months after this happened to me, she was let go.
And do you know that if the Board of Nursing was aware that she was let go?
I have absolutely no idea because I had the communication with them was nearly impossible.
All right, so I'm going to, boy, there's a lot here, but I want to shift to this NAP program. I've got a lot of experience, personal experience in my life of people that needed help and have been through different drug programs that failed them as well. And I see a lot of wasted money at the state level that we spend on different treatment programs and mental health issues that tend to be invested in programs that are just a money suck, and they get paid for doing things without regard for outcomes. And this NAP program seems like that needs to be a target of ours as well, to make sure that it is handled right for those that do need it. I'm not saying you need it.
Absolutely.
I'm saying that you were forced into this by a board that has no regard for human life, it seems like, from what I can tell from these last couple of meetings. The power-hungry individuals that are ruining people's lives. And I think you have a couple of good cases here. I think you have a case, I don't know what the statute of limitation is, against your employer that was retaliatory, but you certainly have a case against the state for all your expenses and lost wages. And I think there's a lot of people in this room that have legitimate claims against the state for what we put you through. And when I say we, I mean the Board of Nursing and the people that run it and the director. And I'm hoping at the end of the day, we can make a recommendation to take some of that $4 million that they have in the bank and share it with the people that deserve it and allow you guys to all make claims against the state in order to get your money back, and then also kind of come up with a solution to get your life back.
Yeah.
Thank you.
That'd be great. Thank you.
All right, thank you, Stephanie. Okay, committee, we have Katie Mag. Did I say that correctly? Mog. I generally will, if there's only 2 ways to pronounce it, I'll pronounce it the wrong way. Welcome.
At this point. Thank you, Madam Chair and committee members, for letting me speak today. Stephanie's story was my fear of happening, so I did what a lot of people didn't do, and I stood up to the board. I've been a nurse since 2014 after completing my bridge program. I was an LPN for 2 years before that. In September of 2018, my license was to be renewed. Simple oversight. Started a new job. It was an MDS coordinator. I didn't even know what MDS stood for at the time. I just knew I was going to do it. I realized my license was lapsed on October 12th, so 12 days had passed before I filed my reinstatement application, contacted them, was honest and said, hey, what do I need to do at this point? They were extremely, almost just rude, like, how dare you not reinstate your license? Now we're going to come for you. They told me they were going to open an investigation because of the unlicensed practice. And also there had been a complaint filed 8 months before that on a drug test that they were told was failed, but it was not. It was cleared by the medical review officer. I don't even know how they got a copy of it. Multiple people at the Board of Nursing misread that drug test because I refused to sign a professional misconduct consent agreement. A couple months later, I received a summary order to revoke my license, all because of an anonymous drug test result by the Board of Nursing. In 2019, in January 19, 4 months later, I hired an attorney and we were going to take it to the administrative hearing because I was gonna fight that. I worked hard for my nursing license. I wasn't just gonna let it go to waste after somebody made a mistake. $5,600 is the amount I paid the next 4 months. Prior to the pre-hearing conference, William Shepnick, at the time, who was the Assistant Attorney General, decided to propose conditions of requirements for me to present to the board that would clear them or answer all their concerns of any possible substance abuse. Simple things like prescription list or a letter from the medical review officer on the said drug test, which they had already received because I reached out to her requesting a copy of that be sent. Once all of that was received by the Board of Nursing, they also then demanded that I get a KNAP referral and evaluation and enter into any monitoring program they recommended. I was pretty hesitant about getting the evaluation because what program that receives a kickback isn't going to make somebody be enrolled in that program? Either way, I was told that you do this or we will continue to the pre-hearing with the administrative hearing. So I went ahead and did the assessment. I was cleared. No recommendation for treatment, as I did not have a problem or failed drug test. KNAP still came back and recommended a year monitoring program. I'm pretty headstrong, and I wasn't going to admit to something I didn't do or get treatment for something I don't need. I decided to receive a copy of the contract just to see what they would stipulate. And like Stephanie said, it's a lot of let us know when you're going to leave town or your financial assessment of the program. KSBN has a contract with KNAP, and they're the only ones that you're allowed to go through. You should look into that contract. There's a very, very heavy fine or amount that the KSBN pays to KNAP. Either way, a couple months, actually, not even a month later, my license was reinstated by William Shepnick because I had completed all of their requirements, but I said I'm not entering into the program. And I said I would like some form of proof that I would not receive retaliation against the Board of Nursing for not entering into that program at the time. He agreed. I got a written document. Since then, my license was renewed twice. Then in 2024, I became very ill. They could not diagnose me. I wasn't sure if I was going to live. I've been diagnosed with Lyme disease. Sorry. Then in March, I renewed my attempted to reinstate my license and was told that you did not enter into a KNAP program back in 2019. Since then, they have offered 2 consent agreements and I won't sign them. So it's been 169 days since I applied for reinstatement, and I'm still waiting for the board to figure out what they want to do. I contacted Carol Moreland and said, how can I file a complaint? She said, send me a complaint and I'll send it to where it needs to go. So you can imagine where that complaint went. The Board of Nursing is so adamant that we follow their rules and guidelines, but yet, when practical, within 90 days after receipt of a completed application, the state agency shall approve or deny an application in whole or in part. It's been 169 days. There needs to be reform, and that's what I'm asking for today. The Kansas Board of Nursing says that they're not trying to cause any harm, but that's all they've caused. Thank you.
Thank you, Katie. So sorry for all you went through. We'll take questions at the end. So
sorry.
You were okay. Committee, we actually have one more scheduled, Sandy Pickard, but if you'll hold on 1 minute, Sandy, Representative Pickard, actually, who also is a nurse. I'm going to ask you to look at the written testimony. There's quite a long list of testimony, including Representative Blex's wife, Megan. If you look to the back page, Maggie Ortez is listed. Maggie, I know you're here and you flew in. Because of time, I'm not going to give you 5 minutes, but your testimony is excellent. It's the very last one in your packet. If you'd like to come up for a few minutes, I think there are some valuable recommendations to consider, and then we'll end with Representative Pickard.
So thank you for having me. My name is Maggie Ortiz. I've been a nurse for 25 years. I do not have a license in this state. My life's work has been around due process as it pertains to nurses that are under investigation. I was a prior investigator for a board of nursing in Texas. I was there for a short period of time after practicing for 15 years. I left the emergency room, came into the board of nursing, and I felt like the training was poor. So the elephant in the room is the investigative process. I think that we've all hit on that. There's no training. I'm not going to shock you, right? There's no training. So there's the lack of training, but it's the way that administrative law is written in the United States. I've met with a DC lawyer, myself and one of the presidents from a large physician group, because we have concerns about the lack of oversight that pertains to boards in the United States. The Board of Nursing seems to be far more egregious. This is not unique to Kansas. I wish it was, but it is not. This has been my life's work for a decade. So there can be some things, and the board has said that they are already looking inside themselves, which, I think is amazing that they're willing to look to see to correct some things. There does need to be some oversight. We cannot let the fox oversee the hen house. That's what's happening with administrative law. So there is no accountability. So the young lady that just gave testimony, and she said that person was going to investigate that. What's the process when you file a complaint? I can tell you from my own state, until I did go to my representatives, nothing existed. And they sat there, jaw dropped, and there's 440,000 nurses in the state of Texas. You guys have 77,000. So my representatives were shocked that there was no way to make a complaint about the nursing board to the nursing board. I went back, helped write a bill, drafted up some stuff. There is a way to make a complaint about them, but then they investigate themselves, which is not due process. So I do want the investigative process. I think there needs to be reform with that. I'm not here saying that there are not nurses that do deviate from the standard of care. There are, and should they stand in front of the Board of Nursing? They should, but with consistency and a rubric, which you guys have pointed out. There is no rubric. So that's why I'm here. I think that there are some things that pertain to due process that I have written up that I'm not going to bore you with my testimony. I've spent a decade in this space. I've helped nurses across the United States. If you've seen them on the news, they've reached out to me. I do not provide legal advice. I am pursuing law school because of this very reason right here. So I hope this to be the rubric in the United States. Kansas does have the opportunity to make change in the United States for nurses in the United States.
All right, thank you, Maggie.
Yes, ma'am.
Her testimony is in your packets, the very last one, and I did get permission from Maggie to actually take a few of those items, even word for word, and put them into the recommendations that you all will have an opportunity to look at and to vote on at the end of our time here today. So thank you, Maggie.
Thank you.
Okay, Representative Pickard, it is your time. Thank you for your patience, and thank you for helping me put together the testimony today.
Thank you, Madam Chair and members of the committee. Well, I don't know if you feel as I do, but so imagine dealing with these stories since March. They're coming out of the woodwork. There are many nurses that we don't have testimonies from because of fear of retaliation, or it's just too hard for them to share their story. So, but I'm telling you, Pandora's box is open. It makes me, you know, it's not unusual for me to hear from at least one nurse a day, sometimes 2 or 3, and by the end of that, I'm just wiped. I'm so disheartened, disappointed, and I feel so bad for them because they've been hurt emotionally, professionally, financially, and God knows however many other ways because of their dealings with the State Board of Nursing. And I want to point out, this is not a witch hunt for the State Board of Nursing. I had no idea before March that there was really any challenges because I had never personally experienced that. But I think that now that we are aware of these things, we need to address them head on. And, you know, it's hard to look at yourselves when you're being accused, but it's not a partisan issue. It's an issue that, that we really need to do because we need good nurses in Kansas. So let me get on with my testimony here. So I'm going to try to recap challenges. We've heard from so many nurses and so many challenges. Hopefully this will kind of help hone in on some things. Okay, we've heard plenty about lapsed licenses due to clerical errors, the website malfunctioning, and then nurses get no acknowledgement if they've tried to use the website, if they've failed in their renewal, or if they're successful in their renewal. So that, I think, needs to change. Failure to complete the process, never mind, okay. Not receiving a postcard. Now that the post office has a lot to do with that, but there's other ways to let nurses know, and Carol Moreland talked about that. So there's no grace period beyond the licensure due date. We've heard plenty of that. Poor communications about a timeline, and we've heard how it's been, you know, 6 weeks, 6 months, 4 years, you know, timeline, and this going on and on before there's some kind of a conclusion to a determination about licenses. Okay. All right, then just the State Board of Nursing's customer service. There's a lot of issues, a lack of oral and written communication, rude or condescending remarks, lack of follow-up, inconsistent fees for the same infractions, fees not refunded if a nurse double pays for her license, or if a service isn't provided. There's one testimony that you didn't hear. This nurse was testing today. That's why she didn't show up doing her some kind of a licensing test. Anyway, but she did not get the service that she'd paid for, but no refund of her money. Okay. All right. Then an attitude of guilty until proven innocent. And in our society, in our nation, it's you're innocent until proven guilty. All right. And that denies the nurse's credibility. It makes judgments before the nurse is even allowed to tell their story, if they get to tell their story. Another thing is coercion into the KNAP program. And we heard how that worked. Okay, investigations. Now, Carol Moreland did address that they're trying to use nurse investigators, which I think is a great thing, but I think we also need nurses who are peers. You know, if you've got an LPN investigating an ARNP, that may not be effective. All right. No timelines given for investigations, unreasonable timelines, causing financial hardship and angst for patients and for employers. Another thing, conflict of interest issues, coercion by the director of a nursing who is also a KSBN board member, and that places staff and patients at a high risk for poor outcomes. Another was nurses' lack of trust and confidence in the State Board of Nursing. And then there's lack of advocacy for nurses. You know, there's no neutral place or person that a nurse who is being charged with something can go. I'm telling you, just as a regular nurse, you know, when I was, before I retired, I would have no idea if I was charged with something like these nurses that you've heard from. I wouldn't know even where to start. I know I'd be really upset, but it'd be like, whoa, what do you do? So we need an advocate. I think about the patient advocate or the advocate for children. You know, yeah. What? Yes, Office of the Child Advocate. Thank you. That is, you know, for people that have any kind of questions or challenges with, if they're being charged with child abuse or foster care problems or whatever, they have a person they can go to that's neutral, not affiliated with the government. And so that would be great if nurses or all healthcare professionals have that, because there's other healthcare professionals that have problems. Okay? All right. And then I already mentioned the fear of retaliation from the state board. These nurses that came forth, kudos to them. They're scared about retaliation, and there's many that did not come forth because of that. Okay, so we've heard from a lot of input from nurse experts around the state, and here are some recommendations. Number one, use nurses to investigate nurses, ideally from the same background. And that may take some contract nursing to do that. Okay, allow nurses the ability to declare safe harbor, to request a peer review of a work assignment that they believe is unsafe or unethical, protecting them from their employer retaliating and any disciplinary action from the state board. Okay, number three, don't revoke or suspend a nurse's license over issues unrelated to their ability to provide ethical and competent care, like something like late on paying taxes, alimony payments, or student loans. Number four, differentiate between human error, reckless error, and malicious behavior when it comes to processing complaints and determining disciplinary action. When I was here to speak to the committee before, I was asked, you know, how can a nurse forget? We're human. I mean, you know, there could be a month where it's just horrendous and you just plain forget. So that would be a human error. Okay. Number five, create algorithms to help ensure consistency in processing lapse licenses or complaints. Number six, if there's a system error showing that a nurse is not licensed, but the nurse can demonstrate evidence to the contrary, the Board of Nursing must allow them to practice. And there have been cases where this has happened, where the nurse was maybe told that they couldn't practice until IT fixed the state board's system error. It's not the nurse's fault. Okay. Number seven, advise nurses under initial investigation an estimated time to be reinstated. There's no information whatsoever for that. We've heard that a lot today. But the time to reinstate, maybe days to months, as we've talked about, give them some kind of an estimate. All right. And reinstate nurses who are not a threat to the public. If it's just been a simple forgetting to renew their license or for some reason didn't. Do that within 3 days. What takes so long, you know? Number eight, when a nurse is investigated, assume innocence until proven guilty. Number 9, remove the option of reopening cases without a cause for those who have not signed a consent agreement. Some of the APRNs that spoke today said that, they got a letter saying that their case could be open at any time. Why? Consider a statute of limitation for opening a case against a licensee for being 2 years. Beyond 2 years, you cannot reopen a case again. Number 11, if a nurse protests the summary judgment of the Board of Nursing and goes to court, the Board of Nursing must accept the verdict of the court. Number 12, remove the state board's ability to force the nurse to fund all court costs if they lose the case. Number 13, the state board must abide by Kansas Open Records Act and Kansas Open Meetings Act. Okay. And then compensate for any attorney fees and lost work time by the State Board of Nursing. Okay, independent of the State Board of Nursing, have an independent advocate for licensed healthcare professionals. So I'll stand for questions at any time you might have some, and thank you so much for your time, and thank you for giving your utmost attention to all these conferees. Thank you.
Thank you, Representative Pickert. You have spent a lot of time, and we truly appreciate that. Now, committee, I want you to just take a moment and look through some of your testimony. I'm going to give you a minute. I want you to consider any questions that you may have for those that have shared their testimony. Because of time, I want you to pick the 1 or 2 questions that you find priority, and then you'll name which person you would like to direct your question. But just take a moment and go through your testimony before I call on you. Okay, I know we have heard quite a bit today, and it takes a while to process all the testimony that we have heard. We will give the executive director an opportunity after your questions to respond to anything she'd like to respond to related to the testimony this morning or conclusive remarks. And we will also give you an opportunity for follow-up questions as well, directed towards the executive director or attorney or board member. So keep that in consideration. But right now, would anyone like to ask a question of those that provided testimony? Representative Berquist, please state who you would like to call to the podium.
Representative Pickert, if you could come forward. I just wanted for you to tell the public who is listening to this meeting, for the record, how long have you been a nurse?
52 years. I retired at the end of 2020.
Okay. Thank you for your service, and it gives a lot more credibility. The more, the better. But thank you for your service, and thanks for your expertise.
Thank you very much.
Thank you. We have Representative Sutton and then Vice Chair.
Thank you, Madam Chair. I know looking over here to the left is tough. I get it. This question would actually be for Maggie Ortiz.
Yes, sir.
Well, thank you for being here, and I really enjoyed your testimony here. You heard a kind of a laundry list from Representative Pickert of recommendations And I wanted to see with your experience if you had anything to add to that list.
I agree with everything that she said. I think that the investigative process is where it all ends up. So to your point, I think that that needs to be looked at. The nurse should be able to see the full and complete file. They should be able to have sufficient time to look at the complete file to give sufficient response to that. I do believe that there should be a statute of limitations. There should not be something hanging over a nurse's head for years and years and years. I think that there should be accountability. There needs to be some kind of oversight. I think she pretty much touched on everything that I feel like needs to happen. There needs to be an advocate. There is no, like she said, when we're a nurse, when we learn that piece in school about the investigative process, I'm like, okay, but I have to memorize all the bones of the ear. And you know what I mean? I'm not going to do anything wrong. Therefore, why do I need to know this? And then I'm 10 years into a profession, into my practice, and then I get this letter from the Board of Nursing, and it's Friday night, and who will I call? The number one reason why a nurse will attempt suicide is the Board of Nursing complaint. I think that's really important to know. The number one reason why a nurse in the United States will attempt suicide is a Board of Nursing complaint. So an advocate would be a great piece to have because we don't understand that. It's all written legalese. The nurse doesn't understand. And we do have PTSD. 70% of the population will have a substance use disorder. Now insert that that's a nurse, right? And now we're taking care of people. I just put someone in a body bag and they're 6 months old. If you don't think I have PTSD, you're kidding yourself. And the KNAP program, that's, again, across the United States, we're not overseeing the programs that are affording nurses mental health and substance use disorders because no one oversees them as well. We heard the young lady, it's egregious. They found nothing wrong with her in her evaluation that she paid out of her pocket for, which is $1,000 to $3,000. Doesn't matter what state you're in. And then the drug testing, all that, for why? Why? It's egregious. So it's not exhaustive. I do have more stuff that I could share. I'm more than happy to do that. But I think that she was pretty inclusive of a lot of stuff that I think needs to happen.
Excellent. Thank you.
And Maggie, if you'll stay up there, there's a question from Representative Tarwater, and I do think you would be an invaluable resource for the Health Committee during this session. Representative Tarwater and then the Vice Chair.
Thanks, Madam Chair. Just real quick. Yeah, thanks for coming all the way in for this and being here live from your state. Can you tell me, because this seems to be a passion of yours, and I love the way you stumbled upon it because you were a board member and you saw.
No, I wasn't a board member. I think that's
investigator.
The piece that's lack of understanding is the way that it's broken up. So I was an investigator. I was not a board member.
Okay. So you saw the inherent problems with the system, and now you're trying to do something about it. And you're even going to become a lawyer, and I think you're going to be a damn good one and a great advocate for nurses. And hopefully you'll be licensed in Kansas because you'll be very busy up here. I promise you that. So my question is, what states do we need to be looking at? Because I know this is your passion. Which states do it best? Which states do we need to look to for advice as to where to go from here?
So each state, I do believe, brings some different things, and I have reached out across to nurses across the nation for this very reason. For example, we heard representatives speak about safe harbor. That the only two states that have safe harbor are Texas. I stand on the shoulder for giants. Safe harbor is a peer review process that can be called, and I'm just going to use the staffing as an issue. If I'm assigned 10 patients and I should have 5, I can call safe harbor and enact a peer review process. That's one type of peer review. The second one is a peer review, like that was referenced here. I do something on the unit. It's something minor. People with my same or similar circumstance look at it, and then it's decided whether there was a deviation from the standard of care. Texas is the only one that has that. It's written into the MPA. If you have more than 8 nurses, you have to afford it. If you can't, then there are organizations that will do that. Those are 2 things that can be done. There needs to be a third-party entity. There needs to be an ombudsman that if I have a complaint about the board, that it has to go outside the board. I mirrored a bill in Texas. It was not picked up. It was around child care or mental health care, so I wasn't trying to reinvent the wheel. That did not get passed in Texas. 2020 hit, unfortunately. We all know what happened then. So great question. I think that the board has gone back and done some things and introspectively looked at some stuff that they can work on and leaned into some other states as well, and then leaning into the Nurses Association, the Nurse Practitioner Association, and I'm more than happy to come back with some of those things. But oversight and an investigative process, the clear training is the national training that an investigator goes to, but I was there with PT, OT, MD, just learning about the investigative process. It wasn't inclusive to the Board of Nursing. I then went back to the agency where I don't feel like the program was as robust as it could be because I'm not a lawyer, and I can tell you that I feel like it's a huge responsibility for an investigator to pick a violation. And I know we're focusing on professional conduct, but that's one that's always going to get applied if you get disciplined by a board of nursing, as I was told. So you're going to walk away with all kinds of discipline. It's the investigative process. We need to have robust training for nurse investigators. And the young lady said that there was an LPN, and I don't know if none of you hold a license, I don't think that you can appreciate in civil litigation, an LPN would never be able to give their opinion or opine on an APRN's conduct. That would never stand in civil litigation because they don't have the same education. So why, therefore, under the Board of Nursing, is an LPN investigator allowed to basically give their opinion? I don't have a problem with, it would be like in a law practice where the legal nurse consultant or someone would work up the case in the practice, but then someone with that APRN, the same or similar circumstance, should be given their official opinion as it pertains to that.
And we have Vice Chair Lewis.
Thank you, Madam Chair. I have a question for Conferee Taryn Derman. Thank you for your testimony. I just want to try and clarify for myself what the gist of your situation is. Correct me if I'm wrong, but I understand you were alleged not to have attended a mandatory class, and this Juliana Rishik
I believe that's how she pronounces it, yes.
was your boss at that time?
Yes,
And she said because of that, she's terminating you, right?
yes.
And you then proceeded to leave. And she said, well, you can't leave. You've been terminated, but you have to stay.
Yeah, she told me I had to wait for HR to terminate me.
Right, okay. All right, and, all right. And,
But I had to finish working first.
right. And then she said you would be engaged in patient abandonment because she had told you to leave.
Well, initially she told me it was patient abandonment, which is not true, and she knows that because I was working as an administrator. So I had no patients in my care. Me not being there that day would not affect any patients at all.
Right. I understand that you didn't agree with that, but that's what she said to you, that it would
Yes.
be. And then going further, she threatened you multiple times to turn you over to the nursing board,
Yes.
right? Which apparently she did,
She did.
right? And in your written testimony, it wasn't clear. I take it that it was the allegation that they're investigating is patient abandonment?
It's job abandonment, which I actually looked in the Kansas Nurse Practice Act. That's not even listed in there, job abandonment. That's not an option.
But that's the allegation.
That's the allegation. And
Okay.
it's been 15 months and I'm still being investigated for something that's not even in the Nurse Practice Act.
Right. Now, and this may just be a slight error on your part in terms of who's doing the investigation, but on one, you say that it's being reviewed by the Assistant District Attorney. Do you mean the Assistant Attorney General?
Probably.
Yeah. It's not being investigated criminally, is it?
No.
Okay, thank you.
Well, I just have to add on to that. My notes right here said, Carol, define job abandonment is, and where can we find this listed? So thank you for hitting that particular item. Amazing that you can file a complaint on something that's not even in nurse practice.
Yeah.
Yeah. Okay, so Representative Humphreys.
Thank you, Madam Chair. This might not be the most appropriate because I'm not sure who could answer this, but I wanted to dig in a little bit more to that KNAP issue. But, and what I'm wondering is, who do they operate under? Is it the Board of Nursing? It's a different, it's.
What we can do on that one, is you could hold it for Carol or a Board of
Okay.
Nursing member. Would that be okay?
That is fine, and I'm wondering how the finances break down about that too.
Okay,
Thank
I
you.
think that would be great.
Okay.
Representative Sutton.
Thank you, Madam Chair. And I apologize for not getting your name, but the young lady that was just testifying, yeah, I'm sorry? Taryn, yes. Sorry about that. This may not even be relevant, but I am curious as to what was this class that was offered one time only and never,
Well,
ever,
that's
ever
actually
again?
interesting. The hospital is being sued by the Department of Justice for failing to provide an interpreter for an ADA patient. And so when that happens, so when a hospital gets sued by like either CMS or Joint Commission or investigated by Joint Commission, usually they have like 30, 60, 90 days, like an action plan essentially to correct their wrong. And I've had classes like this happen before where like, hey, we have 30 days, everyone needs to take this class. And it's common practice where if you don't complete certain education, you do get fired. But like I stated in my testimony, like I was never formally and properly notified of that. But yeah, so that's what happened. All of my like standard education and training for Providence for that role was up to date. This was just a random like corrective action class that the hospital made up to correct their wrong, essentially.
So, well, I find that interesting, that your training to be a nurse was fully up to date.
Yes.
and continuing education, that sort of thing, okay.
Correct.
But it was because the hospital was being investigated that you were then
Yes,
subject to investigation.
exactly.
Interesting. All right. Thank you, Madam Chair.
An unfortunate turn of events there. All right, so we have Representative Avercamp and then Representative Waitmaster.
Thank you, Madam Chair. Question for Amy Sipple. Sipel, sorry. Thanks, Amy.
Sir.
Hey, so in your testimony, you kind of went through the history of the last few months a little bit that you went through. You had a hearing in front of the board, and you made
An administrative judge.
Okay,
I
administrative
was
judge.
never allowed a hearing in front of the board.
Okay, so the board was there present, correct?
No, the board's attorney was present, Sydney Winslow, and one of the investigators was present.
Okay, and I believe you made the comment in your testimony that you would have anticipated that during that, in front of the judge, when you were in front of the judge, you would have heard some additional information beyond just the initial accusation, or they would have thrown everything they had at you. Are you willing to go into detail on just what all did they have on you that would have caused you to go through this whole process?
Yes, I will tell you, those of you who are attorneys on this committee must empathize with mine, who, just last week, he said, I am pleading with you to stop talking about your case in public. I care more about the cause than I do about my case. And so my case is still open. I did put in my testimony what their charges were against me, which I will tell you that it took a long time to figure that out. I didn't know what they were actually charging me with. So as soon as I was told that I was under investigation, I filled out a RECORA request, and I said, can I please have access to all communications that involve me or my case number? Because I wasn't even employed as a nurse practitioner during that time. And they told me that my CORA request was denied because I was under investigation. Then I hired an attorney, and I hired my attorney. I got the notice the week of Thanksgiving that I needed to sign the consent the following Monday. And so I had to find an attorney the week of Thanksgiving. I found one, and then I met with him that Monday morning following Thanksgiving, and he called the board and said, can we have a copy of her file or case file, because I don't even know what I'm defending here. And they refused. And so we did not get my case file until, I think it was around the end of May. I can give you those exact dates, I just don't have it in front of me, whenever the judge, the administrative judge, said that my case file had to be released to my attorney before we went to trial, which was in August. And so, sorry, Josh, but what they did come after me for was they said that on my website, the title nurse practitioner was listed on the website, and I have an online calendar, and someone part of their investigation, they looked at my online calendar, and part of my online calendar included me speaking at the calendar showed that I was scheduled to speak at conferences and to senior centers. That is my crime. that they're accusing me of during the license lapse. Now, I will say that if you look at the online calendar, there's no speeches scheduled from the time that I became aware of my license lapse to reinstatement. But no, they didn't attend any speeches, they just had the calendar.
Thanks for clarifying. Thank you, Madam Chair.
Was this gratuitous? Amy?
I'm sorry?
Was this, when you were helping at the senior center, were you charging any fee for this?
My attorney would.
Okay, no, you don't have to answer.
Yes. And so I'm just saying that my calendar showed this, and my attorney pointed out, no one heard me speak, no one verified if I spoke, if this was based on an online calendar.
Okay, and again, we're hearing time and time again that the information, the files are not being shared with those that are being accused. So I'm very sorry to hear that. Representative Waymaster.
All right, thank you, Madam Chair. This is actually, again, for Taryn to come up. And I just wanted to say, I mean, the day that you were told you did not have this continuing education program that was in.
Yeah, it's not, it doesn't count as continuing education.
Just-
the class that I missed, yeah, it was a corrective action course for the hospital to get back in line to not get sued again.
Well, and I just have to say, it was very unprofessional for Juliana to say this in front of your coworkers.
Yes, we were in a room about this size with like social workers, physicians, other administrators, and she was sitting up there, and I would talk to her, and that's the conversation we had in front of everybody.
Well, that's, I mean, the epitome of unprofessionalism as far as being a manager. And then what perplexes me, that's the second time I've used that word today, is then she was named to the board of nursing.
So
And
she was the
the board.
president at the time. I
She was
didn't
the
know
president
that.
on the board.
Yeah, no one told me that before I got into an argument with her.
And
Maybe I wouldn't have argued with her if I knew that.
well, still, there's an air of unprofessionalism there as
Yeah.
well.
Yeah.
You don't use that as a way to intimidate your employee.
And I did
And
reach
that's
out
what
to-
is exactly what she did. And I just want to make it, I have sure I have your testimony right from what you expressed when you were giving your oral testimony to what we have in written. She's no longer on the board, and she's no longer president of the board, obviously, but is she still an investigator?
So she was present at this last meeting in July, but as of August, I don't see her name. No, it's no longer listed on the website for KSBN as a board member or as an investigative committee chair is now vacant. So I'm not sure if she resigned. I'm not sure if they let her go.
That's what I was trying to clarify, because I thought when you were giving your oral testimony, I was under the impression that she was still actively as an investigator.
Yeah, so when I initially wrote my testimony like a couple weeks ago, I was under my impression that she still was. I just recently found out that she's no longer, as far as I know, she's not on the board or a part of the investigation committee.
Well, if she is still, I mean, just given the evidence that you have supplied in regards to how you were treated as an employee, how she was using her position as president of the board to intimidate you, and then becoming an investigator, I think in her own words, she should be terminated.
I agree. I will add that, this happened last June. She was still the president up until September, and then she became a board member, and then from December until now, she was investigative committee chair. Even after I reached out to the board multiple times about her conduct, and I talked to Carol Moreland on the phone and through email, which I provided, and she still remained on the board and somehow.
But as I think was expressed by Representative Pickert and then also by Ms. Ortiz, I mean, we need to have somebody outside investigate if there's a complaint against somebody who's on the board of nursing. When you have I think you used the term, we have the fox watch the hen house, nothing's going to happen. And that kind of behooves us to make something happen.
Yeah.
Thank you, Taryn. Thank you, Madam Chair.
And according to the testimony that we received, she is no longer on the board, but that was a very recent change. All right, committee, if there are no further questions for those that provided testimony, all right. Oh, yes, Representative Ballard, my mistake. Representative Ballard?
I want Iolanda Griffey.
Hi.
Right. My question for you, since you would have renewed your licenses many, many times, because I wrote down you've been a nurse for 55 years, 47 years,
As a licensed nurse.
as a licensed nurse.
Correct.
And yet you were charged with unprofessional conduct, right? Am I correct?
Correct.
All right. I guess what I would ask for you, since I can understand what you were saying, what would you like to say right now to the Board of Nursing in relationship to your being a nurse for 55 years and perhaps maybe how they should handle someone who forgot to renew their license?
You know, the grace period sounds wonderful. I think it needs to have a limit. Of course, my time went over, but mine was more of a computer issue than it was because I failed to renew my license because I tried to renew it. But the grace period is phenomenal because we're busy nurses. We are busy out there working with people's lives and preparing the world to do what they need to do to function, to keep it going round and round. And I would ask the board to please consider that for nurses. There's no reason that nurse that you spoke to earlier had to go through 6 weeks without wages. I mean, that's just unreal. And, you know, if a nurse has proven that she's completed the continuing education hours and has everything in place, there's no real reason to keep an investigation open for as long as they did. So,
Well, I want to thank you very much. You have the experience, you know.
Thank you, ma'am.
So I thank you very much.
Thank you.
And Madam, I would just like to comment on I think of Michael, I think it's Schomburg, I can't remember. In a way you say it didn't affect him, but it did because it was his son that this happened. And it's a little differently than what we've been hearing. But again, it was someone who did not get that license done, maybe in a timely manner, but he could have lost his son. And that's serious. Thank you, Madam Chair.
Very serious. Thank you again to all our conferees for providing your testimony. And I would encourage our committee to take some more time, another day, and another moment, and review the testimony because I think it will matter as we move forward from here. With the conclusion of this portion of our select committee, I'd like to invite Carol back up to the podium. If there's a board member that would like to stand with you, that would be great. And if we need an attorney, a more difficult question, then of course we would ask Rachel to come back up if necessary. So let's see. We've got Brenda's right there. Okay, so I want to give you the first opportunity to respond to anything that you listened to this afternoon. I know it's difficult to listen only and not be able to respond, so I want to give you that opportunity. Then second, I'd like to give you an opportunity to share anything that we missed this morning that you feel like is important. And then we will also give you an opportunity to give some conclusive remarks after there are opportunity for the committee to ask questions.
Okay, thank you. I think first of all, I would say it was a lot to take in. You know, it's very difficult for us to remember every case. I'm sorry, that's probably not what everyone wants to hear. It would be, I think, very helpful for us if we could actually get a copy of the testimony because we would like to review those to see what was going on and stuff like that. I'm not saying that they were not saying everything right. We would just like to be able to see because we didn't see that testimony. So we were trying to take notes and stuff, but that's not exactly the same. So I think that would be very helpful. That's a request that I have, if possible. I thought the recommendations from Representative Pickett were very, very good. I think it's something that definitely we should take back to the board and discuss with the board. But again, we kind of need a copy of the testimony because I was trying to copy it all down, but it was a little bit difficult to do. You know, I know there are some questions about KNAP. We do contract with KNAP, the Kansas Nurse Assistant Program. And Rachel can probably talk more about why someone would be sent to KNAP for, you know, an evaluation and kind of how that process goes. But we do contract with KNAP. I'm trying to think what other ones really kind of stood out. I know there were questions about KNAP.
And we will provide you the testimony.
Okay,
And
thank you.
in fact, we would appreciate response back on these items.
Okay.
Review those items and provide a response would be appreciated.
Okay.
Not necessary to give an overview of the KNAP program. I think it's at least clear from what we've heard today that we need to take a hard look at that. Even from a funding perspective, is it really doing what we want it to do? So you don't have to provide an overview.
Okay, great.
Would you like to add anything else before questions, or would you like to proceed with questions? Okay, Representative Francis.
I would just like a little bit more understanding. Is KNAP a standalone 501c3, or do they receive funding from the state? Just a better understanding of what the relationship is. Do they provide services to other entities? I mean, that's one of the things.
I'm not sure about other entities. Do one of you back there know that work with it a little bit closer? I don't believe it gets any funding from the state. I can say that.
I believe they also set up contracts like with other state agencies, and so that if there is impaired providers in those agencies that need a referral for substance use disorder or mental health, then they can refer them that way via their contracts that they establish. I believe they're a 501c3. They have their own executive director. They have their own board of directors that they respond to. And we just contract for the nurses and the LMHTs that we have licensing for. Does that answer your question? Okay.
And actually, Sade, in all of your free time, would you be able to do a little checking up on KNAP for us and find out who they contract out to for other state agencies, how much we spend for the program, how many people they serve, any criteria that may be required, if they're paid per person, anything that you can find for us, if you could send it to our committee on KNAP. Representative Hoy.
Thank you, Madam Chair. And just to add to that, I would be curious if any nurses employed by the state, if the state's insurance would cover services for that. Thank you.
And committee, if we forget anything in this meeting here today, we'll certainly have an opportunity to reach out to our research or revisers for those follow-up. Further questions for Carol or for the board?
Hey,
Sorry, I apologize again. It's hard for me to remember, but Representative Sawyer.
yeah, thank you. I think I had my hand up, but I don't know if I did it right. I have a question for the director. Did I hear you correctly say you don't think you had statutory authority to do a grace period when you spoke earlier?
I do not believe that we do. No.
Okay. All right. I wanted that clarified. So, okay. Thank you. That's what I need to know.
Representative Sawyer, actually that question
Yeah.
was also asked of our revisor. Jenna did not believe that there's any statute that would prohibit it. And so.
Yeah, but
yes.
But I don't know if you ever served on administrative rules and regs, but we criticize all the time when they get up there and say, well, we did this because there was no statute that said we couldn't do it. You understand what I'm saying?
Sure.
Legislators. Well, and they were saying you didn't have statutory to do this. They said, well, there wasn't one that said we couldn't. So
Make a valid point, and so I think what you'll find is that's something that is very popular amongst the legislature that we've visited with, and so you just might find that on our recommendations here shortly.
okay, I just want to make sure we put if if they felt like they had to have statutory authority, they didn't have it, that we can just definitely put that on the list. I will say right now, so I don't have to keep, it's hard to do this by phone, is that I like all of Sandy's recommendations. So I would think we need to do something statutorily with the grace period, and I think we ought to recommend the list that Representative Pickard had.
Great, thank you. Vice Chair.
Thank you. So in our last hearing, we had cases, I'll call them cases, presented by Anna Ahrens, by Elaine Gabbert, and John Coslet, and Amy Seipel. Amy Seipel's was and is still being litigated, so I'll put that to one side. We asked the board to go back and we said of those cases using the information provided on the consent agreements, public record, please provide a justification of how these nurses were disciplined and how they were a threat to your patients. And then you gave responses which were fairly perfunctory. Also, although I don't know if it was in a formal request, I know that Representative Ballard had asked that you go back to these cases and ask yourself, essentially, did you think these cases were treated fairly? And if I understood what the board member Sharp told us this morning, is that, you know, they can't really tell us anything about the the factors that went into the decisions, because that's all confidential. Having said that, I mean, I'm taking from your silence, and maybe I shouldn't, that you stand by all of the rulings and decisions on these three cases, the Aaron, the Gabbert, and the Coslet. And I take it, too, that you did what we asked you, and you went in and you reviewed those cases. The board reviewed the cases and has determined that there's nothing that the board feels should be done to compensate these people, to change the outcome of these cases. Yes, Rachel.
Thank you. I'll go ahead and respond, since I am not representing the board in all those cases, but I have requested a status update. So those are currently being reviewed. The board is doing a thorough review and will be discussing outcomes with the licensees, applicants, or their next of kin first. But as soon as that review is completed, I imagine it will be within the next few weeks. We will update the committee as long as there's no concerns from the licensee applicant or their next of kin.
All right, thank you. Then we'll expect in the next few weeks a report from you or the board.
And if for some reason there's a delay in that, we will let you know.
Thank you very much.
Thank you.
Representative Berquist.
Yes, questions for you, ma'am. Thank you. We've heard in the last two sessions of this committee, have heard testimony about cases that are anywhere from 10 to 15 years old and maybe more, and I may have missed it in that first, in my listening to the last meeting. In all that time, you've been as the Board of Nursing, you've been dealing with regulations and statutes that are written in a certain way to operate. And maybe the Board of Nursing has been operating according to those statutes and rules. But in all that time, to hear all these complaints one by one and issues where careers are being crashed, and I say crashed because that's the way I look at it, that there isn't something within the Board of Nursing, which are made up of nurses and other people, but certainly people that understand what nursing is, to not ask the state to change laws to make your job as the Board of Nursing more aligned with reason, because most of these things are so unreasonable. We're blowing our minds up here, hearing the things that are happening to people. And honestly, is there ever any consideration on our annual review of doing things different, or is it just a status quo? Your thoughts?
I'm going to talk about the task force that's been looking at this.
I can try to address that. I've been on the board just a couple of years, Representative, and one of the first things that I requested was an update on the statutes that are, this board is subjected to. And I would say that there is there are many mixed feelings about opening up statutes at any time in the legislative body because anything else can get added to that. And so I will say that there has been some fear expressed to us, for instance, from the APRN profession that worked very, very hard over the last several years in order to become to have independent practice here in the state. And there have been concerns expressed at various times by other board members, associations, et cetera, of opening up statutes that may in fact get other things tacked onto them, such as moving supervision back under MDs or something along those lines. And I think we all know how detrimental that would be in a state like Kansas with so many rural areas. So that's not a good enough reason for me. And so I did ask that a statute work group be formed, and we have had one meeting. We have determined that we would like to have external representatives on that, including some of the lawyers that work with some of the clients, some of our professional association colleagues. I think we would love to invite the representative whose many of her recommendations are not things that we disagree with per se. This board would like more tools in its toolbox. We do follow the statute, and as was shared earlier, many of the other boards have grace periods in their statutes and we do not. And so we interpret that, and I think most lawyers would interpret that as don't do it unless it's in your statute. And there are plenty of people that have approached me in the last few weeks since this first hearing and said, you know what, you're either licensed or you're not. I feel like that's pretty harsh. I would love for us to have some kind of a grace period. I think what we would like to hear from this group, what is an appropriate grace period? I don't know what it is. And if my mother in Western Kansas has an adverse event when they are having a nurse who's unlicensed practicing in that room with them, whose fault is that? Who's to blame? I don't know. If we have an unlicensed professional representing themselves, if a pharmacist was out giving talks on opioid prevention to kids in high school and they happen to not be a pharmacist but represented themselves as such, is that a problem? We don't know what all of the exceptions should be, but we're being asked by you all to make exceptions. And so we need feedback on what's an appropriate grace period, what are appropriate exceptions. And I will still contend that this board acts in good faith and takes into account all facts and circumstances related to things that may appear one way to this group, but in fact we believe are another. And I can't really state that any more strongly.
Yeah, can I follow up? I heard you mention the concern of APRNs in the last few years as to how they would be controlled or how they'd be protected. And I'd just like to say that I think that most nurses, men, women, nurses, LPNs, RNs, would like to be protected by somebody. And I don't think they're being protected right now. The ones that are falling in line and never have a hiccup at all, they're never noticed, maybe. And they're just fine. But if somebody actually has a human error, accidental or otherwise, that seems like a knife point rather than a corrective point to help those that went through training either 10 or 20 or 30 years ago to be able to continue to do what they do well and to teach others how to do it. And that's just my thought. Thank you.
I think you all have talked about culture. The culture is changing across the United States as well, and several representatives from our board attended training recently nationally that is looking at best practice in this area, and even changing our language and words from discipline to board action so that it's less punitive in nature. Those are things that can be fixed and can be done. We need help from this body around statutory changes and to protect them so that they don't become a vehicle for other things that actually undermine the profession of nursing in this state and undermine the nursing workforce.
Simply within the reversal of things that have happened in the past, because they seem to have been handled wrongly, I'd like to see a real strong effort to reverse some of those actions and get us on the right path. Thank you.
Representative Hoy. Thank you, Madam Chair. Sorry, it's school bus time, and I'm making sure that my son remembers to take the dog out. But I did want to clarify that I had written down from this morning, the revisor said current law does not support a grace period. So may I get clarification, Madam Chair, from the revisors that I got that correct?
Jenna.
Thank you, Madam Chair. I'm trying to find the exact language. So the nurse licensure renewal statute is KSA 651117. And the language, it does not provide for a grace period. What I said is that there's no overarching statute like preventing, saying there shall be no grace periods allowed in any boards of licensure. And if we look to, like the Board of Healing Arts, they sort of have a grace period, but I hesitate to use the words grace period because there's still a penalty that has to be paid. There still is a disciplinary action. It just takes a different form, and they use different terminology related to license cancellation rather than renewal, so it's not apples to apples comparison of the way that licensure is renewed, even though they are all health professions. Yeah, but that language could be amended, obviously, for nurse licensure to allow some sort of grace period, if you want to call it that.
Thank you, Madam Chair. And I do want to follow up because I think that's a great point, depending on if it's a true grace period or just some sort of renewal extension. Because the way I view a grace period would be like, okay, your license, you have until this date, but then if it's 30 days over, you wouldn't get any discipline, but you would still be unlicensed in this time. And thinking of 77,000 nurses, not only is it, well, how long is it okay? How long is it acceptable to be practicing without a license? But also, how many nurses would it be okay to be practicing at one time in the state of Kansas without a license? So I guess it seems like the board is looking to us, but is there any appropriate amount of time, in your view, for either a certain number or a certain amount of days to be practicing without a license?
I have not formed an opinion on that. We're still doing research. One state that we think has done some good work in this area potentially is Washington State. They have some diversion programs and language. And, I've gotten feedback from individuals that are in this room anywhere from 0 days to 1 year. So as you can see, there's a lot of mixed opinions about what that should look like. I will point out too that any extensions create additional administrative issues because right now all licensees renew in their birth month. It is always their birth month. And if they were to get an extension, do they then renew their license 2 years after the time that they renewed, or does it go back to their birth month? So it's really maybe a 18-month renewal. So all of these kinds of things have additional consequences that would need to be addressed, but certainly worth looking at. And this board is absolutely committed to looking at those and raising these kinds of questions. But we would like input, because this is of such importance to this group. We would like input on what you think is reasonable, because ultimately you would have to pass something along those lines unless we did it as an internal policy, which is what we're currently looking at.
Thank you, Madam Chair.
Humphreys and Representative Osmond, did I catch you? Okay, I did. Okay, good. So if there are not further questions, we're going to end with a Representative Humphreys question, and then we're going to allow Carol to make some, is there someone else? Representative Ballard. Okay, Representative Humphreys, Representative Ballard, and then we'll turn it over to Carol.
I think I just wanted to make a comment. I hear you saying that it seems as though the statutes are what are guiding you and you're really abiding by those. I think what seems egregious to some of us on this committee is that it doesn't seem consistent in what is happening. And I agree, we don't know all the details, but when especially in the case of, mistyping something or, lapsed, forgotten license for 1 to 20 days, whatever it is, it seems inconsistent. And so I don't think just I don't find that fulfilling when I hear from you that, oh, we're just following everything perfectly, because that inconsistency is
I
what
would
is
never say
bothering
we
us.
follow everything perfectly. We're human beings. The licensees are human beings. This is a human process. That's where we're at. I would strongly encourage this committee to consider that there are other facts and circumstances which are not able to be discussed in this venue. I suppose there are other ways for you to obtain that and challenge our decision-making process and what I consider, again, to be good faith based on all of the facts and circumstances that were presented to us. I think that it is incumbent upon all of us to look for opportunities here to have these kinds of discussions and dialogues in a productive manner. I think we can absolutely improve on our communication and customer service and all of those things. And I will tell you, we are trying to do that every day. And I know that staff tries to do that every day, and it works pretty well for about 75,000+ licensees every year. But we can always be better, and we want to be better, and we're committed to being better. But these are not, every case is different. That's all I could really say. Every case is different. I would love the idea of a rubric. I worked in child abuse for a long time, so I know a lot about, the dispositions of cases around different kinds of abusive acts and juvenile delinquency kinds of situations. I also know from working in that field that there would be times when action would be taken against a family by DCF or KDADs, and those families would be very, very quick to call their legislator and say, I've been wronged, and the investigators would love nothing more than to turn over other files. But we cannot, and we will not, until we are directed to, I suppose, by somebody that says that that's a necessity. And I think at that time, those licensees would probably want to determine, based on their legal counsel, if they have it, whether or not they want that to happen. Because I was deeply concerned about this list that was produced for this committee. There is no other way to get that list other than from us. And if I was on the 60 that have my name out there now in this way, in this venue, I would be deeply concerned. But we were compelled to do that, so we did it.
Okay, thank you. I think we did hear that there were other ways to get it
There's other ways to
publicly.
look
So,
up an
yeah,
individual
but,
licensee. If you were aware of someone or looking up a licensee, there's a way to do that. There would not be another way other than compiling and going. I guess you could spend some time and go through a newsletter and.
Yep.
compile that.
So, just a little point is that part of the inconsistency I think that is troubling is if someone forgets to renew their license for 10 days, but they don't remember and they're continuing to practice. I don't, an aside is the medical malpractice or what you talked about, your elderly mother in Western Kansas. But they don't go from, okay, today my license was due to be renewed. Oh, they don't become incompetent that day.
I agree.
And so that's part of the concern that we have too, is and sorry, I got distracted because my 96-year-old mother just tried to FaceTime me. So I got a little bit.
I agree.
So I got a
and
little
I can assure
distracted.
you,
So
the investigative committee and the investigative committee chair, when we have one, is we don't want to spend our time on those cases either. We're dealing with really serious stuff on this
yeah.
committee
So
that
it
we'd like to
seems
spend more
not,
time
it
on.
seems not objective to us. It seems very subjective from what we're seeing. So I do think the training for the investigators, and I know that will probably be part of I just had one other question maybe for Carol, and it had to do with the CORA and the coma. So how did you think that didn't apply to you? And I'm just going to say it was in Amy's case when she asked for the case file so that she could prepare for her hearing. How was it that you evaded the CORA request?
Or about getting files when it's an active case?
I can't talk about CORA because that's generally through the general counsel, which is through the AG's office that advises on those matters. But if we're talking about disciplinary cases on how we obtain discovery,
I would prefer on this one, if you don't have a comment, Carol, on this, that you can reply back to the committee and respond to that. But if you do, but if you have a response right now, Carol, I don't think I want a legal response at this moment.
Yeah, I can respond back. Yeah.
Well, you're welcome to respond back now.
Well, I would like to talk to the ones who handle Cora. 'Cause
Okay.
I don't actually handle Cora, so I just want to make sure that I'm
Okay.
answering that correctly.
Okay.
All right, thank you.
Yes, sure. And then we are going to wrap up our questions. I am allowing Representative Tarwater, he had to piggyback on Representative Humphreys, and then Representative Ballard will close our questioning.
Thanks. My question is for, I think it's Mrs. Sharp. So realizing that you can or cannot release or discuss your side of the cases that we've heard, I guess I somewhat understand that. But to me, it feels like after everything that we've heard, I don't really trust y'all much. And it kind of feels like you're using it as an excuse. And so, and we've heard the human side of this from the nurses. And today we took it, they even took it a step further where Michael talked about his son and how this process darn near killed his son because the nurse, the one person that understood this kid, double-clicked something on your website and you took her license by a sheer reaction. And so if, say in that case, she was willing to sign a document that said, yes, you can discuss this with us and you can release your side of the story on how that was so egregious that you almost killed a patient, would you then be able to discuss it? If she signed it, if any of these people wanted to sign a document to say, yeah, I think you're using it as an excuse, and I would like your side of the story to come out in public too. Would you be willing then to disclose that?
Rachel.
So you're wondering if they signed a document allowing us to provide you the investigative file if we would produce it?
Yes.
I would have to defer. I generally don't work on, again, Cora production or production outside of disciplinary cases. I would want to reference that to the board's general counsel, who is contracted through with the Attorney General's office. We can get back with that response. It's not a no, it's not a yes, but since I'm not the attorney that generally advises on those matters, I want to make sure that the attorney who would have best access to that information can provide a response.
Okay, we're back to the empty chair, of course, so I guess we'll wait to hear from the empty chair. Thank you.
Well, Representative Tarwater, to know that many of these individuals that have been accused of something, they have not seen their files themselves. They do not know, in some cases, what they're being accused of. They do not know the limits of it. So it could be that some individuals right here do not even know the full extent. A consent agreement may or may not include everything. So that's also a problem of transparency. All right, thank you. Last question from Representative Ballard.
Thank you, Madam Chair. You know, I would have to say, and I am somewhat encouraged because I think Ms. Moreland opened by saying what some of those changes, she listened carefully to what we had done July 29th, and the board is making changes. And I think they need to continue to make those changes as well. And the other board members, their conversations make me believe that they will make those changes. Yes, we have 77,000 nurses, and yes, we didn't hear from a large number, but we heard from a large enough group to say that there is a problem. And I am hoping that the Department of Nursing will look at this in terms of, yes, they need to make changes. We have to do things a little differently because a lot of people are suffering as a result. And that really comes down to their constituents and everyone as well. I spent part of this time talking with different nurses because I wanted to know. My mom was a nurse, and they would like a grace period. And they said anywhere from a week to 2 weeks. just to remind them, because they get caught up in other things as well as their work. Like 30 days before, let us know when it expires. All those things to say that they're reaching out for help. But I am encouraged that Carol Moreland opened by saying, I heard you. And I think if we continue with what we feel could be better recommendations to make sure that we don't have to hear what we heard both times, it would benefit everyone and especially Kansans. So thank you, Madam Chair.
All right, thank you, Barbara. Okay, thank you from Kansas Board of Nursing. Carol, any final statements before we move to the next item on our agenda?
Yes, thank you. And thank you, Representative Ballard, for your comments. I do feel like the Board of Nursing heard your concerns. You know, today's hearing has underscored, you know, there's a depth of concern, but there's also a strength of commitment surrounding the regulation of nursing in Kansas. We've heard passionate testimony, some in opposition, some in support. There's written testimony. We haven't seen that yet, but we'll have a chance to look at it. Every perspective offered reflects a shared value, and that is to protect the public through safe, effective, and accountable nursing practice. The Board of Nursing agrees with a lot of the suggestions that were heard today, but we also understand that it requires visible action. And you're going to want to see that, and we're very aware of that. We did come with some improvement plan today that we had worked on. We tried to look at what could we do the fastest, and then what's going to take maybe a little bit longer, you know, maybe statutes and stuff like that. We acknowledge the concerns raised by the conferees today, and we do take them seriously. That's why we would like to go back and review and understand a little bit better. But we also, you know, we really like the recognition that others see the board's vital role in protecting Kansans, because we really feel like that's what we're there for. And we also want to support the nursing workforce. Our path forward then can honor both realities. The hearing is not the end of the discussion, but rather a continuation of an important partnership between this committee, the board, nurses, and the public we serve. So on behalf of the Board of Nursing, we thank you for your attention today, working with us to ensure that we are understanding everything and that nursing regulation in Kansas remains strong and focused on public protection. So thank you.
All right, thank you very much for your testimony and your willingness to go through with questions. Committee, we have some more items that we're going to finalize. I do not think that it'll take too terribly long, so if you will bear with us. We would like to entertain two motions today. One, Vice Chair Lewis will open us with, and then the second one will be a list of recommendations that we will pass out. They will also complement the recommendations that were provided by Representative Picker and that we also heard sprinkled throughout testimony today. So let's go ahead and get started. Representative Lewis. And would you like that document passed out?
Yes, please. It's a resolution of the House Government Oversight Committee regarding nurse relicensing.
And while you're waiting for that to be passed out, again, I cannot express again, my gratitude to Representative Pickert for putting together the testimony. There's so much more testimony in here that is of a different nature that I would really encourage you to read if you want to understand the more of the breadth of the difficulties that our nurses are experiencing. All right, Representative Lewis.
I'll just wait for everybody to get a copy. And Representatives X, Sawyer, and Ballard, I'll try and briefly summarize the resolution.
Can we email that to Representative Sawyer and, yes, and Representative Ballard? Representative Ballard and Sawyer, you may not have it in real time, but it will be coming your way shortly.
Thank you, Madam Chair. Okay. So the chair and I spoke, and one of the things that we agreed upon, many, but this was one, that we didn't want the work of the interim committee or the Government Oversight Committee to stop here, and that we really wanted the legislature in the next session to take the work that we've been doing and continue with it, and to work with the board to make the changes that I think the consensus among the committee members is that we need. And so we put together two documents. One is this resolution, which is just a broad brush of generally what I think represents the not the findings per se, but general findings, if you would, and the sense of the committee. So the resolution first just lays out, what we've done. We've had hearings with conferees and looked at documents, and that we've looked at a number of things, but specifically at the lapse problem. We've looked at the situation where there are errors made by the nursing board's computer relicensing software, where a nurse desires, there's a lapse because a nurse desires to take time off from nursing to help an ailing family member, or where a nurse mistakenly registers twice for the same license rather than one time for each of the two relicensing she sought, or there's an error by the nurse in knowing whether a particular continuing education program is nursing board approved. We looked at those and some others that we heard about today. And I think that the resolution says that we've also heard from the nurses about the serious professional and financial problems that they've experienced due to the unintentional licensing lapses that have no adverse effects on the patients. We find that there is some ambiguity in the meaning of unprofessional conduct, and or that it is being unfairly applied in the relicensing process, which has resulted in unfair treatment of nurses. We also find that we sense that the board has applied the laws, regulations, and policies in ways that seem more focused on punishing innocent mistakes that do not adversely affect patient care than in helping good nurses remain important contributors to the health of Kansas. We also are concerned that where there's a licensing lapse, once again, due to unintentional error without any adverse effect, that the nurse is faced with a bit of a Hobson's choice. He or she can either admit to have engaged in unprofessional conduct in a public document that continues in perpetuity, or she can decide, for instance, to just leave the profession or the state, which of course is not good for either her or the state. Another choice she oftentimes has to make if she believes that she's, after the summary order, has unfairly or illegally alleged things that she disagrees with, she can either consent in the unfair treatment, which is essentially an adhesion contract drafted by the nursing board, and she has to admit to unprofessional conduct, leaving a blemish on her record forever. That's one choice. Or she can choose to spend thousands, if not tens of thousands of dollars to hire an attorney to litigate the issue before an administrative judge and then in the courts, during which time she's not allowed to practice, and obviously is then losing all of the revenue from that work. Finally, we believe that the relicensing process in Kansas, as currently administered, is contributing to a nursing shortage in Kansas and is unfair to the treatment, unfairly treating nurses. And so because of that, we believe that there's fundamental change is needed in the laws, regulations, and policies governing the relicensing of nurses, as well as the administration of those laws, regulations, and policies by the nursing board. And accordingly, the committee has set forth recommendations, which we'll be discussing next, for reform, and that it urges the legislature and the board to consider. And the committee urges the nursing board to take corrective action immediately insofar as it can without legislative action to amend or change regulations, policies, and procedures for administering the relicensing process. As I said, this is a non-binding resolution. It just seeks to sort of summarize what I believe is the sense of the committee, having had 2 days to consider the situation. And so I will move that the committee adopt this resolution.
Is there a second? Second by Representative Berquist, and we'll open up for discussion.
She says she, yeah. In other words, there's things they can do that don't require any legislative action. It violates what?
Which particular, where are we
She's saying.
No, it just says urges.
If can, without legislation.
some offline discussions here. You know that when attorneys can sometimes have to work out the finer details, and so we had a couple of our attorneys here, our vice chair being one of them, and thank you, Jill and Jenna. We appreciate that. So just to be of utmost, caution, I'll go ahead and make a substitute motion, and just for the last few items, it's on accordingly, and it's the two. In the committee suggests the nursing board evaluate and review regulations, policies, and procedures for administering the relicensing process. So that is the.
That's what I meant by my second.
Yes, thank you. I was going to ask you if that's what you meant, so perfect. We are going to open up for discussion. This is, again, a summary of what has occurred these last two meetings, and you have an opportunity to vote an affirmation that you believe that this is a fair assessment of our 2 days, and that would be a yay and an aye and a no if you do not. Any discussion? Representative Sutton.
Thank you, Madam Chair. I just want to clarify that when the committee has set forth recommendations for reform, those include Representative Pickett's recommendations?
No, they do not. That is a separate motion that will come next.
Oh, see, I skipped ahead. Then in that case, what are these set forth recommendations?
The set forth recommendations is actually, we're implying that there are recommendations that we are going to be providing, and we will be, and that will be the next motion.
Gotcha. All right. Thank you very much.
Representative Hoy.
Thank you, Madam Chair. While I am very pleased to hear some recommendations, and I think there always room for process improvement, I do have a couple of issues with the wording in here that are going to lead me to vote no. I won't go through every single one, but just a couple. First, just saying that as a committee, we've reviewed hundreds of pages of documents submitted by the conferees. There are still a number of pages that I have not reviewed that I received today. So all of that written testimony, I've only made it through 2 or 3 of those. So I would like to do my due diligence, and if I say that I'm going to do it. I think that there are frustrations in this process. I think we're already on the road technology-wise to improve some of that. I think saying the board that this has resulted in unfair treatment, I don't know that is an overarching theme. I think for the entirety of nurses in Kansas. I don't believe the board is focused on punishing innocent mistakes more so than they are helping good nurses remain important contributors. We've also, on the unprofessional conduct area, we have seen that that is not what is in those public-facing lookup organizations. It says practicing without a license, and I do think that there would be some ways statutorily too, if we as a legislature don't like that practicing without a license includes or is under that unprofessional conduct, that could just be changed. Then we could do that. I don't know that I believe that for just the practicing without a license that it's harder to obtain malpractice insurance and find employment. On this list that we received today, I recognized a name on there. I know that person is currently employed. So I do think that it could, I don't know. I'm not sure that I've seen enough evidence for that one. And I do believe that there are many, many other contributing factors to the nursing shortage in our state. And I believe the nursing board is already looking at this and doesn't need some I just think that if we want to really reform this, that we sit down, we work together, we don't give testimony on one day that they haven't even seen, and then get frustrated that they can't answer all these questions. And that is why I'm voting no. Thank you.
Representative Sawyer.
Yeah, thank you. Do we have a list of the recommendations? I got the resolution. I've read it. It's fine. But it says the committee has set forth recommendations for reform that it urges the legislature and board to consider. I don't have that.
Yes, you will have that, Representative.
Okay.
I do have, it's a separate motion, so you're not voting. You're voting on the basic overview or summary of what we have done for the 2 days. Understanding that affirmative vote would include that you understand that this committee is voting on recommendations. Those have not been established yet. That is a separate motion. It will follow.
Okay, but it's so you don't have a list yet that I can look at. You're just.
We do have it. It's the second motion.
Can we get that?
We need to
mailed to
dispose.
us?
Well, we will
Okay.
dispose of a motion before we take on a new motion.
Madam Chair.
Representative Francis.
I think maybe Representative Sawyer's not following the fact, wasn't the last 2 sections were taken out, and then there's new substitute language that would absolve his concerns, I think.
We actually didn't remove 1. We updated and amended 2 on it. So 1, the way I read it, the committee has set forth recommendations for reform that it urges the legislature and the board to consider. The words "to consider" are not binding. It's simply, these are suggestions. We're bringing those recommendations second, but we wanted to acknowledge that there will be recommendations with this committee, whether the committee, if the committee so chooses to pass those recommendations.
Yeah, and what does the substitute language say for 2?
The substitute changes the committee, instead of urges, suggests. And then it's reviewing. So it just alters the language a little bit. Representative Berquist, Representative Osmond.
Thank you. In regards to the representative's thoughts about we don't have enough of our information to move forward with this, I'm reminded, and I remember over the last 25 or 30 years, the industries of the world and the toy makers of the world and the food producers of the world. Whenever there's 5 or 10 people that are injured by a toy, or whether there's 5 or 10 or 50 people that are injured by a medicine or a food, they're normally taken off the shelf and they're evaluated to see what's really wrong. Not that they're absolutely destroyed forever, but that they're taken out for a review so that the things can be fixed. And we don't know that everything needs to be fixed, but we've heard enough evidence in this committee that I think that this resolution that we start with here is appropriate. It is not all inclusive, and it certainly isn't all absolutely correct. It's a matter of this issue has finally been pried open enough for a whole committee to recommend to a whole governing body that we take a look at it. And that's why I support this resolution.
Representative Osmond.
Thank you, Madam Chairwoman. Okay, so first of all, just as a point of order, the accordingly I think needs to be modified to be spelled correctly. But beyond that, point number 1, so the committee has set forth recommendations. I think that this has already been addressed, but we don't have those recommendations. So it's difficult to vote on something to say that we're going to be supporting recommendations that we've not yet seen those recommendations of. The second thing that I wanted to point out was on the first page. So this is where I'm at, and I wanted to say to everybody that came forward today and gave your testimony, thank you very much. I appreciate that members of the public, that nurses, that those that are interested made their voice heard, and it's spurring things on to make a difference. I greatly, greatly appreciate that. But that said, I don't know that we have the evidence at this point that the nursing board is punishing innocent mistakes or that they do not adversely affect patient care. It is possible, it might even be likely, but we don't have that evidence. And I don't think, my feeling is this, our job here in this committee is not to adjudicate issues on an individual basis between an individual and the nursing board. I, again, greatly appreciate everybody's testimony, and I think that we're going to use that for really good things as we move forward. But we only have the one side of the story, and I'm not interested in pulling out the full details, because that is not, I do not believe that that is our role in the committee, is to determine on an individual basis what is going on. I believe that our role in the committee is figuring out the larger issue and what we can do to modify that to make it better. And so I do have an issue with making blanket statements that we don't have definitive proof on within this this resolution. Sorry. Thank you.
Representative Vice Chair Lewis.
Yes, just a brief response to Representative Osmond. I think for the most part, the resolution doesn't make definitive determinations of this. It just has, it's a general sense of the committee. The second thing I would say is that I understand from questions from the committee that they feel a little uncomfortable voting on the resolution because of the little I under accordingly, appropriately misspelled, as you point out, because they haven't seen those recommendations. So with the chair's indulgence in the committee, I'm going to pull my motion and suggest that we first consider the recommendations and then come back to the resolution after people have seen and considered the recommendations.
Okay, the motion has been withdrawn, if there are all okay with that. And we'll go ahead and look at the other. And I certainly would have great arguments or discussion points in response to some of the concerns that you expressed. And likewise, others were in the queue to share their opinions as well.
Yes.
But we will circle back. So Representative Ballard, we will put
I will
you
say
on
thank you.
hold. Yeah, we'll put you on hold. And now what we need to do is pass out the recommendations and be sure that those that are online have those recommendations. If you'd like to, we're going to walk through those recommendations. If you'd like, you can also pull out Representative Pickert's recommendations. You will find many of the items included in Representative Pickert's. They will also be found within this recommendation that I'm presenting to you. So I did ask for those that are providing testimony to include any types of solutions that they might be able to recommend, and did so. And Representative Pickert has also looked through this list here. And actually, we'll go through this, and it will be my motion as I go through it to present this to the committee. We will go through the items, but we will be voting on it as a unit. However, we may amend as we go. And in addition to that, I wouldn't get hung up on, well, I prefer 35 days and I would prefer 45, because this is a recommendation. Eventually, there would be work to introduce a bill. And then from a bill, it would go to the speaker and the health committee probably. And then from there, those individuals on the health committee would be the ones to determine what they like, what they don't like, have a hearing, and they would go through this process again. So I wanted to make that note. Let's go ahead and start with the first item. I'm not going to read this, but the first item deals with a grace period. There seems like there's overwhelming support for a grace period, and we have, along with Representative Picker, recommended 3-month grace period. You can look at the details of it. But that is the general idea, is a grace period of 3 months.
Madam Chair.
Yes, Representative Francis.
And I understand we're not supposed to get hung up on the granular detail, but that's the problem when we have granular detail. You know, I think $1,000 for 3 months, once we put our thumb on it, we're saying that that's what we think is right. I mean, that's nothing close to what I think the grace period should be. But I do understand the need for a grace period or some kind of period for which they're not working without a license. So again, yeah, I have a lot of problem with this, the granular detail of this thing that I'm not supposed to be worried about the granular detail on, even though I'm in favor of a grace period without a doubt.
Right. I would just remind you that, that again, this is just a recommendation, and it would be kind of like a conference committee report where even lesser so than that, because we have no binding authority. We are sending this on to those that will be introducing a bill. The bill will then go to the speaker. The speaker will determine who gets the bill. We would assume that it might be the health committee. The health committee will have a hearing, and then anything that is recommended will potentially could be in the bill or not, because the bill of its own animal. And it's also going to the committee, and they could say, no, we don't like this.
Yeah, and I'm saying I don't like this. Much prefer there shall be a grace period given to those whose licenses have lapsed for failure to fulfill all relicensure requirements, and there shall be a fine imposed. But the fact that we're putting in 3 months and $1,000, yeah, I got a problem with that. That's not what I envision at all.
I think $1,000 came from something that exists already, and I'm not exactly sure, but I am certainly open to striking that portion. I do, you know what, we can.
All I want is
Right.
3,000
Madam,
3 month and 1,000. An amount may be imposed, should be imposed. I mean, I agree with all of that.
I'm just going to speak for myself here, and then I'll let the committee members speak for themselves because we are working through this. I think a 3 month we started with 6. We started with a 6-month period, and then we brought it down to 3 month. We know that the dentists have a 6-month. We know the pharmacists have a 6-month. And I think that's reasonable to change statutes in such a way that they have that amount of time. They're not going to, I don't think it'll be used very much, but we saw some individuals that had 38 days, but most of them, it was 3 to 12 days.
Yeah, and I'm not saying I know what the right amount is.
Right. So since it's a recommendation, I would prefer not having an open-ended recommendation. I would prefer having the 3 month. That is the recommendation that Representative Picker worked with other nurses to recommend to us. And so that's why we selected it. So are there other comments on the committee about the?
well, I have a comment
Representative Ballard.
with several. Thank you, Madam Chair. I talked with several people, and no one mentioned 6 months. No one said anything about 3 months. They were talking more like weeks. But have we looked at what other states that have grace periods do they have 3 to 6 months? That seems awfully long for a grace period.
All right. Well, we're going to just. what we're going to do is, committee, we're just going to vote on the 3-month grace period. We're going to just eliminate everything else off of this that's below, and we're going to vote on the 3-month grace period by itself. If you don't want the 3-month grace period, then you'll vote no. So,
Okay.
and then the fines that can be dealt with by the committee, because I don't think we're going to have time to go through every single dot and tittle. So, all those in favor of a
Can you clarify
Yes.
for me real quickly what I'm voting on again?
Yes, and in fact, I will just withdraw my original motion of the entire document. We'll actually back it up, and I'll make a motion that we just approve, or we recommend a 3-month grace period. And we have a second by Representative Tarwater. Right, approve number 1 with a 3-month grace period. Right, any discussion? Okay, all those in favor of 3-month grace period, just raise your right hand. 1, 2, 3, 4, 5, 6, 7, 8, 9. Okay, 9 in favor, and those opposed?
No, on my end.
Okay,
Representative
and,
Sawyer's no.
okay, Representative Hoy. So if we'll keep account of that, and we will combine all these at the end. So for clarity, we have approved item number 1, 9 to 3, and we will eliminate any discussion other than the 3-month grace period. Okay. Item number 2, KSBN shall provide digital notice, text, and email every month for 3 months before license renewal, beginning at 90 days, 60 days, 30 days, and continue within 14, 7 days, and renewal due date. This entire paragraph was provided by Representative Picker and other nurses. There was a suggestion, I think it was Maggie that made the suggestion of or someone did in their testimony, congratulations notification. Again, this is just an overall recommendation, and nothing would require the ultimate rules regs, because we do not do rules and regs. We only do statutes. So we're just making recommendations. Representative White.
Could you repeat those recommendations, please?
Do you have the document in front of you?
No, I don't.
Okay. The document says KSBN shall provide digital notice, text, and email every month for 3 months before license renewal, beginning at 90 days, 60 days, 30 days, and continue with 14 days, 7 days, and renewal due date. Digital notice on the expiration date and 1 week following the expiration date shall be provided for those with a past license, along with instructions for step-by-step to be taken to reinstate the license. It also will send a congratulations notification when you have successfully renewed your license. Again, this is just a recommendation. It is non-binding, but we did want to have a position. Representative Hoy.
Thank you, Madam Chair. And so just to clarify, this is a recommendation from this committee to the legislature to make statutory changes. So do you see this as a statutory change?
No, it says, recommendations to legislature for KSB and statutory. I would change the heading, recommendations to the legislature, and I would just say it like that. And then there would be a separate bill, but these are our recommendations. I don't know if you would put that type of detail in.
Okay, yeah, because I'm like,
in
text,
the
email, that can go.
But I think recommendations are also what we are sharing with the Kansas State Board of Nursing.
Because I do think saying that they, in statute, that they shall give digital notice by text and email for 90 days, 60 days, 30 days, 14 days, and 7 days, that could go out of date. I'm not sure that I think that there needs to be that many, especially if it's in statute.
That's true.
I would definitely support saying that we recommend modernizing the renewal licensing reminders. But I love the, congratulations notification, great. But I think that could be a lot of reminders that end up backfiring. I think like a 30-day and a 7-day or something like that.
Okay, so again, as we're having some little sidebar discussions, I really do like your idea of recommend the modernization, but I do want to say again that these are general recommendations. This is not a bill. This is not necessarily going in statute. There will be a bill introduced. I think if we all sat here for about 5 more hours, it'd be perfect. It really would. I agree that, to your point, you wouldn't want perhaps all of this in there. But by putting this in writing, the state board can also take a look at it and say, okay, we like this portion of it. This makes sense. And that's what, so we're really just trying to provide what are the takeaways and what would we recommend. It doesn't have to mean that Representative Francis likes every single little, item on it. I agree. You've made your point. Everybody's made their point on that. So Representative Humphreys.
Thank you, Madam Chair. I'm wondering if we could add to this section that if someone has not renewed by their date, that they get a notice that says you didn't review.
I believe that may be in here at
Okay.
some place.
Somewhere else, okay.
And so, but again, that is something that if you make a note of that, then
Okay.
when we are looking, or when the health committee is.
I almost think that's as important as being reminded of it. I mean, in my opinion.
Actually, I'm pretty sure it is in here.
Okay.
Because that was recommended by nurses, recommended picker. I
Yes.
believe that is in here.
Okay.
So
And,
let's just combine 2 and 3 together.
okay.
Because that way we pick up everything. This is all IT. Include the following IT updates with report to the legislature. Use automation for license renewals with text email notifications. I think that's closer to Representative Hoy's. If a nurse does not renew following the 3-month grace period, send a text, email, and survey asking why. There we go.
Okay.
Collect the data. C, if credit card was denied during renewal, an immediate prompt shows the card was denied and stops the renewal process. D, allow nurses to save progress on renewal portal. E, provide immediate feedback, which I already mentioned, congratulations message when you have completed it. F, built-in alerts when checkboxes are missed. Do not allow double clicks, things of that nature. So all of that would be one motion, item 2 and 3. And basically, that is not necessarily all-encompassing. We know that there are other, we have Representative Pickards, we have Maggie's, but this is just the things that we noted. So that, I have a motion, I need a second before discussion.
I second it.
Second by Vice Chair, Representative Osman.
Thank you, Madam Chairwoman. With regards to Section 3, so I don't know what the information is that the Kansas Board of Licensure requires for their license renewals. But they want, or they've said that they want everybody to get on this system where they have electronic notifications. So we should mandate in here, or highly suggest that in the licensure renewal, they put their email address, a good email address in, they put a good contact phone number in, and they mandate that is an opt-out clause so that they automatically go on the list once that happens, unless they specifically opt out of that list.
Thank you, Representative Osmond. Actually, that is an item that the board has already expressed that they are working toward. There was a letter that was provided, and I do appreciate the letter. They are moving toward that direction. They have actually 3/4 of their nurses that already do receive digital notice. There's just a quarter left. But what we want to, where relevant, is back up good regulations with good statutes. So, but thank you for that. So let's see. We have a second. Any further discussion? All those in favor of item 2 and 3, say aye.
Aye.
Any opposed?
Aye.
Any opposed? Okay, motion carries. We have those items. Now we're on to number 4. This is a piece of the statute, and we're probably getting into the weeds, so this one's not even particularly necessary. It's something that could include in the bill. So, but it's here, so I'll go ahead and leave it. Basically, it just says in statute what, it's adding the words include grace period for practice of professional nursing. It's just literally adding that additional language in it. Or extension due to extenuating circumstances.
Yes.
Was that a second?
Yes.
Okay. Okay, that was a motion and a second. And again, this is not, I'm gonna actually ask Vice Chair here out loud. This is more of, as I'm looking at it in this discussion, more of a item that we could place in the bill. Should we strike it entirely or leave it?
I'm not sure.
Item number 4.
Yeah, I'm not sure I understand the question.
I just included
Right. But that would be the amendment to the statute.
Right, but we could do that separately. Do we even use this in here today? Should we just take it out?
We can skip that, yeah.
Okay, we're going to just go ahead and strike item number 4 entirely from the recommendations, because when you read that, it's out of context, and so it's difficult to follow. But that is something that we could include in a bill and that could be amended later. So we're just going to strike that one. Is that okay with you, Representative Ballard, since you seconded the motion?
Yes, it
All
is.
right, good. All right, next item is amend the makeup of Kansas State Board of Nursing. Include legislative appointments. Currently, there are, that should say 11 members appointed by the governor. We recommend that, and so actually, I would, yeah, that the number adds up to 9. It should add up to 11. So we recommend 5 members, 7 members be selected by the legislature, and 4 members, actually, that should be 6 and 4. All right, actually, committee, we're going to, since I put the wrong number in there, it's 11. We're just going to strike how that makeup will look. That can be placed in a bill. So the only item we will have in here is amend the makeup of the KSBN, include legislative appointments, period. Everything else goes.
Second.
All right, motion and a second. Any further discussion? Representative Hoy.
Thank you, Madam Chair. I am open to this. I am just very curious, like, what problem we're trying to solve with this. What did we hear that led us to believe that the makeup of the board, the current appointment process, is an issue?
I think that that would be a person-to-person opinion, deciding on whether or not or why. But we have heard of many concerns from or related to the board. And I think in general, I'm not sure why we ever created boards that were entirely appointed by the executive, the governor. I think it's very good practice to have a balance in our boards. We have changed our boards recently. We just started a new board for child advocacy, or actually that was childcare, and we included both legislative and governor appointments. The Children's Cabinet, we just amended that. It includes both legislative appointments and the governor's appointments. And so we're trying to be more consistent and having our boards represent both the legislative body as well as the governor. But in terms of the makeup, I struck all references to the makeup and simply made note that we would include legislative appointments. And then that could be up to debate during the legislative session.
Well, I did appreciate that the minority leader of the House and Senate were included in there, so I was more inclined to support it with those in the motion.
We can include, we recommend, we could just take out the numbers. We could include all of it. Currently, there are 11 members appointed by the governor. We recommend members be selected by the legislature and by the governor to include a makeup from the Speaker, Senate President, Minority Leader, or you can just trust that that's going to be in a bill and you can debate it later.
No, what you put in there, I think sounded good. I'll support it then. Thank you.
Confusing.
My concern right now is that I'm marking out things and that people may not be sure what they're voting on. So that's why I was just going to eliminate the language and then let that be hashed out in the legislature. Okay, so we're going to stick with that because that was the second on the motion, but that would be something that you could advocate for. And if we were putting forth a bill, we would likely include that. That was the intent. Any further discussion? Yes, Representative.
Very, very briefly, just to say that because this is a nonpartisan portion of this recommendation, the balance of power changes from time to time. And so it's not a matter of giving one party more, but giving position more rather than party.
All right, thank you for that. Representative Vice Chair.
Thank you, Madam Chair. Well, one concern I have generally about the way our state government is run is that administrative agencies are too often unmoored from popular sanction, and that's because oftentimes the governor appoints and the agencies and their heads are not subject to election. By adding legislative appointments to the board, we're bringing the board closer to the populace, the voters, and they have a little more control over what's going on in the legislative, in the administrative agency. So as a general proposition, I prefer that these boards do have legislative appointments as well as executive.
Appreciate that. All those in favor, say aye.
Aye.
And those opposed? Okay, 2 opposed. All right, 2 opposed. That item passes. All right, the next item is, and again, these are excellent discussion points for further use. Item number 6, ensuring those who face disciplinary action are provided notice of a fair and impartial hearing through an appeals process under the Administrative Procedures Act and court review. It also says every nurse shall be afforded the opportunity for prompt mediation before moving to litigation. At the bottom of the paragraph, it says that if the nurse prevails in a final adjudication of her dispute, she is entitled to costs and 50% of reasonable attorney fees. A, set reasonable discovery and timelines. We did hear repeatedly that timeline was an issue. And B, this item came from Maggie's testimony, include continuity of care safeguards. This would have been especially helpful to Michael and his son if there had been bridging plans available to provide for his son during the time that Anna was not licensed. This is the motion. Do I have a second?
I'll second it.
There is a second. Discussion? Representative Humphries.
Yes, and I'm going to take this opportunity because of what is in here to also just say I had to walk out at the worst moment with your number 1 because my question about this number 6 is my same question that I would have had about number 1 is, okay, if we're doing continuity of care, continue to practice, during this period, are they licensed? And my question is, when I was gone, I hated it, I was gone. Did y'all talk about a lapse grace period? Are they licensed during that period, but at the end of that period, that's when they lose their license. I think it's because these things that we got, like this one today, this did not discuss a grace period. This is about lapsing. But my question is, during a period, okay, so
Yes. So that would be added to a bill that the Vice Chair and myself will introduce, but absolutely a grace period, you are fully licensed.
yes, okay. I think that is really important that we make that clear.
Yes, I agree.
Thank you.
If there's no further discussion, all those in favor of item number 6, say aye.
Aye.
Any opposed? Motion, 1 opposed. Okay.
don't know why he would
One in
think
opposition. Motion passes. Okay, number 7, actually, this was a recommendation from the Speaker. The House Health Chair may establish, doesn't require, may establish a subcommittee to review KSBN actions and make further recommendations for statutory amendments and oversight. So we may not have adequate time to address all of the issues. We may not even know what all of the issues are. There may be some issues that are remedied through regulation changes, and there may be some that are remedied through statutory changes, and then there may be a period where we're not sure exactly what needs to be done. So that is why this was recommended. So all those in favor, or actually, is there a second?
I'll second that.
Second by Vice Chair. All those in favor of item 7, say aye.
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 Any opposed? Motion carries. The next one, 8, is annual reports. As you know, with the annual reports, those were going as hard copies just to our chairs, and many of us did not see those. So basically, we would just update this requirement for the annual reports and make it very similar to other annual reports that go to KLRD.
I move.
There is a
second
second. Any discussion? All those in favor of item number 8, say aye.
I have a question.
Aye.
I just have-
Yes.
Is this for all, because it just says annual reports, is it for all annual reports?
It is, no, it is just for the Kansas State Board of Nursing.
Oh, I would love for it to be all annual reports, but thank.
Yeah, and actually it is, and we will update this in the bill, but actually there is a statute that actually has them, and it's not just the annual report, so I'm glad you.
Madam Chair?
You
can
stopped me.
Oh, I can help you with the.
Yes.
it's Statute KSA 651120A, and that's the one that made a report on and after, every year after 2018, that goes over the reinstatement of revoked licenses.
So I would like to amend this motion and include the annual report plus the statute reference. Can you reference that one more time again?
It is KSA 651120A.
So those are the required reporting that has performance measures on it. And so those are the ones that we did not see except for maybe 2018 and 2019. And so we have, you're good with that?
Yeah.
Substitute. Any further discussion? All those in favor, say aye.
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 Any opposed? Motion carries. Okay, let's look at this for a minute. Maybe we can combine some of these. Number 9 and 10. I think 9. I think Representative Ballard's getting tired here. Now, Representative Ballard, I know you're in California, so it's not even as late as it is here. So,
Yeah, no, it's not. But remember, I'm supposed to be at a conference too, so I'm taking a whole lot of
okay.
time.
Oh, we apologize. I'm sorry. I didn't think this would take this long, so my bad. Okay, item number 9 and number 10, we're going to combine together as one motion. It's requiring a consent agreements to include certain required disclosures. What we want is rather than just stating in the consent agreement that they will abide by reporting that's federal and state, we want specifically those people that sign that consent agreement to understand what databases they will be listed on. So that's a recommendation in item number 10. We want consent agreements may be offered when evidence of clinical misconduct has been proven or willful misconduct has been proven. And then also create ratings of misconduct, which disallow clerical human error to be included. Consider human error versus reckless behavior versus malicious. For less serious infractions, reporting shall be removed from databases in accordance with federal law. Prioritize continuity of care. So basically, these two statements are just cleaning up requirements relating to consent agreements. Is there anything in item 9 or 10 that is of concern?
I second it.
There is a second. Representative Hoy.
Thank you, Madam Chair. I just have a question. I'm not sure I understand what this means. Create ratings of misconduct which disallows clerical human error to be included. Is that what I was talking about earlier? Or were we saying unprofessional conduct is a separate thing from?
Double click.
Right. So right now, unprofessional conduct is listed in statute. There's a whole list of items that can be included. Some of those items that are listed have nothing to do with clinical practice. And some of them, as we heard, relate to being 3 days late, or you didn't you didn't pay on time, or you didn't click the button, or you had other errors. So it's basically, if you approve of this, then you approve of the notion that if you have sexual misconduct with a patient, or you take a patient's medicine, or you sell patients medicine, that should not be in the same category as somebody that let their license lapse for 3 days, or someone that didn't push the button correctly. There's a difference between professional or clinical misconduct and basically just creating some type of rating of that. We didn't say what that is. We just recommended that.
Okay, but that one is in statute.
There is a statute that actually has unprofessional conduct and lists all kinds of things.
It's a regulation.
That one's regulation.
It's a
Okay.
regulation.
Nursing, it's a regulation.
Okay, it's a regulation, not a statute.
Okay, thank you.
But what we would do is probably, in a bill, some of these items need to be a little firmer so that regulations can follow or mirror what is in statute. So I don't want to pretend that all of these are only recommendations to the legislature to recommend to KS, the Kansas State Board of Nursing. Some of them do need to be in statute. So, Representative Osmond.
Thank you, Madam Chairwoman. I have two questions on the first sentence of Part 10. Consent agreements may be offered, et cetera, et cetera. Does that imply the reverse, that consent agreements may not be offered unless evidence of clinical misconduct has been proven? So in other words, the only way that consent agreements can be offered are in these two instances?
Yeah, I would think that you're reading that correctly.
Okay.
Because I don't think that we want our nurses in Kansas to receive a consent agreement or to be compelled to sign a consent agreement for, if we have a grace period, this is not going to be an issue anymore. But for a clerical error, for an error with the website. So we do want it to be for clinical misconduct. We want it to be around the realm of safety.
Okay. The second question that I have is on that as well. So correct me if I'm wrong, but isn't consent agreement in place of some sort of a hearing or trial or adjudication? In other words, nothing has been proven. It's just an agreement because you bypassed the proving stage of it.
It can be, but it can also be with a final order. And I'll let my vice chair respond to that, but in some cases, there was a final order, there was a consent agreement. In some cases, there was a consent agreement right out of the gate, and there was no hearing that followed.
Okay.
We'll ask our vice chair if that's how he understood it, or I may be wrong, I'm not an attorney.
Right. I appreciate your pointing out there is some ambiguity here, but the way I understand it is it's when it says evidence of clinical misconduct has been proven. The consent agreement itself obviously is, or not obviously, but in fact includes an admission of misconduct. And I think the point here is we want to ensure that the board has sufficient evidence of that misconduct before compelling somebody through the process which we've found to be lacking to consent to something that they haven't done, which seems to happen from time to time. But I admit that there's ambiguity in the way this is drafted.
So thank you very much. Let me try to rephrase this and see if this is what we're going for, and just so that I understand. Consent agreements may be offered only in cases of clinical misconduct or willful misconduct. Is that what you're trying to accomplish here?
Thank you. I think
That's correct. And with the committee's allowance, we can, if you give us room, we can clean up the language on some of these, provide back to the committee for a final look. But we could make this a little bit more concise. So that would be my offering.
I mean, I think we could probably take your language and put it in right now.
Okay, say that again.
Thank you. I was just looking for clarification. So if I'm understanding the language, it appears as if it's trying to read as in consent agreements may only be offered in issues of clinical misconduct or willful misconduct. That appears to be how it's phrased and how I'm interpreting it. Does that seem correct to everybody?
That is, and we could simply, consent agreements may only be offered when evidence of clinical misconduct has been proven or willful misconduct has been proven for any reason relevant to the profession of nursing.
I think you take out has been proven, just where there is clinical misconduct or willful misconduct relevant to the profession of nursing.
Okay, we'll put a period there.
So as I understand it, it reads consent agreements may only be offered where there is clinical misconduct or willful misconduct relevant to the profession of nursing. Is that it, Representative Osman?
Again, yeah. Thank you. Those are my words. I'm still trying to parse whether this is a good idea or not. I'm just trying to clarify that this is what you're intending.
And on this item, on item 9 and 10, if you vote the affirmative, the motion, the friendly motion is that we will clean up the language, but you're agreeing that in basic substance, these recommendations are worthy of review. It does not mean that they're worthy of adoption, but they are worthy of review. So we have a motion and a second, I believe, by the vice chair. Do we have any further discussion? Representative Waymaster.
I just have one comment, and it looks like this is the only placing in here where there's any mentioning of any type of document. And then one thing that I think we had a concern of, and I was kind of thinking back to the first job I had, and we had a saying that was one done right, and I kept hearing that this afternoon or this morning, and if there's some way to express that these are only for case by case, like one case, the case closed, and we cannot repeatedly leave it open, which was, I think, in the correspondence that they received, some of the nurses received, saying that this can be opened up at any time. This should only be for one pertinent item, and if there's another one, then it has to be another consent order, but you can't perpetually leave something open as far as an investigation.
Okay, and that would be on Sandy, Representative Pickett's. She has an item 8 and 9. When a nurse is investigated, okay, wait a minute. Number 9, remove the option of reopening cases without cause for those who have not signed consent agreements. And the statute of limitations for opening a case against a license is 2 years. Is that what you're referring to?
Yes, yeah.
Okay. So we could include those, and we'll add an additional item for that at the end.
Thank you.
So actually, we'll insert it here, 9 and 10 from Representative Pickett's. 9 and 10. 9 and 10, again, we ask for you to allow us to wordsmith it and maybe group things a little bit differently so that it flows easily, so that when it goes to the next person, it is not confusing as it is in this very moment. So I do apologize for that. So we have items 9 and 10, and also 9 and 10 from Representative Pickett's testimony. And that was my friendly motion.
Okay, I second that.
Okay. Any further discussion? All those in favor say, Representative.
Sorry, at the risk of opening Pandora's box, and I'm not going to make a motion or want to change anything, but I would like to see whoever runs with this bill, I'd like to see this be retroactive to the current people that are having all these problems, because there are a lot of people on this list that shouldn't be. Thanks.
Yes, we will do so. All right, and by the way, we will make sure you have this list today as well in your email box. All those in favor, say aye. Aye. Those opposed? Nay? Okay, all in favor, so those items are good. Item number 11, practice without a license shall not include instruction, public speaking, writing, or counseling when no money is exchanged and/or the nurse disclosures that she is not currently licensed. This was an issue. That is the motion. Is there a second?
I second the motion.
Second motion. Discussion. Representative Hoy.
Thank you, Madam Chair. I have really big concerns saying that regardless whether or not money is exchanged, that people could represent themselves as a nurse and go into a classroom, speak at a public event or on maybe a podcast, writing into journals, things like that, offering counseling to somebody. I just think that that is something, those are items that if you're going to present yourself as a nurse, even if you're going to eventually give a disclaimer that you're unlicensed, I just think that this could have some very far-reaching and potentially unintended consequences. I just am thinking kind of worst-case scenario, like, hey, let's have these kids come to my free sex ed talk. I mean, there's a big responsibility of presenting yourself as a nurse and offering advice to others. And to me, that does require a nursing license.
Okay, thank you. And there are some free speech issues, but you make a valid point. Representative Humphries?
Thank you, Madam Chair. I'm wondering if it might leave some of the concerns, but what the committee would think about adding something in here about if this is a gathering or a public something that you don't have to be a nurse to speak at. Like if the general population could be one of the speakers at this convention or at this whatever it is, then, because that's some of the issue too. If only nurses can be speakers at something, then that's one thing. But if they're licensed right now, if they're in that grace period or whatever, and they're speaking, writing, whatever, and if it's at something that you don't have to be a licensed nurse to do that, then it seems perfectly fine for them to do it, and they shouldn't be held to a different standard.
Sure, and I actually do agree with you, but to expedite the process, I will withdraw this motion, and I put a note to myself, review with the vice chair because I think maybe we can look at the statutes that relate to this and see if there's a better way to do it, and then we'll just eliminate it for today. So that item is off the table. I think number 12 is a pretty easy one, review KNAP program, possible legislative review through LPA and/or through joint committee to evaluate appeals and KSBN progress. Any issues with that? Is that a motion? That's a motion. This is a second. Second by Representative Bergquist. Discussion? All those in favor say aye.
Aye.
Aye. Those opposed? Motion carries. The next item, consider pathway for restitution to the nurse through claims against the state. Okay, now this second part here, we're going to eliminate. So I think so we do not get into the weeds. I want you to just cross out the next sentence. But considering a pathway for claims against the state, we're actually going to, after we dispose of this motion, go back to the original motion, there will be a quick conversation about claims against the state with the chair. So we will have an opportunity, but this is just saying consider the pathway. Anybody?
I second the motion.
Second is for the motion. Any discussion? Representative Hoy.
So eliminating that statement does potentially mean the taxpayers are going to have to
likely not, because there is a fee fund of almost $5 million. So, but that would be something that would be a discussion point probably during the session, and also Representative Humphries can come back and circle around to that thought as well. Okay, all those in favor say aye.
Aye.
Any opposed? Okay, motion carries. Next item, item 14, require nursing board to allow individuals who believe they have been unfairly identified as engaged in professional misconduct or unprofessional conduct. I go back and forth on that. Without clinical violations, to request this identification be revoked and a public record of such misconduct expunged. Give nurses a window of 1 year to request this retroactive relief, require notification on website and a newsletter of this opportunity for retroactive relief. If you turn the page, if a modification is approved based on criteria set by the legislature, KSBN shall make requests to all federal databases for the removal of individuals published. And that is, once you are on a database with the federal, then it cannot be removed without the State Board of Nursing making that request. And then item B is requested by nurses. For state database, no home addresses shall be reported if there is a state database. It is not required by statute, I do not believe, but there is one that exists right now.
I second the motion.
There's been a motion and a second. Discussion. Representative Hoy.
Is this only if it's outside of the 3-month, like the new law? Like if we're going to go back and kind of retroactively remove this, is it's only outside of the new law that potentially could be made? Like for now, we're recommending, the recommendation is a 3-month grace period. So that only apply if they're currently in line with what the new potentially law could be.
I think you're correct. I think it applies right now as our general recommendations. If there is a bill that is introduced and that is passed by the legislature and signed into law, then it will have its own criteria that may be different than this. And then this would go away. This is just a recommendation from us today. Vice Chair.
I'm not sure if I understand the question, but my understanding of the intent here is that any of the nurses that we've heard from would, if this kind of legislation got passed, would have an opportunity for 1 year after the statute was passed to go back and ask for retroactive relief. Yeah.
All right, all those in favor, say aye.
Aye.
Those in opposition? No, the motion carries. We're doing great, everyone. Item number 15, review the use of diversion agreements. Is there a second?
I second that.
All discussion? All those in favor, say aye.
Aye.
Those opposed?
Aye.
Motion carries. Thank you, Barbara. Item number 16. All right, so this was actually recommended by nurses as well as Maggie. It was on her testimony. It says you use recognized professional frameworks such as the NCBSBN decision-making framework and just culture principles to help the board match responses to actual patient safety risk while promoting learning. And it includes items that Representative Pickard also suggested, and that is A, include nurses to investigate nurses, B, separate roles to preserve trust, C, allow alternative methods to review such as safe harbor, which was another item that was shared in testimony, which includes peer review of work assignments. So that is an item directly off of Representative Pickard's. That's item 16. That's the motion.
I would have one question.
Yes.
Could it be and others? Because if you only limit it to that, it can only be for them. There might be something else someone thinks of that they need. I mean, can you leave it more open?
Where are you adding that?
Well, you were adding the organizations or whatever you want to look at. Then you mentioned Representative Pickard's, but is it just going to be inclusive? Just those groups can be involved, or you want to leave it more open?
No. These are recommendations. So, for example, the legislature or the State Board of Nursing might use something entirely different. But
okay, that's fine.
But by listing this, we're giving examples. So it doesn't prevent them from going in a different direction, but it does give them something to look at, and they can respond back to it as well. They can say, we selected another example, or again, just a recommendation.
I just wanted to make sure they have the option.
Yes, these recommendations are non-binding.
Okay.
So we have a
I second that.
We have a second. So any further discussion? Representative Hoy?
Madam Chair, just back to the previous question. I'm Googling the just culture, trying to catch up with all of the details of it. Is this something that is publicly available, or these are things like we have to get a consultant to do? I just want to know like the full, what that means.
I believe it's publicly available. However, it is included in Maggie's recommendations for adoption, and it sounded like a positive thing, and I do think it would need to be explored and to determine if it's of value. And so I think that ultimately the State Board of Nursing would need to review it. And so it doesn't say that, it says use recognized professional frameworks such as, and it gives 2 example, principles to help. Or we could add, I think they're just recommendations. I don't think we need to get hung up on them. Representative Waymaster.
And I think there is a process already in place in North Carolina that we could refer to.
Okay, and we could, or other states, we could, yes. So with your permission, we will clean up this item as well and maybe make mention of other states. All those in favor, say aye.
Aye.
Any opposed? Okay, motion passes. Item 17, create anonymous survey opportunity as well as allowances for suggestions, complaints, and requests, track complaints. This is something that we have asked the board to do. I think that they have said that they would do that. By type, we want to know, are there website issues, are there professional complaints, clinical, ethical, administrative, et cetera, and add these to the performance measures. Actually, in regard to the complaints, there may be something entirely different that the legislature does that is separate from the board, and it may, so, but we're not addressing that right now. We're just encouraging the tracking of those complaints and allowing people to make those complaints.
I second the motion.
There's a second discussion. All those in favor for item 17, say aye.
Aye.
Any opposed? Motion carries. 18, KSBN must honor CORA and COMA. So actually, if you look at their annual report on page 8, I'm just giving this to you so you can look back at page 8 of their annual report. If you do not have that, if we could get that sent to everyone, their annual report, it does give some information that would be, I think, very informative to us. And we won't go into it right now because we're going very, very late. Do I have a second?
I second it.
Second has been made by Vice Chair. Any discussion? All those in favor of 8? Yes, Representative Hoy.
Yeah, I think, I mean, I believe this is already the case, but then there are certain exceptions for things that I would think a lot of nurses, especially if they're going through certain issues and complaints, investigations, whatever, would not want some of that material to be open record.
CORA protects that already.
Yeah.
So basically, it's.
This is just saying
it's
we're doing what we're already doing.
Right.
Okay.
It's reinforcing the importance of CORA and COMA. The state board says that they do. We've had some testimony that say that they do not. We're just reinforcing that it is very important. And CORA and COMA does not violate individual protective rights. So you would not be voting in favor of providing anything that wouldn't normally be provided to the public. All those in favor say aye.
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 Any opposed? Motion carries. Item number 19 is review performance measures and appropriately update to better align with the recommendations. For example, the performance measures, it had lapsed licensees and the reasons, and sometimes that was inconsistent with what we were reviewing here today. Types of complaints. Consent agreements are not on it, so we would just like them to consider looking at those performance measures. Is there a second? There is a second by Representative Berquist. Discussion? All those in,
My discussion.
yes.
My discussion is, can we look at that as being an item that covers helping to get due process for investigation time and disposition of accusations that are made that won't protract over months and years?
Yes, actually, duly noted that how much time does it take for hearings to go through the process or consent agreements to go through the process? Those items could be added, and I would ask that when you're in the Health Committee that you further review what would be some good items you would like measured.
All right.
Okay. All those in favor of item number 19, say aye.
Aye.
Any
Aye.
opposed? Motion carries. Okay, item number 20, I'm adding this on. We would like the board to review the cases that were provided in testimony today and provide back a response as well as a review of each of those encounters that we heard about. That is, again, we cannot compel the board to do this, but we would like to have a response back. And we do not have to vote on that, but I would if that is a general consensus, then that is something we will request. The last item that we can add is to recommend that the Health Committee review Representative Pickard's list so that there may be additional items, but we do not need to vote on those today.
I second the motion.
Okay, so the last item, number 20, is review Representative Pickard's list. And there's a second discussion. All those in favor, say aye.
Aye.
Any opposed? Motion carries. Okay, again, this, now we need to have one solid motion that brings them all together. I make a motion that all of the items that we have just approved be put together into one document that would be a recommendation from this committee that will go to the speaker as well to the Health Committee. And we do ask that you give us some leniency to tighten up language, clean up language, and make any corrections and restructure so it is clear. And we will present that back to you. You do not have to respond to it unless that we've done something wrong. So that is my motion. Is there a second?
A second.
There is a second. Discussion about that motion. Representative Humphries.
Yep. Great, I'm in favor of it. But there was one thing, I don't know if it was included in here, but it could have been. It was about the training for the investigators.
Yes.
It
was
was in
not
there,
included.
or was not included.
I do not, but we could insert it.
Okay,
So there is a portion that talks about practices, the framework portion. And that is number 16.
yep.
So why don't we just, if it would be considered a friendly amendment by this committee, we could just add something about training. Would that be, okay? No objection, if there's no objections, we'll
Okay,
include
thank
that in
you.
there.
Thank you, Madam Chair.
And
Okay,
if
we
staff, you
made
guys
that.
will help us make sure we don't miss that. So we do have a motion and a second. We have had a discussion. All those in favor of combining all into one recommendation? Yes, Representative Hoyt.
Thank you, Madam Chair. Is that including this, just the one recommendations to legislature or also the resolution? This is,
We have not, we're going back to the resolution.
okay,
And I think
so that's
we'll-
not all,
No.
it's only this one document you're talking about?
Yep, yep, just the recommendations. So all those in favor, say aye.
Aye.
Any opposed? All right, it was motion carries unanimously. I believe it's unanimously. Now we're going to go back to the withdrawn resolution and, okay, 14 minutes. All right, let's go. Representative Lewis.
Yes, thank you, Chair. So I move adoption of the resolution with the following amendments to the text which you received. It has to do with correcting the spelling of accordingly. And thank you, Representative Osman. And with respect to the last little I, double I paragraph, it now reads, the committee suggests that the nursing board to evaluate and review regulations, policies, and procedures for administering the relicensing process. That's the motion.
There's a second by Representative Tarwater, and now we are open for discussion. Boy.
Thank you, Madam Chair. Okay, I think I'm confused because I thought that the previous motion was just to put this, give the permission to put this together and wordsmith it. But then don't we need to vote on the resolution? Like
That's what we're doing right now.
Or I'm sorry, the recommendation. Like I'm fine.
We did.
Letting you wordsmith it, but I want to vote no on it as
My
a whole.
intent was that we did vote for the recommendation. Am I correct?
Okay, thank you. I misunderstood that.
Now
Yeah.
I'm not sure anymore. So, okay, yes, we did. Okay, so we are now on the resolution, and if you agree with the resolution statements, then vote affirmatively. If you do not agree, then vote against it. But we are open for discussion. Is there any further discussion? Representative Ballard or Representative Sawyer, both of you had originally had your hand up for this item, but they perhaps it's resolved.
Yeah, it's been resolved. I'm fine now with, I understand what I was at.
Okay.
I'm
Okay,
not sure. I have a little bit of hesitation on it, but I'm okay.
Okay, if there are no further discussion items for the resolution, all those in favor of the resolution, say aye.
Aye.
And those opposed, say no. No. Okay, the resolution passes. Would you like to be recorded?
Yes, thank you, Madam Chair.
We would record one in opposition, and Representative Hoy would like to be recorded. He doesn't need to record it. Okay, the final item, and I appreciate all your time when we are over, and this one will not take long, but I do want to take a moment to talk about the claims against the state, and I want to give the chair of the claims just a brief moment to discuss that, because that is something that we are considering for our nurses.
Okay, so just, well, I will say I'm the vice chair this year, but I've been the chair before. We kind of alternate Senate and House back and forth. It is a committee of last resort if someone feels like they have been wronged financially by the state and they've gone through all of the channels that they can go through, then they can make a claim to the state. So it's called special claims against the state. It goes to the Research Department, KLRD, and they determine if it is a valid claim. And if it is, then it comes before the committee, which meets 4 times per year. And the claims have to be submitted by November the 1st, I believe, to be considered in that calendar year. It's a form you fill out, and it's actually very much has a lot to do with the research department if they come to the committee or not. And the committee can pay the claim. They can reject the claim, and they can recommend who pays it. So we can say, we recommend that this claim be paid, and it comes out of the Department of Corrections or so on. So, and then once we're finished with those 4 meetings at the end of the year, there's a bill during the next session that takes care of those claims against the state. And sometimes it's the state that pays it. We've had different things. And the claims range from $5 to $2 million. We hear all kinds of things. And so that's how it works. There's usually no limits that we impose on the committee, what people do. But the committee has a hearing, and we hear from both sides and then make a determination if the claim should be paid or not.
Representative Humphreys, when is the next hearing? And is there an opportunity for anybody that may have provided testimony to submit an application, and where would they find this application?
If you were to Google special claims against the state, Kansas, the form will come up. I just did it earlier today to make sure that that's what happened, and that's what it is. We don't have a meeting in September. Our next meeting is October 28th. And You can make the claim, you could make the claim right away, and it might be able to be included in the October meeting, and then we'll also have one in December.
Okay, so I would encourage the nurses that feel that they may be unfairly ruled upon, and we have had nurses that have talked about thousands of dollars that they have spent trying to rectify situations. If they would like to pull up the form and submit it, I would encourage them to do that sooner rather than later, since October 28th is coming up. Committee, you've done an excellent job. You've been extremely patient. I applaud our witnesses. I appreciate the Kansas State Board of Nursing for working through all of this, and I look forward to us finding better solutions for Kansas moving forward. Any final comments? Representative
More,
Berquist?
the staff and the chair of this committee have done an excellent job. It's just, it's really refreshing to get through a process together and with very little backbiting.
Well, thank you. This ending was not quite what I'm used to, so I'll take the blame for that one. But staff, huge applause for you guys, and we'll be talking to you very soon about getting these documents in tip-top form. All right, with that, we are adjourned.
Madam Chair, good job.
Yep.
Good job, Madam Chair.